going so far as to suggest it should lose its federal broadcast license. They've discussed issuing subpoenas for news organizations, prosecuting journalists and their sources, and
He's a coach.
He was a real successful high school coach, but he made all his money in running his camp. I think it's 3,500 kids at camp, or a summer at his camp,
Where's
all
that?
over the country, right up the road from us.
Really?
Yeah. And more importantly, he's made a ton of money in this. He's getting ready to sell it. This wrestling apparel, wrestling shoes, kind of nice. He's got these venture capital guys coming in and buy it now.
Wow.
He's a hillbilly up the road. We can get started. Committee will come to order without objection. The chair is authorized to declare recess at any time pursuant to Committee Rule 2, House Rule 11, Clause 2. The chairman may postpone further proceedings today on a question of approving any measure or matter or adopting an amendment for which a recorded vote is ordered. I now recognize the gentleman from Alabama to lead us in the Pledge of Allegiance.
Allegiance to the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all.
Pursuant to notice, I call up H.R. 60, the Knife Owners Protection Act of 2025 for purpose of markup, and move that the committee report it favorably to the House. The clerk will report the bill.
H.R. 60.
Without objection, the bill will be considered as read and open for amendment at any point. The chair now recognizes the gentleman from Arizona, Mr. Biggs, for an opening statement.
Thank you, Mr. Chairman. The bill currently before us, H.R. 60, the Knife Owners Protection Act of 2025, or COPA, is a common-sense solution to a real-world problem. Knife laws vary widely from state to state. For example, some states place restrictions on the type of knife and length of the blade that may be lawfully possessed. Some states also prohibit the concealment of a knife and at what age an individual may carry a knife. Other states have restrictions on carrying knives on school grounds. 24 states do not place any restrictions on the type of knife, its length and opening mechanisms, or whether the knife is evidently visible or hidden. Traveling across state lines with a knife can easily result in serious criminal penalties, as what is legal in one state may be restricted or illegal in a neighboring state. COPA establishes certainty for knife owners by protecting the right of law-abiding citizens to transport knives between states. COPA allows non-prohibited individuals to transport a knife across state lines in a vehicle or airplane if the knife is not accessible to the passenger compartment, or locked in a compartment box. COPA provides exceptions for an emergency knife to be carried interstate without being locked in a compartment box unless an individual is being subjected to security screening through TSA. Under COPA, if possession of a knife is legal in the states where the trip starts and ends, and the knife is secured in accordance with the requirements outlined in the legislation, knife owners would not be subject to a state's criminal penalties while traveling from one state to another. COPA also establishes a strong right of action to allow individuals to seek damages from jurisdictions that violate COPA. I hope we all remember that the Second Amendment guarantees Americans the right to keep and bear arms to protect themselves, their families, their businesses, and Congress must ensure that those rights are protected. The Second Amendment protects an individual's right to not only purchase and possess firearms, but also knives. Like the Firearm Owners Protection Act that became law almost 50 years ago, the Knife Owners Protection Act will ensure that knife owners may travel from one state to another with a knife so long as it is transported in a safe manner and lawful to possess in the original jurisdiction and the jurisdiction that is the terminus, without fear of undue prosecution. I urge my colleagues to support H.R. 60. And Mr. Chairman, thank you, and I yield back.
The gentleman yields back. The chair recognizes the ranking member for an opening statement.
Mr. Chairman, thank you very much. Framed as protection for lawful knife owners, H.R. 60, the Knife Owners Protection Act, is a confusing and unnecessarily broad bill that ends up threatening public safety and actually tying the hands of law enforcement. While we all support reasonable rights for responsible knife owners, this bill goes far beyond what's reasonable and what's responsible. Currently, a variety of federal, state, and local laws govern the sale, possession, manufacture, and transport of knives. Because these laws vary by jurisdiction, knife owners may indeed find it difficult to follow all of them as they travel across state lines. And while H.R. 60 is meant to address these circumstances, just like the Firearm Owners Protection Act of 1986 did for firearm owners, this bill goes way beyond allowing knife owners to travel safely between the states. H.R. 60 veers far from its model by allowing knife owners to transport knives within the passenger compartment of their vehicle, in a console or locked glove compartment if the vehicle does not have a separate compartment. Under this bill, an interstate traveler could have a knife inside of their car at arm's length or right next to them and easily retrievable with the turn of a key, increasing the risk that the knife might be easily and quickly accessed and used to commit violence. Compare that to the Firearm Owners Protection Act, which strictly prohibits transporting firearms in this manner, providing that neither a firearm nor ammunition should be readily accessible or reachable from the passenger compartment of a moving vehicle. That legislation was passed in a bipartisan manner to allow responsible gun owners to safely and lawfully transport their firearms. And unlike the Firearm Owners Protection Act, this bill preempts not only state law, but federal law too. Here's how it does that. The bill establishes the right to lawfully transport knives between states to, quote, any individual who is not otherwise prohibited by federal law from possessing, transporting, shipping, or receiving a knife or knives. But the preceding clause, the preemption clause, includes this phrase, quote, notwithstanding any provision of any law or any rule or regulation of the United States. That phrase is not included in the Firearm Owners Protection Act. So when you read them together, these clauses create a conflict in application that will be left for law enforcement officers, prosecutors, and ultimately judges to try to sort out and reconcile. Federal laws such as the Federal Switchblade Act and the Ballistic Knife Prohibition Act prohibit the possession and transport of certain types of knives across state lines, from switchblades and butterfly knives to knives with blades propelled by springs. And while this might not be the intent of the bill, as written, those federal laws would arguably not apply to someone caught possessing or transporting knives across state lines by operation of the odd and inscrutable addition of the notwithstanding clause. The bill's conflicting and confusing language would have a negative effect on public safety. And because H.R. 60 creates a private right of action for any person who's deprived of the rights, privileges, or immunities conferred by the bill, this confusion will almost certainly invite costly litigation. The uncertainty in the meaning of the statute, which is completely unnecessary, and the fear of litigation together would undermine public safety, placing both officers and the public at risk. If my colleagues would like to pass legislation to allow knife owners to travel freely with their knives, they should do so through a narrowly tailored common sense measure that keeps public safety in mind. There is one that is moving in the Senate. I oppose this legislation, and I yield back to you, Mr. Chairman.
Gentleman yields back without objection. All of the opening statements will be included in the record. The chair now recognizes the gentleman from Arizona for the purpose of offering an amendment in the nature of a substitute.
I have an amendment at the desk.
Clerk will report the amendment.
Amendment in the nature of a
Without
substitute.
objection, the amendment in the nature of a substitute will be considered as read and shall be considered base text for the purpose of amendment. The chair recognizes the gentleman from Arizona to explain the amendment.
Mr. Chairman, this amendment simply removes the year in the title of the bill and does not substantively change the bill in any way, and I urge support of the amendment and yield back.
Gentleman yields back. Who seeks recognition? Gentlelady from North Carolina is recognized.
Mr. Chairman, I have an amendment at the desk.
Clerk will report the amendment.
Order.
Point of order reserved by the gentleman from Arizona.
Okay. Thank you, Mr. Chairman and Ranking Member Raskin. To be
Wait. We're gonna have the clerk report here, and then we'll get to your statement.
Amendment to the amendment in the nature.
Without objection, the amendment will be considered as read. The gentlelady from North Carolina is recognized to explain the amendment.
Oh, okay. Thank you, Mr. Chairman and Ranking Member Raskin. To be clear, I am strongly opposed to this bill for the reasons outlined by the Ranking Member. But my amendment is an attempt to make this backward legislation a little bit less terrible. It's simple. The amendment makes it clear that anyone convicted of a crime of domestic violence or subject to a court order relating to domestic violence is not covered by the protections in this bill. An FBI report indicated that almost 15% of domestic violence murder victims were killed with a knife. And almost 19% of domestic violence-related aggravated assault victims were assaulted with a knife. Without this amendment, domestic abusers would be free to carry these knives across state lines and continue to stalk, threaten, assault, and even kill their victims. My amendment mirrors existing and well-settled federal law that prohibits anyone who has been convicted of domestic violence or is subject to a court order relating to a domestic violence order from owning or transporting a firearm. There is no equivalent statute prohibiting the possession or transportation of knives for known abusers, and I hope that the committee supports this common sense amendment. If we're going to report this bill out, we cannot give stalkers and abusers free license to keep hurting victims. It's shameful that we are spending our time protecting the rights of people who would use their knives in domestic violence. And it's, at the very least, we should take action to protect survivors of domestic violence who've endured unspeakable trauma and ensure that we're not extending protections to violent individuals. Thank you, and I yield back.
Gentleman yields back. Gentleman withdraw his point of order.
Withdraw my point of order.
Point of order is withdrawn. Gentleman from Arizona is recognized.
Yeah, Mr. Chairman, I oppose this amendment. It's unnecessary. This bill already prevents prohibited users from the protections otherwise provided in H.R. 60. Yield back.
Gentleman yields back. Who seeks recognition? Question occurs on the amendment offered by the gentlelady from North Carolina. All those in favor say aye.
Aye.
Those opposed, no. No. In the opinion of the chair, the noes have it. The amendment is not adopted.
Mr. Chairman, I ask for the ayes and nays.
The gentlelady requests the yeas and nays. The clerk will call the roll.
Mr. Jordan?
No.
Mr. Jordan votes no. Mr. Issa? Mr. Biggs? Mr. Biggs votes no. Mr. McClintock? Mr. Tiffany? Mr. Massey? Mr. Roy? Mr. Roy votes no. Mr. Fitzgerald? Mr. Klein? Mr. Klein votes no. Mr. Gooden? Mr. Gooden votes no. Mr. Van Drew? Mr. Nels? Mr. Moore? Mr. Moore votes no. Mr. Kiley? Ms. Hageman? Ms. Lee? Mr. Hunt? Mr. Fry? Mr. Grothman? Mr. Knott? Mr. Harris? Mr. Onder? Mr. Onder votes no. Mr. Schmidt? Mr. Gill? Mr. Baumgardner? Mr. Raskin?
Aye.
Mr. Raskin votes aye. Mr. Nadler? Aye. Mr. Nadler votes aye. Ms. Lofgren? Ms. Lofgren votes aye. Mr. Cohen? Mr. Johnson? Mr. Swalwell? Mr. Liu? Ms. Jayapal? Mr. Correa? Ms. Scanlon? Ms. Scanlon votes aye. Mr. Neguse? Ms. McBath? Ms. McBath votes aye. Ms. Ross? Ms. Ross votes aye. Ms. Ballant? Ms. Ballant votes aye. Mr. Garcia? Mr. Garcia votes aye. Ms. Kamlager-Dove? Mr. Moskowitz? Mr. Moskowitz votes aye. Mr. Goldman? Ms. Crockett? Ms. Crockett votes aye. Mr. Issa, you're not recorded. Mr. Issa votes no. Mr. Massey, you're not recorded. Mr. Massey votes no. Mr. Baumgartner votes no.
Clerk will report.
Mr. Chairman, there are 10 ayes and 10 noes.
The amendment is not agreed to. Who seeks recognition? Question occurs on adoption. Gentleman from Florida is recognized.
Thank you, Mr. Chairman. Sorry, appreciate the opportunity. So I kind of just want to level set the bill for a second. So while the American people are worried right now about losing Social Security and Medicare and Medicaid, they're worried about raising, the rising prices of goods. What is Congress focused on? What are we focused on? Right? We should be focused on kitchen table issues, but actually, we are focused on kitchen table issues. We're focused on cutlery, okay? But, look, this is a commitment. This is a commitment by my colleagues across the aisle. They're very committed to the kitchen. Very old-fashioned of them. Because remember, gas stoves, dishwashers, and now cutlery. And so, I know there's more gas stove hearings, and so this fits right in, I think, with the priority list of what we're doing in our third hearing. I am interested to know how they feel about foreign knives, right? Like German knives and French knives, Ginsu knives. Can't forget the Swiss Army knife, supporting a foreign army. Are we tariffing any of the foreign knives? Right? Are we tariffing the German knives or the French knives? Are the tariffs on? Are they off? Right? I don't know. Are there reciprocal knife tariffs? Perhaps, are we going to impeach any of the knives? A lot of impeachment talk. A lot of impeachment talk by people of this committee. I don't know if the knives have done anything we don't like recently, so we might impeach some of the knives. Perhaps maybe me and the sponsor could talk offline how we feel about the European knives, maybe on Signal later. So that way, no one finds out how we really feel about the European knives, right? Maybe we can do that. And so, again, we're here talking about cutlery, third hearing in Congress. For the American people out there who are really worried about what we're doing on the Hill, don't worry, we're worried about your knives. Thank you, Mr. Chairman.
Gentleman yields back. Question occurs on the adoption of the amendment in the nature of a substitute. This will be followed immediately by a vote on reporting the bill. All those in favor say aye. Aye. Those opposed, no.
No.
In the opinion of the chair, the ayes have it, and the amendment in the nature of a substitute is adopted. The question is on favorably reporting the bill as amended. All those in favor say aye. Aye. Those opposed, no.
No.
The ayes have it, and the bill is ordered to be reported favorably to the House. Members have 2 days to
We would like to request a recorded vote, Mr. Chairman.
record a vote being requested. The clerk will call the roll.
Mr. Jordan?
Yes.
Mr. Jordan votes yes. Mr. Issa? Mr. Biggs? Mr. Biggs votes yes. Mr. McClintock? Mr. Tiffany? Mr. Massey? Mr. Massey votes yes. Mr. Roy? Mr. Roy votes aye. Mr. Fitzgerald? Mr. Fitzgerald votes aye. Mr. Klein? Mr. Gooden? Mr. Van Drew? Mr. Nels? Mr. Moore? Mr. Moore votes yes. Mr. Kiley? Ms. Hageman? Ms. Lee? Mr. Hunt? Mr. Fry? Mr. Grothman? Mr. Grothman votes aye. Mr. Knott? Mr. Harris? Mr. Onder? Mr. Schmidt? Mr. Schmidt votes aye. Mr. Gill? Mr. Baumgartner? Mr. Raskin?
No.
Mr. Raskin votes no. Mr. Nadler? No. Mr. Nadler votes no. Ms. Lofgren? Ms. Lofgren votes no. Mr. Cohen? Mr. Johnson? Mr. Swalwell? Mr. Liu? Ms. Jayapal? Mr. Correa? Ms. Scanlon? Ms. Scanlon votes no. Mr. Neguse? Ms. McBath? Ms. McBath votes no. Ms. Ross? No. Ms. Ross votes no. Ms. Ballant? Ms. Ballant votes no. Mr. Garcia? No. Mr. Garcia votes no. Ms. Kamlager-Dove? Mr. Moskowitz? No. Mr. Moskowitz votes no. Mr. Goldman? Ms. Crockett? Ms. Crockett votes no. Mr. McClintock votes aye. Mr. Harris votes aye. Mr. Onder votes aye. Mr. Kiley votes aye.
Gentleman from Texas.
Mr. Niles votes yes.
Clerk will report.
Mr. Chairman, there are 13 ayes and 10 noes.
The ayes have it, and the bill is ordered to be reported favorably to the House. Members will have 2 days to submit views. Without objection, the bill will be reported as a single amendment in the nature of a substitute incorporating all adopted amendments, and staff is authorized to make technical and conforming changes. Pursuant to notice, I call up H.R. 2243, the LEOSA Reform Act of 2025 for the purpose of markup, and move that the committee report it favorably to the House. The clerk will report the bill.
H.R. 2243.
Without objection, the bill be considered as read and open for. Reform Act allows qualified, active, and retired law enforcement officers to carry concealed firearm in national parks, school zones, public transportation, some federal facilities, and that are open to the public. President George W. Bush signed LEOSA into law in 2004 to exempt certain active and retired law enforcement officers carrying a LEOSA photographic identification card from local and state prohibitions on carrying of concealed firearms. In order to qualify under the law, active law enforcement officers must meet several requirements. For example, they must be authorized to carry a firearm by their agency. They can't be subject to disciplinary actions by the agency that could result in a loss of their police power. They have to meet certain firearms qualification standards. They can't be under the influence of alcohol or other intoxicating substance, and they must not be prohibited by federal law from receiving a firearm. Retired law enforcement officers must also meet a number of requirements in order to qualify under LEOSA. For example, they must have separated from service in good standing and served as a law enforcement officer for an aggregate of 10 years or more. They're also required to meet certain firearms training standards and must not be prohibited by federal law from receiving a firearm. The LEOSA Reform Act will allow these officers to carry a concealed firearm in the same manner that many licensed citizens carry a firearm in their state. For example, the Reform Act will allow law enforcement officers qualified under LEOSA to carry firearms, concealed firearms, in national parks, federal facilities that are open to the public, on public transportation, and in other areas. The bill also reduces the frequency that qualified retired law enforcement officers are required to obtain certain qualification standards. Many states allow state-licensed concealed carry permit holders to carry a concealed firearm in gun-free school zones and on public transportation in the state in which they are licensed. This bill affords certain law enforcement officers that same privilege. We should support our active and retired law enforcement officers and ensure that they have ability to protect themselves and others, no matter where they are in our great country. I urge my colleagues to support the bill, and now yield to the ranking member for his opening statement.
And thank you very much, Mr. Jordan. In 2004, Congress passed LEOSA, the Law Enforcement Officer Safety Act, a law that allows both off-duty and retired law enforcement officers to carry concealed firearms anywhere in the country, irrespective of state laws. LEOSA preempted states' judgments about what was best for their own communities and their residents, forcing all states to allow off-duty and retired law enforcement personnel to carry concealed firearms under the terms set by Congress. As Congress debated LEOSA, members of this committee on both sides of the aisle, including the Republican chairman, expressed grave concerns about how the bill violated the essential principles of federalism and undermined the right of states to decide concealed carry gun policies for themselves under the 10th Amendment and under the Second Amendment. The Republican chairman of the Judiciary Committee at the time, Congressman Sensenbrenner, strongly opposed LEOSA and voted against it for this very reason. Several police groups also condemned the legislation and lobbied against it, expressing concerns about how it would affect officer safety, how it could create more confusion in responding to active shooters, how it might expose their agencies to more liability when officers carried under LEOSA, and how it failed to spell out the specific qualifications and requirements as they pertained to retired officers. Despite all of these objections, LEOSA became law. Although it did at least include some significant limitations and imposed common sense training requirements, which have now been in place for more than 20 years. The bill we're considering today, the LEOSA Reform Act, would wipe the slate clean in a way that will undoubtedly bring delight to the NRA, ending whatever remaining discretion states have to limit the circumstances and places at which individuals can enjoy concealed carry under LEOSA. It would force states to permit retired and current officers to carry concealed firearms onto private property, open to the public, including restaurants, bars, parks, and playgrounds. It would force states to allow off-duty and retired officers to engage in concealed carry on buses, trains, and subways. Shockingly, it would even force states to allow for the concealed carry of firearms in gun-free school zones. It also allows off-duty and retired law enforcement officers to completely disregard state laws prohibiting high-capacity magazines. This legislation not only supersedes the judgment and the policy discretion of the states, but it also threatens the safety and security of federal agencies by forcing them to allow concealed carry under LEOSA in many federal buildings. Forcing federal offices and buildings to allow concealed carry in these places is a completely unnecessary risk today. Another troubling aspect of this legislation is that it weakens training standards. Under current law, a person carrying under LEOSA must meet state training requirements every year. But this legislation would allow individuals to conceal carry with training certification as sparingly as every 3 years. This is troubling given that the bill extends nationwide concealed carry to retired officers who are no longer receiving the training that accompanies their employment. All of these expansions are risky given the large number of people this new law applies to. We know there are more than 700,000 active law enforcement officers nationwide, and while we don't know the exact number of retired officers, we know the number has increased significantly in recent years as many departments across the country have faced sharp increases in retirement rates. One study found that there are 4 retired officers and 4 resigned officers for every 100 active officers each year. So the universe of people this bill would apply to is substantial. Certainly, weighing in the hundreds of thousands. And when it comes to the relaxed training requirements, we're ultimately talking about a lot of people, including many who are retired and no longer receiving regular training, all with the ability to carry concealed firearms in many more places. Of course, our colleagues wish it were the case that a good guy with a gun is the answer to a bad guy with a gun, but the research simply doesn't bear it out. Studies show that individuals successfully defend themselves with a gun in less than 1% of crimes involving personal contact. Members, gun accidents, and unnecessary escalation remain pervasive threats. We have dozens of proposals that we know would actually make our community safer, Mr. Chairman, while still respecting states' rights. This bill is not one of them. I urge all of our colleagues to oppose this legislation on a bipartisan basis, as many members did the last time it came up, in an even better form. Thank you, and I yield back.
Gentleman yields back. The chair offers an amendment in the nature of the substitute. The clerk will report the amendment.
Amendment in the nature of a
Without objection, the
substitute.
amendment in the nature of substitute will be considered as read and shall be considered base text for purpose of the amendment. The chair is recognized to explain the amendment. This amendment simply removes the year in the title of the bill. Is not intended in any way to alter the important purpose of the legislation. I urge support of the amendment. I yield back. Who seeks recognition? The question occurs then. What is? Chair asks unanimous consent to enter into the record the Sergeants Benevolent Association statement of support, the National Fraternal Order of Police statement of support, and a number of other law enforcement agencies who support the legislation. Now the question occurs on passage of the adoption of the amendment in nature of a substitute. This will be followed immediately by a vote on reporting the bill. All those in favor say aye. Aye. Those opposed, no.
No.
The ayes definitely had it. In the opinion of the chair, the ayes have it, and the amendment in the nature of a substitute is adopted. The question is on favorably reporting the bill as amendment. All those in favor say aye. Those opposed, no.
No.
I think the ayes had it again, but I think that'll be recorded.
Yes, Mr. Chairman.
Ranking member
It's not that I don't trust your judgment, but I would like a recorded vote on that. So.
The clerk will call the roll.
Mr. Jordan?
Yes.
Mr. Jordan votes yes. Mr. Issa? Mr. Biggs? Mr. McClintock? Mr. Tiffany? Mr. Massey? Mr. Roy? Mr. Roy votes aye. Mr. Fitzgerald? Mr. Fitzgerald votes aye. Mr. Klein? Mr. Gooden? Mr. Van Drew? Mr. Nels? Mr. Nels votes yes. Mr. Moore? Mr. Moore votes yes. Mr. Kiley? Ms. Hageman? Ms. Lee? Ms. Lee votes aye. Mr. Hunt? Mr. Fry? Mr. Grothman? Mr. Knott? Mr. Harris? Mr. Harris votes aye. Mr. Onder? Mr. Onder votes aye. Mr. Schmidt? Mr. Schmidt votes aye. Mr. Gill? Mr. Baumgardner? Mr. Raskin? Mr. Raskin votes no. Mr. Nadler? Mr. Nadler votes no. Ms. Lofgren? Ms. Lofgren votes no. Mr. Cohen? Mr. Johnson? Mr. Johnson votes no. Mr. Swalwell? Mr. Liu? Ms. Jayapal? Mr. Correa? Ms. Scanlon? Mr. Neguse? Ms. McBath? Ms. McBath votes no. Ms. Ross? Ms. Ross votes no. Ms. Ballant? Ms. Ballant votes no. Mr. Garcia? Mr. Garcia votes no. Ms. Kamlager-Dove? Ms. Kamlager-Dove votes no. Mr. Moskowitz? Mr. Goldman? Ms. Crockett?
No.
Ms. Crockett votes no. Mr. Issa, you're not recorded. Mr. Issa votes yes. Mr. Massey, you're not recorded. Mr. Massey votes aye. Ms. Scanlon, you're not recorded. Ms. Scanlon votes no. Mr. Baumgartner votes yes. Mr. Grothman votes yes.
Clerk will report.
Mr. Chairman, there are 13 ayes and 11 noes.
Without objection, the bill will be reported as a single amendment in nature of a substitute. The ayes have it, and the bill is ordered to be reported favorably to the House. Members will have 2 days to submit views. Without objection, the bill will be reported as a single amendment in the nature of a substitute, incorporating all adopted amendments, and staff is authorized to make technical and conforming changes. Okay, pursuant to notice, I call up H.R. 2240, the Improving Law Enforcement Officer Safety and Wellness Through Data Act of 2025 for purpose of markup. Move that the committee report it favorably to the House. The clerk will report the bill.
H.R. 2240.
Without objection, the bill will be considered as read and open for amendment at any point. The chair is now recognized for an opening statement. The Improving Law Enforcement Officer Safety and Wellness Through Data Act will help our men and women in blue. Police officers risk their lives every day to protect our communities. Unfortunately, they face the continued threat of unprovoked attacks. The defund the police movement continues to have ripple effects throughout the country as criminals remain brazen in their attacks against police officers. In New York City last year, a violent gang of migrants viciously attacked 2 NYPD officers, one of whom was back out on the street after a slap on the wrist jail sentence. Rogue prosecutors and left-wing bail reform policies continue to allow criminals back on the street with no accountability. We should be clear, the threat to officer safety is very real. In 2024, 342 officers were shot in the line of duty, including 61 in ambush-style attacks. 2023 saw the highest number of officers shot in the line of duty recorded in a year, with 378. While the government collects basic information on these attacks, such as when the attack occurred and what types of weapons were used, more information is needed to help law enforcement officers prepare for, identify, and prevent future anti-police activity. Again, this bill will help provide the tools for police officers to train for and prevent attacks. That is so important in the environment our police officers live and work in today. Legislation will also shed light on the mental health impacts of aggressive activity or other trauma on law enforcement, and it will help ascertain the availability and extent to which mental health resources for officers are used. Mental health resources are another crucial tool in the toolbox as law enforcement officers continue to risk their lives every day to keep their communities safe. We must take care of those who do so much to take care of us. This legislation is common sense, seeks to gather more information on an issue to then bring forward the best possible solutions for our law enforcement officers. We should work together to take a stand against attacks on law enforcement and support the men and women who risk their lives every day. With that, I yield to the ranking member for an opening statement.
Thank you very much, Mr. Chairman. I support the Improving Law Enforcement Officer Safety and Wellness Through Data Act. It purports to improve law enforcement officer safety and wellness by requiring that the Attorney General and other federal officials issue reports on attacks on officers, aggression against officers, and officer mental health. The collection and reporting of information in general, and this information is unobjectionable. But I do feel compelled to point out the obvious here. The legislation does nothing to actually make police officers safer. In fact, none of the bills we're marking up today would make law enforcement or anybody else in the country safer. And one of them, the Constitutional Concealed Carry Reciprocity Act, so-called, which is strongly opposed by law enforcement, would make everybody much less safe, including police officers. The reality is, although I'm going to support the legislation, we don't need another report to tell us what is the biggest threat to officer safety in America. We already know what it is. It's guns that are by far the most serious threat to police officer safety in America. We have a lot more firearms than we do people in the United States. We have a rate of gun homicide 20 times higher than the nations of the European Union, 7 times higher than the people of Canada. No wonder they don't want to take up Donald Trump's offer to become part of the United States. They're a lot safer with the gun laws in Canada than they would be under Donald Trump's gun laws. We have a rate of gun death 340 times higher than the people of the United Kingdom. Gun violence is now the #1 cause of death for young people under 18 in the United States of America. Law enforcement officers in the U.S. are far more likely to be fatally shot than police officers in any other developed nation on earth. From 2012 to 2021, 456 police officers were shot and killed in our country. During that same 10-year period, 12 officers were shot and shot to death in Canada. That is 456 in the United States, 12 in Canada. Only 4 were fatally shot in the United Kingdom. Those nations, of course, have common sense gun safety laws, and they are not constantly being derailed by the National Rifle Association and the gun manufacturers. Guns are also the leading cause of police officer assaults. From 2012 to 2020, 735 officers were assaulted and injured with a gun in our country, accounting for 3/4 of line-of-duty assaults over this period. Officers face unacceptably high risks every single day as they do their jobs. It doesn't have to be like this. An analysis of state gun laws and police fatalities found that the states with the strongest gun laws had far fewer police officer fatalities than the states with the weakest gun laws that allow violent criminals to run amok with guns. And yet Republicans continue to want to pass laws that further weaken our gun laws and thus endanger law enforcement along with everybody else. Even when the police make it clear that they oppose those laws. In Texas, law enforcement opposed a bill to allow people to conceal carry without a permit. The Texas Police Chiefs Association said the bill posed a real threat to all law enforcement and the people. The Republican-controlled Texas legislature passed it anyway. The same thing happened in 4 other states. Law enforcement in Alabama, Tennessee, Ohio, and Iowa all strongly opposed permitless carry bills, and in each state, GOP lawmakers simply ignored them and passed the bills anyway. In Ohio, law enforcement and teachers came together to oppose a law to arm teachers, kindergarten through 12 teachers, but once again, Republicans passed the bill anyway over strong objections from the police. When Democrats had control of the House, we passed numerous bipartisan bills, Mr. Chairman, that were signed into law and are improving law enforcement safety and wellness right now. These bills include the Protecting America's First Responders Act, the Public Safety Officer Support Act, the Confidential Opportunities for Peer Support Cops Counseling Act, and the Law Enforcement De-Escalation Training Act. And we passed laws that would make everybody in America safer by reducing gun violence, including the bipartisan Safer Communities Act, which has saved thousands of lives. I encourage my colleagues across the aisle to join us in proposing and passing meaningful, substantive, common sense, constitutional legislation that offers real solutions to the challenges our cops face every day on the streets in America and make everybody safer. In the meantime, we have no opposition to collecting more information and reporting to Congress. I just hope our colleagues are prepared to take meaningful legislative action to improve officer safety. Thank you, Mr. Chairman. I yield back.
Gentleman yields back. Chair now offers an amendment in the nature of a substitute. The clerk will report.
Amendment in the nature.
Without objection, the amendment in the nature of substitute will be considered as read and shall be considered as base text for the purposes of amendment. Chair now is recognized to explain the amendment. This amendment simply edits the short title of the bill. There is no substantive change to the bill. I urge support for the amendment and yield back. Who seeks recognition? The gentlelady from Georgia is recognized.
Thank you, Mr. Chair. And I would like to say that I do associate myself with all the comments of the ranking member. As we know, he's spoken very candidly the truth of what we all know, and especially myself, having experienced gun violence. I could not be more truthful and honest about what he has just said, but law enforcement officers do serve as our first line of defense against danger. And with this bill, we have an opportunity to equip the Department of Justice and Congress with crucial information to better understand and enhance officer safety. Law enforcement officers deserve to return home safely to their families, knowing their well-being is a priority. Our federal law enforcement officers face long hours, immense pressure, and unpredictable dangers. Over time, this constant strain can take a significant toll on their health and their welfare, in particular their mental health. While the mental health resources currently available are a positive step, there is always more room for improvement. This report will provide invaluable insights into the challenges our officers face and what additional support that they need to remain physically and mentally safe. Federal law enforcement officers dedicate themselves to protecting our nation. and it is our responsibility to ensure they receive the protection and care that they deserve. I support this legislation, even though it's not enough, and I will hope that it provides information that we can use to develop bipartisan proposals that will improve officer safety and wellness, and I yield back.
Gentleman yields back. Who seeks recognition? Gentleman from Florida is recognized.
Thank you, Mr. Chairman. I think it's always good, like when we have something that's bipartisan, to point it out because it happens so little around here anymore. But rather than giving like a really big, long speech, I feel like I could just use this, and this will tell you that I think it's good, right? So like that's a fist, American flag, fire. So I'll just, from now on, when we do things where like we agree, I'll just hold this up rather than giving like a really big, long speech. So job well done, guys.
Would the gentleman yield?
Oh, sure, I'll yield.
But I'm not sure everybody recognizes the reference there. Would you explain where that comes from?
Yeah, so this is how when we're in like a chat with friends, right, where we're like having a casual chat about like where we're dropping missiles.
Are you talking about a public chat room?
Yeah, but like, and with friends, and we're just like, you know, hamming about who we're gonna bomb and all of that. But we agree, we fist American flag fire. So I'm holding this up. I think we could just keep the committee shorter if like when we agree, we just hold this up.
No, I think you're supposed to have the flexed arm instead of the fist.
No, it was just,
Okay.
it was just the fist. What signal chat are you in?
But
I was on Twitter.
If the gentleman would yield for an additional question,
Sure.
But what happens if there are reporters who might be there for that?
Well, hopefully they support America and that it's fire.
So you're telling me we can't have a bipartisan conversation among members of the committee without a journalist being there?
Well, we can, but if you don't add them, if you don't want them to know.
And what if they just happen to show up somehow?
Well, that's because somebody added them.
Thank you.
You're welcome.
Does the gentleman yield back?
I did.
The gentlelady from Texas is recognized.
It is hard to follow up behind Mr. Moskowitz on any given day. But I did just kind of want to reiterate what the ranker talked about when he talked about Texas, and he mentioned that permitless carry was something that went through the Texas House. And I can remember being on the floor and seeing all the law enforcement officers coming to Austin to lobby us and make sure that we did the right thing. And they also testified, and they told their stories, and they talked about how dangerous it was. And for whatever reason, my colleagues on the other side of the aisle, it all fell on deaf ears. And it made me wonder if Republicans really meant it when they said that they backed the blue. Because when given an opportunity to back the blue, they didn't. And today, we heard from the chairman that this is all about supporting law enforcement. And to be clear, I am going to also support this bill. But the idea that you can say on one hand, I support law enforcement, while on the other hand, I am okay with January 6ers getting out who assaulted law enforcement. If you can say I support law enforcement, yet you still continue to pass bills that are causing more deaths, not only to our precious children, but it makes it so much more dangerous. Right now, it is difficult to recruit law enforcement officers because of some of these crazy laws. A lot of law enforcement officers want to go to states that are smarter about their gun laws. So I'm just asking, again, I'm going to support this bill, but if we are going to be amenable enough to say that, you know what, transparency in these numbers, this is something that will be helpful for all of us to be able to evaluate, why can't we have a real conversation on what it takes to actually keep us safe in this country? That's the only thing that I'm asking for, is a real discourse, a real conversation about what does it look like to keep not only the streets in my district safe, but the streets in your district safe as well, because we as Americans should want to be safe. We as elected officials carry the responsibility of making our streets safe. So with that, I will yield.
Gentlelady yields back. Gentleman from New Jersey is recognized.
Thank you. I wasn't going to speak on this one because I thought we all agreed, and I guess we do on the bill, but I just wanted to bring something up. I'm a gun owner. I have permit to carry, do everything right, and never have had a problem, thank God. Pray to God I never, ever would have to use it. I qualify every single, at least every 10 days. You only have to qualify once every 2 years, and I'm responsible. And that's the point. The majority of gun owners in America, legal gun owners, are responsible. But, you know, murdering is against the law. Stealing a gun is now against the law. Violence with a gun is against the law. It doesn't matter what state you're in. Threatening somebody with a gun is against the law. Scraping the serial numbers, filing the serial numbers off a gun is against the law. You know, some things that should be against the law, prematurely releasing violent offenders back into the street over and over and over again, not doing anything when people show that they have a horrible history, that they commit crimes, that they've threatened people, they're online, what they look like online, their online character. But what we do is we inflict more and more regulations and jam up legal people that would never hurt anybody, and it's very easy. I'm going to tell you a story. It's true, and I got a lot of stories. A young woman, though, from Pennsylvania had a permit to carry, never has even gotten a speeding ticket, didn't have a problem at all, single young African-American woman. She's driving into New Jersey, drives over the bridge, makes a mistake, didn't realize she had to have another permit in New Jersey. Again, this is a person who never did anything bad and legally was carrying in the state of Pennsylvania. So she gets stopped, and she lets the police officer know and says, just so you know, officer, I have a gun. It's in my glove compartment. Wanted you to know that. It wasn't the officer's problem. He was in New Jersey. He had to abide by the law. He had to arrest her. Never had a speeding ticket, this woman, right? Had to arrest her. You know what they did to her? They gave her 3 years in prison. And fortunately, the governor stepped in and got her out. That's what some of these laws we do are not going after the real cause of the problem. There are bad people out there. And you know what? When you pass more and more and more restrictive laws against legal gun owners, good people get in trouble. We should have some laws, I agree, but good people get in trouble. And I'm going to really lay this one on everybody, and this is a big surprise. The bad people, the murderers, those that commit violence with guns, this may sound weird, but they don't care if they got a permit or not.
Well,
guess what? They steal their guns. They get their guns from illegal sources. They file the serial numbers off their guns. I was in the state Senate in New Jersey. We were doing a bill on guns, and one of the other state senators said to me, you know, why didn't you vote for this thing? And I said, and I gave her the whole speech that I just said now, and she said, yeah, but this was a legal gun. It only had the serial numbers filed off. It was illegal. You can't do that.
Rep. Drew,
we already have these laws. Enforce the damn laws we have now. Go after the bad people. Go after the people that have severe psychiatric issues. Don't do this to good law-abiding Americans. This is a good bill. I'm sorry I got into this, but I couldn't help it because everybody else.
No, Rep, will you yield for a friendly, just
sure,
couple of questions?
I can yield you. Yes, I'll yield you.
Okay,
yield to
perfect. I'm licensed to carry as well. I'm a Texan. So I'm licensed to carry, own firearms as well. And so I appreciate that. The bill that I was referring to through our state house, the concern for law enforcement was that anyone would be allowed to carry and they would not go through any type of training or anything like that. And would you agree with me? I don't know what licensing you went through specifically. I'm guessing it's New Jersey.
I have New Jersey, New York. I've got Washington, D.C., so I've gone through a lot.
But I'm sure in your trainings, they talk about how to safely store the firearm. They talk about things such as, you know, where you should aim when you're using it and, like, do not aim unless you plan to use it, especially when you're going to potentially use it on somebody, correct?
And those are good things.
Correct.
Reclaiming my time.
Go ahead.
Those are good things. I'm not arguing with that. Most everywhere has all that. In effect, I can't speak for every single state in the union. And it's curious, too. Some states, like Vermont, that are generally 10 Democrat, and I'm not giving you a hard time, I promise, But they have very liberal philosophy on this. It's an individual state-by-state thing. But I'll yield back to the chairman.
Gentleman yields back. If there's no objection, I'm going to submit for the record a survey conducted by the National Association of Chiefs of Police. 86.4% of the U.S. chiefs of police and sheriffs support nationwide recognition of state-issued concealed weapons permits. 76% of those same heads of departments believe that qualified law-abiding armed citizens help law enforcement reduce violent criminal activity. Seeing no objection, I submit that for the record. Who seeks recognition? Gentlelady from Vermont is recognized.
Thank you, Mr. Chair. I'm going to keep this really brief. I care deeply about the issues of mental health. It's one of the issues that I ran on. And like my colleagues, I will be supporting this. But there is something that we could do today to help the mental health of our Capitol Police. Today. There is a plaque that is waiting to be hung by the architect of the Capitol that is about the sacrifices and the injuries and the vicious attacks that our Capitol Police endured on January 6th. It is made, it is ready to be hung, and the Speaker of the House will not release it to the architect of the Capitol to be hung. We know where it's supposed to go. Everything is dotted, everything is crossed. Why is it that this very simple gesture that we could make today to thank the Capitol Police for what they've done and to acknowledge the suffering that they've gone through, we can't even get that hung up? So I will support this, but we actually could be putting pressure on some folks in our own chamber to acknowledge what has happened to these officers who protect us every day. And I just find it disgusting that we can't get this plaque hung up to acknowledge what they've been through. And I see the ranking member would like some time, and I yield to the ranking member.
Thank you for yielding, Ms. Ballant, and thank you for that very important intervention in this discussion. I wish that, I wish our colleagues would talk to the House leadership about doing this. I heard from Gladys Sicknick, Mrs. Sicknick, who's the mother of the late Capitol officer Brian Sicknick, who died on January 7th, 2021, after severe violent attacks he suffered on January 6th. He had multiple strokes, and he died the very next day. But I hear from Capitol officers all the time asking the question, when will the plaque go up? It's not that big a deal, really, and given the extraordinary sacrifice which members on both sides of the aisle have recognized verbally, you think it would be the least that we could do to post this plaque in honor of the officers who fought for us on January 6th. And we saw members fleeing that day. No member was violently assaulted, although there were lots of injuries and lots of deaths. More than 140 of our officers were brutalized, wounded, injured, hospitalized, hit over the head, smashed in the face. People suffered broken noses, broken jaws, broken ribs. Why is this not happening? The gentlelady from Vermont, I don't even think you were here with us back when that happened. She was not a member of Congress then. But I thank you for listening to the officers about this, because it's a rather shocking situation that people will come and mouth pieties about backing the blue, but when it comes right down to it, they're backing the coup instead, in the way it's been retroactively rehabilitated and turned into Mardi Gras, as I think the new U.S. Attorney for the District of Columbia describes it. It was Mardi Gras, he said. And the president has said that his followers actually greeted our cops with hugs and kisses. He said it was a day of beauty, it was a day of love. He makes it sound like it was Woodstock. Woodstock for the Proud Boys and the Oath Keepers. So come on, let's get serious. If we're if a lot of the legislation we're looking at today is about honoring the police officers, let's honor the cops who helped save our lives on that day. And if you doubt that that was the case, go back and listen to our Republican leaders, including Speaker Johnson, who condemned the atrocious violence that took place on that day against our officers in an attempt to hang Mike Pence and assassinate Nancy Pelosi and overturn our system of government. I yield back to you, and thank you for yielding.
And I yield the balance to the member, Ms. Scanlon.
And I just wanted to add, thank you for bringing that up. I think it's more important than ever that we get that plaque hung after the disgraceful pardoning of people who actually were convicted for attacking our Capitol Police officers and our Metropolitan Police officers. I yield back.
Gentlelady yields back. The gentleman from Kentucky is recognized.
Well, it seems like the Democrats have jumped the gun, so to speak, on the gun control bills or gun rights bills. That's not the debate that we're having right here, but I find it necessary to insert some facts into this dialogue because they have jumped the gun. And I would point out that Ashley Babbitt was the only person killed with a gun on January 6th. That was by a police officer. Now, a recent study of Ohio's constitutional carry law conducted by the Center for Justice Research shows that after constitutional carry was enacted in Ohio, the rates of crime involving a firearm decreased in 6 of Ohio's 8 largest cities. So this is, I think Paul Harvey would say we need to deliver the rest of the story. There may have been opposition to these bills when they passed in the state legislatures, but there's no proof that they had a negative effect, and there's a proof that people are safer after this has happened. And then if we get to the effects on law enforcement, results of that same study in Ohio show that constitutional carry did not appear to have any appreciable effort on law enforcement injuries or deaths by firearms in Ohio's cities of interest. And then finally, somebody earlier referenced that Ohio had a debate and ultimately allowed some school districts to carry, for people to carry in the schools of some of those districts. And this is the case nationwide. Again, for the rest of the story, people need to know who are watching this, there's never been a shooting, a mass school shooting in a school that allows people to carry in that school. And so with that, that's the rest of the story, and I'm going to yield back.
Gentleman yields back. Who seeks recognition? Question is on the adoption of the amendment in nature of a substitute. This will be followed immediately by a vote on reporting the bill. All those in favor say aye. Aye. Those opposed, no. No. In the opinion of the chair, the ayes have it, and the amendment in the nature of a substitute is adopted. The question is on favor of reporting the bill as amended. All those in favor say aye. Aye. Those opposed, no. No. The ayes have it, and the bill is ordered to be reported favorably to the House. Members will have 2 days to submit views. Without objection, the bill will be reported as a single amendment in the nature of a substitute incorporating all adopted amendments, and staff is authorized to make technical and conforming changes. Pursuant to notice, I call up H.R. 2255, the Federal Law Enforcement Officer Service Weapon Purchase Act for purposes of markup, and move that the committee reported favorably to the House. The clerk will report the bill.
H.R. 2255.
Without objection, the bill will be considered as read and open for amendment at any point. The chair now recognizes the gentleman from South Carolina, Mr. Fry, for an opening statement.
Thank you, Mr. Chairman. H.R. 2255, the Federal Law Enforcement Officer Service Weapon Purchase Act of 2025, allows current and retired federal law enforcement officers to purchase retired service weapons issued by a federal agency to the officer at salvage value. Under this bill, the administrator of the GSA would be required to establish a program to allow current and retired law enforcement officers to purchase a retired firearm from the agency that issued that firearm to that officer. In order to be eligible to participate in the program, the officer must be in good standing with the agency they currently or formerly served. Any firearm sold through the program must be sold within 6 months of the date when the firearm was retired. Machine guns are excluded from the list of eligible firearms. Furthermore, the firearm must be sold at salvage value. Under current policy, federal agencies are required to destroy retired firearms by crushing, cutting, breaking, deforming each firearm to ensure that they are rendered completely inoperable and incapable of being used, except for the recovery of basic material. Additionally, destruction, quote, destruction of firearms must be performed by an entity authorized, end quote, by the head of the agency, and the destruction, quote, must be witnessed by 2 additional agency employees authorized by the agency head or designee. These actions all come at a cost to the American taxpayer. Taxpayers should not be forced to pay for the same firearm twice, first when it is originally purchased, and second, when it is needlessly destroyed. Not only would this legislation eliminate those unnecessary costs, but it would also recoup some taxpayer dollars from the initial purchase of that firearm. In 2022, the Fraternal Order of Police notified Congress that multiple federal law enforcement agencies were in the process of replacing their service weapons. These transitions accounted for the destruction of approximately 20,000 firearms, costing the taxpayer roughly $8 million, allowing current and retired federal law enforcement officers to purchase such firearms would save millions of dollars to the American taxpayer. Last Congress, this legislation passed the House of Representatives with 232 votes, a bipartisan win. 13 Democrats voted in favor of this bill, including some that serve on this committee. This bill was never taken up by the Majority Leader Chuck Schumer for reasons that I do not know. But I want to remind my colleagues across the aisle that the last Congress, this bill was supported by leading law enforcement groups, including the National Fraternal Order of Police, the Federal Law Enforcement Officers Association, the National Association of Police Organizations, and the Federal Bureau of Investigation Agents Association, and Women in Law Enforcement. This bill is a priority for law enforcement, and Congress must do its part in supporting those who risk their lives for the safety of our citizens. This legislation not only saves American taxpayers millions of dollars every year, but also creates a system in which law enforcement officers in good standing can exercise their Second Amendment rights. I'm confident that more of my colleagues across the aisle will recognize this bill not as a partisan measure, but as a common sense, cost-saving initiative that supports law enforcement and the American taxpayers. Once this bill passes the House, I urge my Senate colleagues to put aside politics and send this bill to President Trump's desk and do what's right to ensure that it passes in both chambers. I urge support, and I yield back.
Gentleman yields back. The chair will now recognize the ranking member for an opening statement.
Thank you very much, Mr. Chairman. Federal agencies are currently prohibited from selling functional or reparable firearms that are no longer needed. Under this regulation, when an agency no longer has a need for a firearm, it can either transfer it to another law enforcement entity or it can destroy it. This regulation helps ensure that federally owned firearms do not fall into the wrong hands, but it does miss an opportunity to save money by selling surplus firearms to the responsible law enforcement officers who use them. So in the 117th Congress, our former colleague, Congresswoman Val Demings from Orlando, who had been chief law enforcement officer there, introduced bipartisan legislation to allow a federal agency to sell at fair market value a surplus handgun to the officer who'd been using it on duty. Under the Demings bill, these sales would have required a background check, and it would have required that the proceeds from the sales would have been used for gun violence prevention and for gun safety training. Last Congress, Congressman Fry introduced a bill similar to the Demings proposal, but it wasn't bipartisan, it did not require a background check, and it did not provide any direction about what the funds resulting from the sales should actually be used for. Still, Democratic members of this committee felt it was reasonable, not as good as the Demings version, but they felt it was reasonable, and it passed out of the committee on a voice vote. If our colleagues had simply stuck with that version, I suspect it would be receiving broad support on the floor and might very well have been signed into law by now. But they instead chose to substantially dilute and change the bill again by adopting new amendments when it was brought to the floor. One amendment changed the sale price from fair market value to salvage value, effectively setting up the federal government and the citizens to subsidize private gun sales. Another amendment expanded the bill significantly by allowing surplus firearms to be sold not only to active federal law enforcement officers in good standing, but also to retired law enforcement officers. Because the Fry bill had also eliminated the background check requirement, this would create the remarkable situation in which it would be possible for an officer to retire, commit a crime that makes him or her ineligible to purchase and possess firearms, but then still be able to buy a firearm from the federal government without getting a background check. Agencies have no reason to track the behavior of their former law enforcement officers and are under no legal duty to do so, so they could unwittingly sell a surplus firearm to someone who cannot lawfully buy a gun. And all of this would occur without a background check that might otherwise prevent an illegal sale from happening. Another amendment expanded the types of guns that agencies could sell. Originally, the bill just applied to surplus handguns that the officers used, but it was amended to apply to any surplus firearm other than machine guns, including assault weapons, destructive devices like grenades, and even firearms that are subject to heightened restrictions under the National Firearms Act. Given that the bill had already removed the background check provision, these amendments would make it so that current and retired law enforcement officers would be able to buy an assault weapon, a grenade, or a National Firearms Act weapon from the government at a discount and without a background check, opening up a significant loophole suddenly in the background check system. We've come a long way from the original idea by Congresswoman Chief Demings. This led many Democrats to oppose the bill on final passage when it came up for a floor vote last Congress. All of these flawed amendments appear today in the version of the Fry bill that has now been recombined and all packed together. So in place of a reasonable bipartisan bill, Republicans are digging in on a proposal that opens up significant loopholes in our gun laws, turning it into Swiss cheese. It's disappointing that Republicans could not resist politicizing this traditionally bipartisan proposal that came originally from a Democrat. Because this bill creates unacceptable risks of a dangerous weapon being sold to a person who may not legally have one, I must oppose this legislation in its current form, and I urge all of our colleagues to read it carefully and to do the same. I yield back to you, Mr. Chairman.
Gentleman yields back. Without objection, all other opening statements will be included in the record. The chair now recognizes the gentleman from South Carolina to offer an amendment in the nature of a substitute.
Thank you, Mr. Chairman. I have an amendment at the desk.
Clerk will report.
Amendment in the nature of a
Without
substitute.
objection, the amendment in the nature of a substitute will be considered as read and shall be considered as base text for the purposes of amendment. The chair now recognizes the gentleman from South Carolina to explain the amendment.
Thank you, Mr. Chairman. This amendment just adds the year of the title of the bill. This amendment is not intended in any way to alter the substance or important purpose of this bill. And I yield back. Prior to doing that, though, I do seek unanimous consent to submit a letter to the record in support of the legislation, H.R. 2255, signed by the Association of State Criminal Investigative Agencies, the Federal Law Enforcement Officers Association, Major City Chiefs Association, Major County Sheriffs of America, the National Association of Police Organizations, the National Narcotics Officers Association Coalition, and the Sergeants Benevolent Association, NYPD.
Without objection, they'll be included in the record. Who seeks recognition? Gentlelady from Georgia is recognized.
Thank you, Mr. Chair. And once again, I associate myself with the comments of the ranking member. But Mr. Chairman, H.R. 2255, the Law Enforcement Service Weapon Purchase Act, misses an opportunity for a bipartisan bill and creates unacceptable loopholes in our gun laws. This bill would allow firearm sales to retired federal officers without a background check. One might think that those who have retired from federal law enforcement would be responsible individuals who can pass a background check, and undoubtedly, many of them are. But the bill creates an opportunity for someone to be employed as a federal law enforcement officer, retire, and then, perhaps years later, buy a gun from the federal government without a background check. The agency simply has no way to know what the person might have done in those intervening years. They could have become subject to a restraining order or addicted to illegal drugs, actions that would make it illegal for them to buy a gun, and it would make it so that they would fail a background check. But their former employing agency would have no way to know that. Our colleagues might point out that the bill does require that a retired officer be in good standing in order to buy a gun under this bill. but that requirement is not defined. And that might be because this requirement simply doesn't make sense. Law enforcement agencies don't continue to track the lives of their employees after they retire. They do sometimes declare that law enforcement officers retired in good standing, but that's a determination made at the time that they're actually retiring. It gets us right back to the same issue. What happens after they retire? Background checks are the gold standard for ensuring someone is allowed to lawfully purchase a firearm. This issue could easily be solved by adding the background check provision back into this bill. And a background check would not be burdensome to officers and retired officers, since the vast majority of background checks are completed within minutes. Our colleagues have continued to dig in their heels on a bill that creates an unacceptable loophole in the background check system, a loophole that could put a gun in the hands of a person who is not legally allowed to have one. And even one instance of this could have deadly consequences. This bill could be bipartisan, as it was in the 117th Congress when it was led by my friend, my former colleague, and former Orlando Police Chief Val Demings. Former Congresswoman Demings frequently reached across the aisle. Over 40% of her bills had bipartisan co-sponsorship in her last term in office. We should be following her example to lead with bipartisanship when possible and strive to work together to help improve our communities. This bill is being marked up in advance of Police Week, a time when we used to be able to work together to pass bills with broad bipartisan support. We should be looking for ways to help law enforcement make our communities safer in places that they live, and ways to help law enforcement stay safe as they do their work. We should be investing in tools to help them be effective and directing resources towards solving violent crime. As ranking member of the Subcommittee on Crime, I hope we can still find a better way to do this. My door is always open to my colleagues on the other side, always open to those who want to work together in good faith. I must oppose this legislation for creating needless risks that could have deadly consequences. I call on my Republican colleagues, and I really mean this. I call on you to work with us on bipartisan bills that would give law enforcement the tools that they need instead of opening up loopholes in our background check system, and I yield back.
Gentlelady yields back. Who seeks recognition? The gentleman from New York, and then we'll come to.
I have an amendment at the desk.
Clerk will report. Gentleman from California reserves a point of order.
Amendment to the amendment in the nature of a substitute to H.R. 2255 offered.
Without objection, the amendment be considered as read. The gentleman from New York is recognized to explain his amendment.
Thank you, Mr. Chairman. This amendment does a simple but very important restriction on the ability of a retired officer to purchase a retired firearm from his or her agency. And that is to limit the number of firearms purchased by such officer to one. This bill does nothing to prohibit an officer from purchasing any number of firearms from his agency or her agency, and then with the possibility of distributing them or selling them to others outside of the normal background check requirements for federal firearms sellers. By limiting the number of firearms to one, I believe that we are getting to the true purpose of this bill, which is to allow retired officers to maintain a firearm that they used, if in good standing, while in service. And if the rationale is, as my friend from South Carolina says, which is to simply allow retired officers to continue to hold and possess their own firearm from while they were in service, there should be no objection
to limiting the number of firearms to one. I think this amendment is eminently reasonable, gets to the heart of what the bill drafter is trying to get to, and very importantly, limits the possibility of further distribution of firearms without adhering to the guidelines that protect selling firearms and putting them in the hands of those who should not have them. And I yield back.
Gentleman yields back. Is there further discussion on the amendment? Mr. Fry.
Thank you, Mr. Chairman. Just in response to the amendment, I oppose it, and here's the reason why. I mean, you've got a federal law enforcement officer in good standing, and we are continuing to perpetuate the existing scheme, which costs taxpayers $8 million a year, that somehow that they're limited if they are assigned a pistol, a long gun, and a shotgun, somehow they're limited by this amendment to just have one of those. Well, it doesn't make any sense to me that we're continuing to perpetuate the existing scheme that costs the taxpayers $8 million a year. This is common sense, it is easy to do, and this amendment absolutely limits the intent of the bill and continues to cost the taxpayers needless dollars.
Will the gentleman yield for a question?
I yield back.
Will the gentleman yield for a question?
The gentleman is yielded back. Is there further discussion on the amendment?
I seek recognition.
Gentleman is recognized.
Sure. I know the sponsor of the bill just left, probably just a potty break, but I'm just curious. He was not okay with one. What about two or three? He gave the example of three. What if we set a limit at three? Would he be okay if the amendment was three? I'm just curious. You know, maybe we could try to make it bipartisan. I mean, what we're trying to do is we're just trying to not have an open-ended thing. And so he gave an example of three. If three is the number, I'll support that amendment. If that's okay. Does anyone on the side want to like have a conversation, or how about the gentleman who brought the amendment?
Well, I appreciate the distinguished gentleman from Florida's point, which I think goes even further. It is one thing for an on-duty officer to maintain a pistol, a long gun, and a shotgun while in the service of duty. It is altogether another thing for a retired officer who would not be on any mission or any obligation to act to protect anyone other than him or herself to have three guns. What is the point? If this is just so that a retired officer can defend him or herself with the gun, a gun that he or she used while in service, why on earth would that officer need more than one gun?
Would the gentleman yield for a question?
Yes, of course.
Is there anything in their legislation that would prevent a retired officer from reselling a gun or guns that they are able to purchase at the new salvage value?
There is nothing in this bill that prohibits the distribution or selling of a firearm obtained by a retired officer from the agency where he or she serves.
So you're telling me that a retired officer, if we don't accept your amendment, could purchase 5 guns or 10 guns or 20 guns at the new government discounted price and then resell them at a fair market value price? In other words, they could make money on it through private sales. Is that right?
Absolutely, and even worse, it wouldn't be detected. It wouldn't go through, it wouldn't be required to go through the normal background check procedures, the tracing through the ATF to ensure that that sold gun does not fall into hands of someone who would otherwise be prohibited from owning a gun.
If I could ask one other question of the distinguished gentleman from New York, it seems to me that we either have to adopt your amendment, and this is certainly consistent with the way that Ms. Demings first brought this up, that it was the idea that the officer would be able to purchase their gun when they leave the service, and that was clearly her intent. Either we've got to adopt that, or if it's going to be unlimited, that they can purchase at salvage value whatever guns from the police force arsenal are being retired, then we've got to say that these guns cannot be resold on the private market, because otherwise we're opening up a gaping new loophole in terms of guns entering into the market. And of course, it's that kind of permissiveness and laxness that has given America a rate of homicide, violence, and death that is just unknown in the rest of the advanced countries of the world.
Will the gentleman yield?
I will yield in 1 second. I just want to respond. I actually considered an amendment to that effect as well. The problem, of course, is it is very hard to enforce, and it would certainly cost more than $8 million to do so. I'm kind of surprised that a justification for this bill is that we spend $8 million, not billion, not trillion, but $8 million, which is pennies compared to our budget, that is some sort of motivation for why we should allow the sale of these firearms to the officers. And again, there's no good rationale why it should be more than one. I yield to the chairman.
I just wanted to point out that bill is self-limiting. It's limited to firearms that have been issued to the law enforcement officer. It's not open-ended.
So just reclaiming my time, which kind of went around. So what you're proffering is that there is a limitation in the bill, that there is a limitation on how many weapons.
The bill only applies to firearms issued to the law enforcement officer.
That could be any number.
Gentleman's time has expired. Further discussion, Mr. Massey.
You know, on the other side of the aisle, there's an assertion or an assumption that's completely wrong about this bill that I heard expressed. They said this is so that police officers can protect themselves after they retire. No, they have decades of learning, of discernment, of training, of experience. And the incentive here is if you let them have their firearm, that they will continue to do that for the public on their own dime. They'll carry these firearms. They've been trained to recognize situations. And it's a way to get a safer environment for the public, and all you're doing is making it easier for the law enforcement officer to carry their firearm into retirement. So I reject the assertion that we're just doing this so that they can be safer themselves.
Will the gentleman yield?
Sure.
So in the language, and we're trying to actually work this out. It doesn't say their firearm or the firearms issued to them. It says a firearm. And so that's where the discussion is going. If the intent of the language is that they can only purchase the firearms issued to them, then I think some of the concern that we have would go away. So if we just seeking that clarification.
Will the gentleman yield?
Yes, I'll yield.
I mean, the language is quite clear that the Administrator General Services shall establish a program under which a federal law enforcement officer may purchase a retired firearm from the federal agency that issued the firearm to such officer.
Wait, would the gentleman yield?
Well, Mr. Massey's time. Yield back, Mr. Massey.
Yeah, I think it's pretty clear here in the legislation. It says, may purchase a retired firearm from the federal agency that issued the firearm to such officer.
Will the gentleman yield just for a question?
In just a second, but will you admit that what was just said is wrong, that it doesn't say anywhere in the language that it's one that was issued to this officer?
Wait. Yes, I will. I would like to correct that. All that does is it clarifies and specifies which agency the officer may purchase a retired firearm from. It does not say that it must be a retired firearm belonging to such officer. So maybe
reclaiming my time, I want to point out here, and I appreciate you clarifying what you said before. A retired firearm from the federal agency that issued the firearm to such officer. So the firearm is referring to the one that the officer was issued.
It's modifying the federal agency. It's not modifying the gun. The gun is a retired firearm, and then it's specifying that the retired firearm is from the federal agency that issued the firearm to such officer.
So the firearm, I think, is clear here, but would the gentleman vote for this bill if we change A to the in the first instance of retired firearm?
Well, if it, I mean, I would certainly be inclined to vote for this bill if it were to specify that a retired officer may purchase a firearm that had been distributed or had been issued to that officer. So in other words, it would have to change more than A to the, but yes, if your point is to say that only firearms that belong to that officer can be sold to that officer in retirement, then yes.
I'll offer the amendment if the gentleman will vote for it and vote for the bill, the underlying bill.
Yeah.
All right.
Well,
No, with the background.
well,
Still have a
yeah.
background check.
Will the gentleman yield?
Yeah, I have 36 seconds.
Okay. So we're achieving some clarity here. Right now, it is written in such a way as to say that as long as the gun comes from the same agency that issued
No, it's not.
It says the officer may purchase a retired firearm from the federal agency that issued the firearm to such officer. Right?
The firearm.
It has to be issued to him.
But
It has to be issued to him, and it's the firearm.
No. But it's just saying that it's the federal agency that issued the firearm.
I make you
It
the
says that
same offer.
Okay. Well, in any event, if we can agree to the point, the substance of it, I would support this if we include the background check.
No, now you're moving the goalpost.
No, I'm restoring what we passed as a committee before.
It's kind of becoming obvious that you're refusing to diagram the sentence, and you're just being dilatory.
The gentleman's time has expired. Is there further discussion on the amendment by Mr. Goldman? Mr. Chairman. Yeah, gentleman from Georgia is recognized.
Thank you, Mr. Chairman. You know, oftentimes when a bad actor, law enforcement officer, even from a federal agency, does something that violates the rules of the agency, it may even violate the law. It may be related to excessive use of force. But such officer is allowed to resign in lieu of termination. And in those kinds of situations where a bad police officer, a bad actor, is being pressured to resign or be fired and chooses to resign, that officer would probably be in good standing with the federal agency that employed that officer. And then that officer would be in a position to purchase at salvage value whatever firearm was either issued to him or her, as my colleagues are talking about, or whatever firearm, whether or not it was issued or not to that particular officer. But the point is that you have bad actors who would be able to purchase firearms under this legislation, firearms that were either issued to them or may not have been issued to them. That is creating a danger to society when you are unleashing these powerful weapons into the hands of someone who's being offered the opportunity to step down in lieu of termination. Because of that glaring loophole in this legislation, I would be opposed to it. And with that, I will yield back.
Gentleman yields back? Yeah, we're having a different. Does the gentleman yields back? Yeah. Further discussion on the amendment by Mr. Goldman, Mr. Van Drew.
Thank you, Chairman. Just quickly, I think maybe we're looking into this, how do I say this? I think we're overreading what's going on here, overanalyzing. A police officer retires. When he retires, he wants to keep the gun that was issued to him over the years that he carried as a police officer. He would be able to buy that gun, and I don't think there's anything wrong with this, at the salvage value. The least we can do for somebody that's dedicated their life to serving, to protect others, is that we're still charging them, but we charge the salvage value. If you're trying to indicate, which I don't see here in the legislation, that years later the police officer could buy other firearms from an agency, then I think that a background check would be appropriate. I'm going to vote for this legislation either way. I don't like to vote for amendments on the fly because usually they don't work out. They have to be thought through. And I'm sure the sponsor of the bill, Mr. Fry, if he feels it's necessary, along with the chairman, would move forward if any amendments need to be done as we go to the floor. But nevertheless, we're overthinking this. A cop retires, the gun that he used, he wants to buy it. He buys it, yes, at a discount, because it's a used gun, by the way, and it's the least we can do that he buys it at the salvage value, and it's the gun that was issued to him. So that's how I'm seeing this legislation. I yield back.
Gentleman yields back. Is there further discussion on the amendment? Is there further discussion on the amendment? Seeing none, the question is on the adoption of the amendment by Mr. Goldman. Those in favor say aye. Those opposed say no.
No.
The noes appear to have it, and the amendment is not agreed to.
Can we have a recorded vote on that, Mr. Chairman?
Recorded vote's been requested. Clerk will call the roll.
Mr. Jordan.
Okay.
Mr. Issa. Mr. Biggs. Mr. Biggs votes no. Mr. McClintock.
No.
Mr. McClintock votes no. Mr. Tiffany. Mr. Massey.
No.
Mr. Massey votes no. Mr. Roy. Mr. Fitzgerald. Mr. Klein. No. Mr. Klein votes no. Mr. Gooden. Mr. Gooden votes no. Mr. Van Drew. No. Mr. Van Drew votes no. Mr. Nels. Mr. Moore. Mr. Moore votes no. Mr. Kiley. Mr. Kiley votes no. Ms. Hageman. Ms. Lee. Mr. Hunt. Mr. Fry. Mr. Fry. Mr. Fry votes no. Mr. Grothman. Mr. Grothman votes no. Mr. Knott. Mr. Knott votes no. Mr. Harris. Mr. Harris votes no. Mr. Onder. Mr. Onder votes no. Mr. Schmidt. Mr. Gill. Mr. Baumgartner. Mr. Baumgartner votes no. Mr. Raskin.
Aye.
Mr. Raskin votes aye. Mr. Nadler. Mr. Nadler votes aye. Ms. Lofgren. Mr. Cohen. Mr. Johnson. Mr. Johnson votes aye. Mr. Swalwell. Mr. Liu. Ms. Jayapal. Mr. Correa. Ms. Scanlon. Ms. Scanlon votes aye. Mr. Neguse. Ms. McBath. Ms. McBath votes aye. Ms. Ross. Ms. Ballant. Mr. Garcia. Mr. Garcia votes aye. Ms. Kamlager-Dove. Ms. Kamlager-Dove votes aye. Mr. Moskowitz. Mr. Goldman.
Aye.
Mr. Goldman votes aye. Ms. Crockett. Ms. Crockett votes yes.
How am I recorded?
Mr. Issa, you're not recorded. Mr. Issa votes no. Ms. Ballant, you are not recorded. Ms. Ballant votes aye.
Clerk will report.
Mr. Chairman, there are 10 ayes and 15 noes.
Vote being 10 in the affirmative, 15 in the negative, the amendment is not agreed to. Is there further discussion on the amendment in the nature of a substitute? Ms. Scanlon.
I just wanted, with respect to the underlying bill, I just wanted to associate myself with the remarks of the ranking member and with Ms. McBath. I think they very eloquently stated the base points, but above all, we need to close loopholes, not create new loopholes. When I talk to our law enforcement officers in my district at every level, they say they need help to make sure that we keep guns out of the hands that don't, of people who shouldn't have them. So I can't support the law because it does create a new loophole, and with that, I yield back.
Gentlelady yields back. Is there further discussion on the amendment in nature substitute? Mr. Raskin.
Mr. Chairman, I have an amendment at the desk.
Clerk will report. Gentleman from Arizona reserves a point of order.
Substitute for the amendment and the nature of a substitute to H.R. 2255, offered by Mr. Raskin of Maryland.
Without objection, the amendment is considered as read. The gentleman from Maryland is recognized.
Thank you kindly, Mr. Chairman. My amendment would substitute for this unnecessarily politicized bill text the language that was voice voted unanimously, as far as I could tell, out of this committee without objection during the 118th Congress. The bill before us would allow law enforcement officers and retired officers to buy an assault weapon, a hand grenade, or a National Firearms Act weapon from the government at a sharp discount without a background check, opening up a significant and dangerous new loophole in the background check system. This is despite the fact that 6 in 10 Americans support stricter common sense gun safety laws to reduce the horrific gun-related death toll that we see all around us in the cities, in rural areas, and suburban areas. My amendment returns us to the version of the bill that was previously reported out of this committee and would likely yield substantial bipartisan support on the floor. It would ensure that only active law enforcement officers can purchase retired service weapons, significantly reducing the risk that a prohibited purchaser would be able to buy a gun as a result of our legislation. It would also limit purchases of retired weapons to handguns and ensure that taxpayers are not subsidizing the private purchase of weapons by requiring an officer to pay the fair market value of the weapon. I urge our colleagues to take yes for an answer to restore the bipartisan common ground legislation we all approved of last Congress, and which will achieve perhaps unanimous support on the House floor. I thank you, Mr. Chairman, and I yield back.
Gentleman yields back. Is there discussion on the amendment by the ranking member? Mr. Knott.
Mr. Raskin, may I ask a question?
Yes, of course.
What's the purpose from limiting this just to a handgun if an officer or an agent is familiar with AR-15s or whatever the shotgun, long guns, whatever they may be? What would be the purpose that you're seeking to achieve in precluding them from being able to take those weapons home?
Well, the purpose is consistent with what I understood to be the original motivation behind the legislation that Congresswoman Demings had introduced. I was here on the committee, and she talked about giving officers the right to purchase a gun that they had used for self-defense. And as the Supreme Court determined in Heller versus District of Columbia, that's a core Second Amendment right to be able to carry a handgun for self-defense. So
may I? Mr. Raskin, in regards to the threat to the threat to the public, handguns are used in far more crimes. They're responsible for far more deaths than long guns, whether it's shotguns or AR-15s. Does that alleviate any concerns you have about allowing federal agents or officers to take those guns with them in the same spirit as this language?
Well, we could check with Mr. Fry about it because this was his original legislation, and it is true that the toll of handgun violence is extraordinary because we don't have a universal violent criminal background check, and we have so many loopholes. So I'm not certain I know the answer to that question. I think we could check with Mr. Fry, who originally introduced it this way. It struck us as a reasonable, common sense, bipartisan compromise consistent with the original bill that had been introduced by Congresswoman Demings.
Thank you for the discussion, sir. And I'll just state for the record, Mr. Chair, that having worked with law enforcement at every level, their training, their handling, their abilities with those firearms, I've never seen a law enforcement officer act irresponsibly in allowing them to take home their service weapons. In the spirit of this law, I fully support. I yield back.
Gentleman from North Carolina yields back. Is there further discussion on the amendment? Seeing none, the question is on.
I'm sorry.
Mr. Massey.
I think there's a fair point here that Mr. Raskin has. I'm not going to vote for his amendment, but because our friend over here has a great point that long guns and shotguns can be just as effective or more effective in certain circumstances for defending a person or the public. And so we shouldn't exclude those. But the point I believe you do have is that there may be some NFA, National Firearms Act, weapons that would be allowed under this that might not be necessary for self-defense, like hand grenades. So I plan to offer an amendment that takes care of that issue here after your amendment is voted on.
Jenny, Ms. Baxter, further discussion?
In response to Mr. Goldman's concern.
Does Mr. Massey yield to Mr. Raskin?
I'll yield to Mr. Raskin.
Yeah, no, I appreciate that very much, Mr. Massey. Look, the legislation that we adopted by voice vote last Congress was a compromise which articulated the basic common sense understanding that an officer could essentially take a gun with them, purchasing it at fair market value, in order to have self-defense. And then when we add in everything else, we do get hand grenades and, semi-automatic assault weapons and all of these things, which raises different kinds of issues and strays far from the core meaning of a self-defense weapon. And so that's why I think this, again, would pass overwhelmingly, if not unanimously, in the House if we just went back to that original compromise. But it has been shot through with a bunch of loopholes that are unnecessary. So, I would view your suggestion as a second best solution to just going back to the compromise that we originally had. Thank you.
Mr. Massey.
Reclaiming my time, I think we can make legislation better. We don't have to use the same stuff we had last year if we found a better way to do it. So, and oh, by the way, I think your amendment has something about the price of the gun that the officer has to pay. And again, the motivation, I believe, behind this bill is if you encourage or make it easier for retired police officers who have decades, in many cases, of experience of defending the public, make it easier for them to carry their service weapon when they retire, that they could provide that help. And by the way, retired police officers are often used in school settings to, as the security. And so, because they recognize there's training there's experience, and there's decades of discernment. So I think charging more for the firearm doesn't help, and that's one reason that I can't vote for yours, but I will try to address the concern that you have about NFA weapons with my amendment that I will offer next.
Would the gentleman yield?
I'll yield to Mr. Vandrew.
Just want to associate myself with the remarks by Mr. Knott and Mr. Massey. I think is one point about the hand grenade or something that wouldn't be appropriate is a good point. And his second point, why are we trying to squeeze police officers and say they have to pay more than the salvage value? Again, they serve their long career. They put their lives on the line. We certainly can do this tiny, tiny little thing for them. However, I think the legislation could be tightened up, and I think that would be an appropriate amendment. I would support that amendment, Mr. Massey, just so you know. I think it's a good idea, and I yield back to you.
Mr. Massey.
And I yield back to the chairman.
Gentleman yields back. Is there further discussion on the amendment by Mr. Raskin? Does Ms. McBath seek recognition?
Yes, I do, Mr. Chair. And having good conversation with Mr. Goldman and also with Ranking Member, I would be willing to accept the amendments. I would be willing to have Raskin's amendment. I think the further discussion that we've had is amenable, and it does still continues to close some loopholes. I yield back.
Further discussion on the amendment? Seeing none, the questions on the adoption of the amendment by Mr. Raskin. Those in favor say aye.
Aye.
Those opposed say no.
No.
The noes appear to have it.
Could we have a recorded vote?
A recorded vote's been requested. Clerk will call the roll.
Mr. Jordan. Mr. Issa. Mr. Biggs. Mr. McClintock.
Nope.
Mr. McClintock votes no. Mr. Tiffany. Mr. Massey.
No.
Mr. Massey votes no. Mr. Roy. Mr. Fitzgerald. Mr. Klein. Mr. Klein votes no. Mr. Gooden. Mr. Gooden votes no. Mr. Vandrew. Mr. Van Drew votes no. Mr. Nels? Mr. Moore? Mr. Moore votes no. Mr. Kiley? Ms. Hageman? Ms. Lee? Mr. Hunt? Mr. Fry? Mr. Fry votes no. Mr. Grothman? Mr. Grothman votes no. Mr. Knott?
No.
Mr. Knott votes no. Mr. Harris? Mr. Harris votes no. Mr. Onder? Mr. Onder votes no. Mr. Schmidt? Mr. Gill? Mr. Baumgartner? Mr. Baumgartner votes no. Mr. Raskin?
Aye.
Mr. Raskin votes aye. Mr. Nadler?
Aye.
Mr. Nadler votes aye. Ms. Lofgren? Mr. Cohen? Mr. Johnson? Mr. Swalwell? Mr. Liu? Ms. Jayapal? Mr. Correa? Ms. Scanlon? Ms. Scanlon votes aye. Mr. Neguse? Ms. McBath? Ms. McBath votes aye. Ms. Ross? Ms. Ballant? Ms. Ballant votes aye. Mr. Garcia? Mr. Garcia votes aye. Ms. Kamlager-Dove? Ms. Kamlager-Dove votes aye. Mr. Moskowitz? Mr. Moskowitz votes yes. Mr. Goldman? Mr. Goldman votes aye. Ms. Crockett? Ms. Crockett votes aye. Mr. Swalwell, you're not recorded. Mr. Swalwell votes aye. Mr. Roy, you're not recorded. Mr. Roy votes nay. Mr. Fitzgerald votes no.
Clerk will report.
Mr. Chairman, there are 11 ayes and 14 noes.
Vote being 11 in the affirmative and 14 in the negative, the amendment is not agreed to. Is there further discussion on?
Yeah. Yeah.
Is there further discussion on the amendment, the nature of a substitute? Mr. Massey.
Mr. Chairman, I have an amendment at the desk.
Clerk will report.
Amendment to the amendment in the nature of a substitute to H.R. 2255 offered by Mr. Massey and Mr. Goldman. Page 1, line 10, after quote firearm.
Without objection, the amendment be considered as read. The chair recognizes Mr. Massey.
In the spirit of bipartisanship, I want to recognize that Mr. Goldman and Mr. Raskin have identified ways to improve this bill. And so I want to offer an amendment to address their concerns. It makes two changes to the bill. Page 1, line 10, after firearm in the first instance, where it's mentioned, add, quote, issued to the federal law enforcement officer, unquote. This takes away any ambiguity that might exist about whether the federal law enforcement officer is going to receive the weapon that was issued to that officer, or whether it would be any weapon in the, obviously, after this, it's obvious it doesn't include any weapon in the inventory of that agency. The second change that this amendment will affect on the bill is instead of just excluding machine guns, it will exclude all weapons and firearms covered by the National Firearms Act of 1934. So that would cover, for instance, the hand grenades that they mentioned, or other destructive devices, such as a sawed-off shotgun. Those would be excluded from the transfer to the law enforcement officer if it's and of course, machine guns are also included in that exclusion as well. We're keeping that exclusion. So with that, and Mr. Goldman has worked with me on this. We've used his language, and I'm offering this in the spirit of bipartisanship. If Mr. Goldman would like to speak on this, I would yield.
Yeah. Thank you, Mr. Massey. This certainly makes an improvement to the bill, and I appreciate the fact that we're engaged in meaningful legislative discussion here. We've never had a hearing on this legislation specifically, so I appreciate the fact that the markup is an occasion for us to make some improvements. But and it does, in terms of the things that I've raised, it does take care of not just machine guns, but other, hand grenades, short-railed rifles, sawed-off shotguns, other destructive devices that are regulated by federal law. My problem, my essential problem, though, is a somewhat different one, which is that the retired officers don't need to have a background check before they get whatever guns they're going to get. And that means the person could actually have committed crimes, but we wouldn't know about it because we don't take the 5-minute time period to do a background check on it. And that just doesn't make any sense. I mean, sometimes it takes 2 minutes to do a background check. And so I think there's some confusion about the word retirement and the 6-month period. When I first read it, it seemed like, okay, somebody retires and then within 6 months, they can purchase the gun, the rifle, what have you. But it's actually within 6 months of the retirement of the gun, not the retirement of the person. So it could be 5 years later or 8 years later or 10 years later. That's a lot of time in which a person conceivably could have crossed lines with the law. And so all we're saying is
reclaiming my time.
Yeah.
I hope we've ameliorated that concern somewhat by clarifying that it is the firearm that's being retired and the officer that's retired, and they are paired up. So it's not a carte blanche, open pass to go buy anything in the inventory, and it's reasonable to expect they're going to retire at the same time, the gun and the officer.
Yeah, but you're much more of a gun guy than I am, Mr. Massey. So I don't know what the average length or endurance of a gun is or a firearm is. And I just don't see the problem with restoring the background check. If we take your very fine amendment and we add it to a background check, I think we're close to the common sense, common ground legislation we're looking for.
My problem with that is this is an officer probably likely has 2 or 3 decades of experience, and there are 100,000 false denials in the background check system. And it would add, I think, insult to injury to tell an officer, hey, your name is similar to somebody else, and I'm sorry you can't have the gun you've carried for 3 decades. Yeah.
Would the ranking member yield?
And they would have to be in good standing when they retire. It's not like somebody was fired. I'll yield to Mr. Nadler.
Well, wouldn't a further amendment that made clear that you're talking about the retirement of the officer, 6 months within the retirement of the officer, rather than the retirement of the gun, take care of the problem?
This seems like we're in the weeds here. This is a common sense bill, and I think to complicate it with that. I'm bending over here quite a bit.
Well, if the gentleman would further yield,
Mr. Nadler.
just clarifying that we mean retirement of the officer doesn't impose any burden and would, and makes clear that.
But what I've just been informed, the way the bill's written, if the firearm is retired, the officer can obtain it, even if the officer is not retired.
Yeah, but the problem with
What
that.
is the problem
That's
with that?
exactly right. That's exactly correct. The problem with that is that the firearm may not be retired till 10 years after the officer retires, and maybe the officer, when he retired, is a perfectly fine guy, but in the interim 10 years, he committed crimes, and you wouldn't know that. So if we simply said 6 months from the time of the retirement of the gun, then well, you wouldn't have the problem.
Reclaiming my time, which doesn't really exist
Nadler
right now.
controls the time.
Whose time is it? Mr. Nadler, would you yield?
Okay.
They're not going to have a special safe for guns that officers might want 10 years later. The gun is either going to get reassigned to another officer, i.e. not retired, or it's going to get destroyed or disposed of some other way. They're not going to keep us.
Reclaiming my time.
It's not Dick's Sporting Goods.
Hopefully. Reclaiming my time, the Republicans had a common sense bill on the floor, and it was filled on the floor with loopholes. This amendment would simply restore it to the bill that the Republicans first. The Raskin amendment would simply restore it to the same bill that the Republicans offered on the floor last year. And we should have adopted it. And then we could, and if this amendment were adopted, we could support it now.
Would the gentleman yield?
I will.
Well, thank you. Look, here's where I think we are on this, and the public's getting the inside view of the sausage factory here. We had a bipartisan bill that the vast majority of people supported on the floor. Then it was revised with a whole bunch of new amendments that significantly broadened the bill and added loopholes that you have candidly acknowledged, Mr. Massey, with your amendment to take care of one of the problems. To my mind, it doesn't take care of the essential problem, which is that we don't want people being able to purchase firearms, especially from the police, without a background check. And the vast majority of background checks take place in 2 or 3 minutes, right? And I know you have a different perspective on that. You've got some cases where people have been caught up in that, and maybe there are some false positives or false negatives or what have you. But in the vast majority of the cases, it works, and most Americans are willing to pay that price for the purposes of public safety. If we can come together on that, in addition to the amendment you have, then we're back to the common sense, common ground gun safety legislation that allows for this to happen that we agreed to in the last Congress. So thank you for yielding, Mr. Nadler.
I would hope that Mr. Massey could accept this further amendment or the common sense bill that the Republicans offered last year, which we were going to support until it was filled with extraneous loopholes, and it would enable officers to who presumably had a background check while they were officers to take their to possess their guns, and if someone had waited years to try to do this after they retired, it would require a background check. Which should be the case because who knows, the former police officer may in the ensuing years have committed crimes, and we ought to know that before we allow the possession of the firearm. So I support Mr. Raskin's amendment, and I yield back.
Gentleman yields back. So further discussion on the amendment by Mr. Massey, gentleman from Wisconsin.
Move to strike class 4.
The gentleman's recognized.
I yield my time to Mr. Massey.
I think the basic problem, there's two basic problems here. Is what you're saying is you don't trust police officers, retired police officers, a federal police officer, or the federal agency who may be giving them the firearm. They have to be in good standing to receive it. Here's my problem. Over 99% of NICS denials are false denials. Now, I know you assign value to the 1%, and you say that's better than the, it's worth stopping the 1% that NICS may be accurate for, which is actually probably smaller than that, and burdening the public with the 99% false denials. To me, we shouldn't put a federal law enforcement officer in that kind of jeopardy. And the other problem that I have here, or that I'm seeing, this is not exactly the same bill. This is a better bill. And the problems that have been identified, I'm addressing with this amendment. And I believe there will be some on your aisle who recognize that. I would hope you would vote for my amendment, those on the other side of the aisle. But, you know, I worked with Mr. Goldman on this.
Would the gentleman yield for a moment?
And I'm sure you all have worked on this with people on this side. And you'll find we've got reasonable people, and some days we've got unreasonable people. But what I've found is somebody who's reasonable over there who wants to work with us and improve the bill. So that's what I've done.
The gentleman yield for a moment?
It's Mr. Fitzgerald's time.
To Mr. Nadler.
Yes, I just want to point out that Mr. Massey, I think, was mistaken. 99% of denials are correct. 1% are incorrect, not the other way around.
Okay.
I yield back.
Well,
Reclaiming. Yield to Mr. Massey.
okay, for the year that we have data, there were 12 prosecutions, federal prosecutions, and 110,000 denials. So and by the way, if you are denied, if you're rightfully denied, that means you tried to illegally purchase a firearm. You were a prohibited person who lied on the form, or, and those should have been, if it was 99% accurate denials, there should be tens of thousands of prosecutions from those denials, but instead there are 12 in a given year. And in the best year, no more than 24.
Will the gentleman yield?
I would yield.
Well, but I believe there is a scienter requirement. There's a specific intent requirement. I don't know why they're not bringing all of those cases, but it doesn't follow. It seems to me to be a non sequitur to say because they didn't bring prosecutions in all of those cases, those people were actually qualified to get
Reclaiming. Yield to Mr.
Okay,
Massey.
so here's the specter of what happens when you're denied. You can appeal, and if that appeal doesn't work, then you have to hire a lawyer. And now you're spending money, which defeats the whole purpose of this thing. And by the way, of all the denials ever, I suspect never was one a retired police officer. I mean, I don't know that, but common sense would tell you that. So it defeats the purpose if you're going to put the officer in jeopardy of having to hire a lawyer to get past the second denial of the background check if it's not overturned on the first appeal. And the purpose of this is we trust law enforcement officers. We've trusted them with our lives. They're in charge of public safety. They've spent decades doing it. It's the ultimate background check. You have put your life on the line. You have carried this firearm loaded for 365 days a year in many cases for 30 years, 20 years. That is the ultimate background check. We don't need to put them through some system that's hobbled with all sorts of inaccuracies. And let's just keep the intent of the bill. Let's clarify the objections that you had. I think that Mr. Goldman and these, I think you shared these objections, Mr. Raskin, that I'm addressing in this amendment. We're fixing two, not one of the objections. And let's get this bill done.
Gentleman
back to the
goes
gentleman
back.
from
Is there
Wisconsin.
further discussion on the amendment by Mr. Massey, Mr. Goldman?
First, I just want to thank my colleague, Mr. Massey, for engaging in this good faith effort to reach a resolution. I will say that as part of my discussions, I was under the impression, the wrong impression, that the officer would have to purchase the retired firearm within 6 months of the officer's retirement. If that were the case,
I do not worry nearly as much about a background check, since the officer would be in good standing upon retirement and then would purchase the firearm within 6 months. I think it is very unlikely that 10 years, there are many officers who purchase their own firearm 10 years later. But I do think that the open-ended time frame for an officer to purchase the firearm is potentially problematic. And I agree with Mr. Massey that it is the ultimate background check, which is why I have no problem if the officer has 6 months to purchase the firearm. But I think that we run into potential issues, and I would hate for an officer 10 years out, a retired officer, to have, to be able to purchase a firearm that another civilian would not have been able to purchase, and God forbid, do something terrible with the firearm. I am willing to continue to work with Mr. Massey if 6 months is not reasonable, given that firearms may be retired after the officer is retired. I understand there may be additional issues, but if there were some guardrails on the length of time, and I'm not requiring 6 months, but if there were some guardrails on the length of time so that it wasn't open-ended, I would certainly support this amendment, and I would support the underlying bill as well.
Would the gentleman yield?
Yes, of course.
I think you're correct. It's highly unlikely that 10 years later that the gun is still going to be in inventory and that the officer's still going to be interested in it. He's going to wake up one day and say, oh, you know that Colt I had? Boy, I miss it. It's been 10 years since I held that baby. And it belongs in my safe or on my side. I just don't see that happening. I think you don't either. Ultimately, what I need to know is if you're going to vote for the bill, if this amendment passes. I thought we had an agreement. I was working in good faith. I've modified this thing to ameliorate your first concern, and then you said you had another concern which you brought to me. And so I sent everybody back there to change the amendment again for your second concern. And so I'm all out of concerns. If you can't, after I've addressed, the two concerns that you've had, if you can't vote for the bill with this amendment as part of it, I will withdraw the amendment, and we'll have the partisan vote that it seemed we were doomed to on the way in that I was trying to avoid.
And I reclaim my time, and you are correct, you did address the two concerns I raised. As I said, I was under the misimpression that there was a time limit on the amount of time that an officer can do this. I am not prepared in this exact moment to tell you whether I will vote on the underlying bill. I understand that that is a concern of yours. Given the fact that we haven't had hearings on this bill and that we are doing this in real time, I would ask the chairman to table this amendment and this bill until later so that we can have some further internal and bipartisan discussion.
Will the gentleman yield?
Yes, I yield.
Just to add to one more concern, Mr. Massey, first of all, I hope you don't withdraw your amendment. I thought you were introducing the amendment in order to improve the bill, which it does, so people aren't getting hand grenades and other, dangerous, destructive devices. But in any event, if you look at page 2 on the amendment in the nature of substitute, I'm just confused about this because it begins with the limitations. A federal law enforcement officer may purchase a retired firearm under subsection A if the purchase is made during the 6-month period beginning on the date the firearm was so retired. And then, the top of page 2, with respect to such purchase, the officer is in good standing with the federal agency that employs or employed such officer. What does it mean for a retired officer to be in good standing with the federal agency? And that's why what I'm insisting on is the background check. I just don't know what that means.
The gentleman's time has expired. The chair claims time and yields to Mr. Massey.
Mr. Chairman, I thought I was working in good faith with the other side of the aisle. There was a legitimate concern, some ambiguity in the language. I committed to fixing that, and I thought I had at least one person who said, if I fix that, they would vote for it, but then he had another concern, and he said, okay, well, I've got this other concern. I need it fixed too, and then I'll vote for it. And I fixed the other concern, and we had an agreement. This isn't a backroom deal. This is all played out here in front of the public. You can watch us communicating with each other. And since the agreement is now broken, I regrettably am going to withdraw the amendment, and this will diminish my appetite for trying to work with the other side of the aisle in good faith, because
will the gentleman yield?
It has not worked out. It's Mr. McClintock's time.
Yep,
I yield back to Mr. McClintock.
I'll yield.
Thank you. I understand your frustration, Mr. Massey. I want to be very clear that I was also engaging very much in good faith. As I said to you, and I take responsibility for this, I thought the time frame of 6 months was the retired officer, not the retired firearm. That changes the calculus a little bit for me because I did not think that a background check would be necessary within a 6-month time frame. If we are now talking about 10 years or more, I just want to have an opportunity to think about this. You are certainly welcome to withdraw the amendment, but this is not a trivial matter, and I think that given that this is playing out in real time, we ought to take a few minutes to consider it, speak to some experts, and make sure that I don't have another misimpression about what we're doing here. But I do just want to emphasize, in response to your insinuation that I was not acting in good faith, that I very much was, and just simply was under a misimpression on the parameters that are in the bill already that I thought provided guardrails that it turned out do not. And so,
I'm reclaiming my time and yielding to Mr. Massey.
I withdraw the amendment.
Okay.
If I understand it, there's no debate at that point.
The gentleman begs leave to withdraw the amendment. Without objection, the amendment is withdrawn. The question is on the...
So, Mr. Chairman, I have an amendment at the desk.
Mr. Raskin.
But my amendment, the Raskin amendment is newly
Gentleman, suspend for a moment.
Yeah.
Clerk will report the amendment.
Reserve a point of order.
Gentleman reserves a point of order.
Amendment to the amendment in the nature of a substitute to H.R.
Without
22.
objection, the amendment is considered read. Chair recognizes Mr. Raskin for 5 minutes.
Mr. Chairman, thank you very kindly. This amendment, formerly known as the Massey Amendment, is now the Raskin Amendment. And it will do two primary things here. First, it will make clear, as I think we all agreed, that the firearm denominated in the legislation is the one that was actually issued to the federal law enforcement officer. And I want to thank Mr. Goldman for raising the issue, and I want to thank Mr. Massey for giving us the language to clarify that it is the firearm issued to the law enforcement officer. And secondly, it makes certain that what can be purchased by the officer, or in the newly expanded version, the retired officer, is a handgun, a pistol, a rifle, but not weapons and firearms covered by the National Firearms Act of 1934. And as the distinguished gentleman from Kentucky candidly acknowledged, we don't want to create this gaping new loophole where people can get a hold of hand grenades, sawed-off shotguns, and other types of firearms that have been regulated for decades in America. So, but I'm sorry that that he and Mr. Goldman fell out of love there briefly. But in any event, this is all about advancing public policy legislation, and we want to make sure we make the improvements that came through in actual legislative discussion. We had no hearing on this legislation, so we're essentially doing an impromptu hearing through the markup, and this will at least make what I think is a potentially very risky bill somewhat better, and I want to thank everybody who was involved in this. And so I recommend that we adopt this unanimously in the committee.
Someone from Kentucky is recognized.
I appreciate what the ranking member is trying to do here, but the amendment was offered with a concomitant promise to vote for this, to have a Democrat on the other side of the aisle vote for the underlying bill if this amendment became incorporated as part of the bill. And that's no longer the case. It's no longer the case. It was a compromise. It was a compromise. I apologize to the originator of the bill for trying to amend his bill, which I think actually was fine. And we were going to come to the other side of the aisle here, which I did twice. And so if you want to offer this amendment, that's great. I will not be voting for it because it's half of the bargain. It's the half that I offered without the half that your side offered. So it sounds pretty clever, but it's really not. It's very, I don't want to characterize the motives behind it, but I'll just say that I'm a no. And with that, I yield back.
Gentleman yields. Gentleman from Florida is recognized.
Thank you, Mr. Chairman. So I just want to make sure I'm following. And it's good that we're having these discussions. The American people want to actually see this, right? And it's okay that sometimes a deal falls apart. But obviously, I think you agreed that there isn't that issue in the bill. And regardless of the vote in here, Mr. Massey, there will be a vote on the floor. And I do think that language that you proposed would achieve the goal you were trying to achieve, which would be making it bipartisan on the floor. Because remember, this bill could still be amended beforehand, right? And so, as it was last time. And so I would ask that you reconsider either your own amendment, if you want your name on it, or the new Raskin amendment. Another thought I had, by the way, while I was sitting here is that, we're talking about an officer being able to buy a gun from the agency that issued it. I mean, the way things are going, you got members that actually want to eliminate the agencies that issued the gun in general. So this could be moot anyway, right? If you eliminate the ATF and you eliminate the FBI, the officer won't be able to buy the gun anyway. So, it may be moot to the point, but...
Will the gentleman yield?
I will.
Thank you kindly. I wanted to respond to the distinguished gentleman from Kentucky. In the first place, there was no deal with the Democratic side. I think there were two discussions taking place.
No, it was with Mr. Goldman.
Okay, so the first one was in discussion with Mr. Goldman about an ambiguity in the language, which both of you recognized. And the ambiguity was whether or not the retired law enforcement officer could purchase any gun from the agency where the person had worked, or just the specific gun. And what you were doing, I understand, was clarifying what everybody understood the intent of the legislation was, which is to give the officer the right to buy the guns that they actually used. So all you were doing there was clarifying what was the commonly understood intent of it. Now, on the other thing, I think, and the record will bear this out, as you said, the whole country is watching this, you said that I had correctly and accurately identified a real problem in the legislation as it was brought to us without a hearing. And that problem is that people could purchase hand grenades and sawed-off shotguns. And you said nobody thinks that's what we should be doing. So that wasn't a deal. You and I arrived at the same conclusion about the problem with the bill. So basically, everybody has agreed at one point or another in this conversation that this amendment will dramatically improve the legislation. Now, I don't think in a fit of pique towards Mr. Goldman, you should oppose the legislation that you wrote. You wrote this amendment. You were about to oppose the amendment that you wrote in front of the entire country. And I hope it hasn't gotten to be that bad. Thank you for yielding.
Okay, well, let's start. I was mollifying concerns. I think the language was pretty clear, but if there was any doubt in the first instance of whether it was something assigned to the officer or something just randomly in inventory, I think the language was clear. I did tell you I thought the language was clear. I may have pejoratively said you refused to diagram the sentence, and I apologize for that.
I love diagramming sentences, but I think you diagrammed it well. Yeah.
So the other thing here is, okay, the instance of the grenades. There is some concern there, but the reality is federal officers aren't issued grenades. You don't take the grenade home and keep it in your glove box. Like, these are things that are issued. So even though I knew your example was somewhat ludicrous, that a federal officer be issued a grenade, these are not Army officers we're talking about. We're talking about law enforcement officers, okay? So I thought, well, if Raskin thinks they're issued hand grenades to take home in the glove box, let's take care of that concern. But that's not the way it works. And then you're like, this is a free transaction. It's actually not. You may have gained something in this amendment that I didn't mean to give up, or that I didn't want to give up.
For claiming my time, what if I put a balanced budget amendment in there, and would I get Mr. Massey's support back?
No, that's a fake fight. I vote against the balanced budget amendment. Because I mean, you could go back and look in the record. I think I voted.
Belongs to the gentleman from Florida. The gentleman from Florida yields to the gentleman from Kentucky.
So anyways, there's also the question of, and I'll tell you one reason I'm not going to vote for the amendment. When you throw all NFA items in there, you may be including suppressors, which are legitimate, they shouldn't be categorized as weapons, but they may be under the NFA Act, and those are typically paired with the firearm. If an officer has carried a firearm with a suppressor on it, then it wouldn't really make sense to divorce those two items, but yet you may have accomplished that in this amendment, in the amendment that I wrote. So it wasn't a free transaction. Something was given up here, and that's why I'll vote against it.
Time has expired.
Given up in exchange for a vote, which is not, has been revoked.
Mr. Chairman?
The gentleman from New York is recognized.
Move to strike the last word.
Gentleman's recognized.
I yield to Mr. Raskin.
Thank you, Mr. Nadler. I will continue to stand up for the Massey Compromise, even if Mr. Massey will not. And so I urge everybody to vote for this amendment.
And reclaiming my time, I do the same. I yield back.
Gentleman yields back.
May I be recognized briefly?
The gentleman.
You up, Jasmine?
I think so.
Gentlelady is recognized to yield to the gentleman from New York.
Mr. Massey, I thank you because you yielded to me, right? Okay, good. I thank you because right now it seems like we can't work together on anything. And so the fact that you put forth the effort, it matters to me even though I wasn't engaged in this conversation. If you would, for me, just riddle me this. Do you understand that we have fears that say someone could retire as a law enforcement officer today and on tomorrow could go and commit some heinous crime or some crime that would prevent them from being able to walk into a store and buy a firearm? It's the reason that the gun show loophole is a big deal for us. And so do you understand that we understand that anything can happen on any given day? I'm asking. If you don't want to answer, it's okay.
Oh, no, I'd love to answer. If it's a heinous crime, they should be in prison. If it's a notorious crime, the federal agency would know that, and it would be on its face ridiculous to issue that firearm to them. They are now then a prohibited person, okay? So just because they don't undergo a background check doesn't mean you're not breaking the law if you give that person a weapon. You are, in fact, breaking the law. The federal agency would not be issuing a firearm to somebody who's broken the law, or they would be in violation of the law as well. Regardless of the background check. Now I yield back to you.
Thank you so much. So one of the things that we used to have to deal with, more so on the state level in Texas, is that someone would get arrested for an offense, whether it's domestic violence or whether it's something that is a felony, but because they had not been found guilty, the judges oftentimes would have to issue an order telling them to give up their firearms, list all their firearms, and it was really difficult to enforce that order because you're relying on a person who's just been incarcerated. And I personally know of a number of cases where someone would say arrested for domestic violence. They then end up getting out. They did not turn in their firearms, and then they go out and they do something like the murder-suicide situation. So I guess my question is more so, what is the problem with a guardrail that you see? And is there another way that we could categorize the guardrail that would be amenable, such as there is no other law that prevents or precludes the officer from possessing a firearm, so that we could maybe have an enhancement if for some reason that officer, say, did end up catching a case and they caught the case in some other state and law enforcement was unaware. This isn't a background check, so it wouldn't be anything that would prevent them, but it would allow for the potential of an increased penalty if for some reason they should not have been allowed to possess that firearm. Would you be amenable to any language like that? It still would allow them to go, they could still go get the gun.
Gentlelady yields.
I'm just trying,
Yeah,
because you're the only person that I've seen, honestly, since I've been in Congress, that is trying to work. And so I want to work. That's it.
Yeah, I don't think we need to go modify federal statutes that are already clear that say it's a crime if you give a prohibited person a firearm. It's a crime to receive it, it's a crime to give it, and a federal law enforcement agency is not going to be committing crimes. They're just not. If we can't trust a federal law enforcement agency with the discernment to not give out guns to former federal officers who've committed crimes, which is a completely hypothetical situation, then we got bigger problems. And I yield back.
You want the remainder?
Gentlelady.
I yield.
Yield back or yield to the gentleman from New York?
Thank you, Mr. Chairman. My concern is a little bit different than my colleague from Texas, because I tend to agree that the likelihood of someone committing a heinous crime and then purchasing a firearm from their agency is very low. What I am concerned about, and I would love for my colleague from Kansas to address this, I'm concerned about domestic violence. Domestic violence is something that does not always lead to a conviction, but oftentimes will lead to an order of protection, and in many states prohibits someone from purchasing a gun because of the danger to the domestic partner. And I think I just want to be clear that that is the derivation of my personal concern, that I think the statistics show that there are, as with any sector of the population, a portion of retired federal law enforcement officers who would be prohibited from purchasing guns because of domestic violence incidents. And that may not be known by the agency, but would, I think, be very problematic. And so, just so the record is clear, Mr. Massey, that's where my concern stems from.
Let me guess. If I modify my amendment to address domestic violence, you will vote for this until I offer the amendment, and then at which point you'll have another concern, and then I have to withdraw the amendment.
I tell you right
Raskin
now,
will offer
if you add domestic violence, I will vote for the amendment and I will vote for the underlying bill.
So, fool me once, shame on you. Fool me twice, shame on me. I've fallen for it twice. I won't do it a third time. I hope the public sees that I've tried to work in good faith here. There's an infinite number of concerns. There are all these scenarios that are being dreamed up on the other side of the aisle, which basically have to imagine that federal agencies are not trustworthy and that former federal officers aren't either.
I reclaim my time.
Back. Yes.
I reclaim my time. I want to be really clear. That's not what I'm saying. I agree with you that if somebody commits a crime and then tries to buy a firearm from an agency, that the agency's not going to allow it. That's not my concern. But there is data that shows that retired officers do engage in domestic violence incidents, which would prohibit them from purchasing firearms if there were a background check. This is not a hypothetical. This is real. There's data on this. And I want to just ground this conversation in the data, but that is my concern. And given that there's no time limit within which a federal officer can purchase a his or her own firearm from the agency, and the fact that an order of protection would not necessarily be known by the agency, that is why that 6-month time limit was originally very important to me when I was under the misimpression that it applied, and that is what my concern is without having a background check. As I said, if you want to address domestic violence, which I think would be the vast majority of circumstances when an officer would otherwise be prohibited from buying a gun in any state, I am happy to support this amendment, and I give you and the American people my word that I will vote for the underlying bill.
Will the gentleman yield?
Yes.
The distinguished gentleman from Kentucky implies that he's somehow like Charlie Brown, and you keep on pulling the football away from him every time he's about to kick a field goal. In fact, we never had a hearing on this bill, so this markup session has become a hearing. But here's the bottom line, Mr. Massey. We had a deal in committee last Congress. It passed by voice vote, unanimously as far as I can tell. Everybody supported it, and then it was tanked on the floor with all of these amendments, which riddled it with loopholes. And now we're discovering what the public safety consequences are of those loopholes, and you did, at least briefly during this hearing, recognize them, and you agreed to change the language, and yet you seem to be more invested in your spat with Mr. Goldman as opposed to advancing public policy here. Let's pass my amendment, which used to be your amendment, which everybody can agree to, and let's make this better legislation. I yield back.
Gentleman's time has expired. Is there further discussion on the amendment by Mr. Raskin?
I think I would, somebody.
Does Mr. Knott?
I yield to Mr. Massey.
I would just point out that even Mr. Goldman is not satisfied that your amendment goes far enough at this point.
Reclaiming. I yield back.
Gentleman yields back. The gentleman from Georgia is recognized.
Thank you, Mr. Chairman. I rise in support of the Raskin amendment, but I would again point out the fact that, law enforcement is a brotherhood. They protect each other. When one has a problem, say alcoholism, or, somebody gets a call from the wife of an officer calling his supervisor saying, my husband just assaulted me. And, or an officer could be undergoing PTSD and experiencing trauma that causes them to act out on the job. And because law enforcement is a brotherhood, the agency allows that officer who's having trouble to resign in lieu of termination. Or that officer could have even more pressing issues like the use of excessive force repeatedly, or maybe even theft of government property, some kind of issue involving the criminal law, but yet the brotherhood, in an effort to protect that officer, one of the brothers, allows that officer to resign in lieu of termination. Well, that officer, when he or she resigns, is in good status with the agency, and under this legislation, they would be able to purchase their firearm. And I don't know why we're treating firearms like, say, police dogs, when you have a police dog that is assigned to you, and you and that dog work together over the years, and then you retire, and you have a relationship with this dog, and you want to take that dog. We all understand that, but how can you have a relationship with a firearm? Apparently some folks do, and that's what gives rise to this legislation. And, because it potentially puts a loving firearm in the hand of someone who is not so loving, I'm going to be voting against this legislation, but I think the amendment makes the legislation a little better, so I'll be supporting the amendment. And with that, along with my condolences to the many officers who are forced to retire with no way of being able to connect with that precious firearm that they have lived with for, 10, 12 years. My condolences to them. Thank you, and I yield back.
Gentleman yields back. Question occurs on the amendment offered by the ranking member. All those in favor say aye.
Aye.
Those opposed, no.
No.
In the opinion of the chair, the noes have it.
Could we have a recorded vote, please?
The sponsor asked for a recorded vote. The clerk call the roll.
Mr. Jordan?
No.
Mr. Jordan votes no. Mr. Issa? Mr. Biggs? Mr. McClintock? Mr. McClintock votes no. Mr. Tiffany? Mr. Massey?
No.
Mr. Massey votes no. Mr. Roy? Mr. Roy votes no. Mr. Fitzgerald? Mr. Fitzgerald votes no. Mr. Klein? Mr. Klein votes no. Mr. Gooden? Mr. Van Drew? Mr. Nels? Mr. Moore? Mr. Moore votes no. Mr. Kiley? Ms. Hageman? Ms. Lee? Mr. Hunt? Mr. Fry? Mr. Fry votes no. Mr. Grothman? Mr. Grothman votes no. Mr. Knott? Mr. Knott votes no. Mr. Harris? Mr. Harris votes no. Mr. Onder? Mr. Onder votes no. Mr. Schmidt? Mr. Gill? Mr. Baumgardner? Mr. Baumgardner votes no. Mr. Raskin?
Aye.
Mr. Raskin votes aye. Mr. Nadler? Mr. Nadler votes aye. Ms. Lofgren? Mr. Cohen? Mr. Johnson? Mr. Johnson votes aye. Mr. Swalwell? Mr. Liu? Ms. Jayapal? Mr. Correa? Ms. Scanlon? Ms. Scanlon votes aye. Mr. Neguse? Ms. McBath? Ms. Ross? Ms. Ross votes aye. Ms. Ballant? Mr. Garcia? Ms. Kamlager-Dove? Mr. Moskowitz? Mr. Moskowitz votes aye. Mr. Goldman? Mr. Goldman votes aye. Ms. Crockett? Ms. Crockett votes aye. Ms. Ballant, you are not recorded. Ms. Ballant votes aye. Mr. Van Drew, you are not recorded. Mr. Van Drew votes no. Ms. Hageman, you are not recorded. Ms. Hageman votes no. Mr. Chairman, there are 9 ayes and 15 noes.
The amendment is not adopted. Question now occurs on the adoption of the amendment in the nature of a substitute. This will be followed immediately by a vote on reporting the bill. All those in favor say aye. Aye. Those opposed, no.
No.
In the opinion of the chair, as the ayes have it, the amendment in the nature of a substitute is adopted. The question is on favorably reporting the bill. All those in favor say aye. Aye. Those opposed, no.
No.
The ayes have it, and the bill is ordered to be reported favorably to the House. Members will have 2 days to submit views.
We have a recorded vote, Mr. Chairman.
Recorded vote requested by the ranking member. The clerk will call the roll.
Mr. Jordan?
Yes.
Mr. Jordan votes yes. Mr. Issa? Mr. Biggs? Mr. McClintock? Mr. McClintock votes aye. Mr. Tiffany? Mr. Massey? Mr. Massey votes aye. Mr. Roy? Mr. Fitzgerald? Mr. Klein? Mr. Klein votes aye. Mr. Gooden? Mr. Van Drew? Mr. Nels? Mr. Moore? Mr. Moore votes yes. Mr. Kiley? Ms. Hageman?
I think we'll go to Massey's next bill.
Ms. Lee? Mr. Hunt? Mr. Fry? Mr. Fry votes aye. Mr. Grothman? Mr. Grothman votes aye. Mr. Knott? Mr. Knott votes aye. Mr. Harris? Mr. Harris votes aye. Mr. Onder? Mr. Onder votes aye. Mr. Schmidt? Mr. Gill? Mr. Baumgardner? Mr. Baumgardner votes aye. Mr. Raskin?
No.
Mr. Raskin votes no. Mr. Nadler? Mr. Nadler votes no. Ms. Lofgren? Mr. Cohen? Mr. Johnson? Mr. Johnson votes no. Mr. Swalwell? Mr. Liu? Ms. Jayapal? Mr. Correa? Ms. Scanlon? Ms. Scanlon votes no. Mr. Neguse? Ms. McBath? Ms. McBath votes no. Ms. Ross? Ms. Ross votes no. Ms. Ballant? Ms. Ballant votes no. Mr. Garcia? Ms. Kamlager-Dove? Mr. Moskowitz. Mr. Goldman. Mr. Goldman votes no. Ms. Crockett. Ms. Crockett votes no. Mr. Van Drew, you are not recorded. Mr. Van Drew votes yes. Ms. Hageman, you are not recorded. Ms. Hageman votes yes. Mr. Roy, you're not recorded. Mr. Roy votes yes.
The clerk will report.
Mr. Chairman, there are 14 ayes and 9 noes.
The ayes have it, and the bill is ordered to be reported favorably to the House. Members will have 2 days to submit views. Without objection, the bill will be reported as a single amendment in the nature of a substitute incorporating all adopted amendments, and staff is authorized to make technical and conforming changes. Pursuant to notice, I call up H.R. 2267, the NICS Data Reporting Act, for purposes of markup, and move the committee report it favorably to the House. The clerk will report the bill.
H.R. 2267.
Without objection, the bill is will be considered as read and open for amendment at any point. The chair now recognizes the gentleman from Kentucky, Mr. Massey, for his opening statement.
Thank you, Mr. Chairman. The NICS Data Reporting Act is a simple and straightforward piece of legislation that many of our colleagues here today have voted for on both sides of the aisle. It simply requires the Attorney General to submit to Congress a report that includes the demographic data that they already collect when they do the background check. They collect this data on 4473s, such as race. And, you know, when in sales, they say when you've got the sale, quit selling. And so I don't want to oversell this, because this is the identical language that we've all voted on before, but it did pass as an amendment to a bill introduced by Mr. Nadler. These were the golden days when we worked in bipartisan fashion, and I offered an amendment, and we got this done on and that bill actually passed the floor of the House. So it was a Democrat bill. You all incorporated my amendment, and it passed the floor of the House. Then, last Congress, this committee also unanimously reported this bill out. And hopefully we can advance it out of this committee now. Let me tell you what the bill does, or the concern that we have and what I'm trying to address. And Mr. Ivey spoke to this last Congress. He shared the concern. It was actually our late colleague, Ms. Jackson Lee, who also shared this concern with me and spoke for this bill. Here's the concern. When you undergo a NICS background check, if you have a name and or birthday that's similar to somebody who's been convicted of a crime, a disqualifying crime for firearms ownership, you could be falsely denied. Now, this happens, we understand, but we estimate that it happens 3 times more frequently for blacks and twice as frequently for Hispanics, because within ethnic and racial groups, you share first names and surnames as well. And there is a large population of blacks that is incarcerated or has committed crimes and have been convicted, and because they share these names. And by the way, probably, I'll say this from my side of the aisle, over-incarcerated. And so it's not fair. It's built into the system and it needs to be fixed, but to fix something, we need to see the data. And that's what this would do. This would require publishing the data so that we can all look at it and see what happens. Because once you're denied, your options for owning a firearm are to go to somebody else, not through a background check. It's the only way you can do it. If on appeal you don't succeed, and if on first appeal you don't succeed, you have to hire lawyers, it becomes expensive, and you may be deprived of your Second Amendment rights simply because you had a surname and a first name that were similar to somebody who was incarcerated or had been convicted. So hopefully, hope to get this passed out of here without much debate or discussion. I want you to note that in the bill, it asks for the ATF to report sex and gender. Now, this isn't because I've gone woke. It's because the ATF used to ask for sex and then they changed it to gender, or vice versa on the form. And so we need to know that data. There were some conservative groups who were concerned that I'm asking for sex and gender for some liberal reasons, but maybe I just took a reason away for you all to vote for it. But the reality is, on the form, it changed from sex to gender or gender to sex, and we need to collect that information. Also, we're not asking for more information to be collected on the Form 4473 when you undergo a background check. We're just asking for them to report the data that they already collect, and we're not asking for personally identifiable information. This is not to create a registry. We just want to know to what degree this is a problem. And so with that, I urge my colleagues to support this bill, and I yield back.
Gentleman goes back. The chair now recognizes the ranking member, Mr. Raskin, for an opening statement.
Thank you, Mr. Chairman. To prove to my friend that bipartisanship is not dead and the spirit of common ground, common sense legislation still works, I will support the NICS Data Reporting Act and recommend that we all support it. I do have this question after your interesting preface to filing it, Mr. Massey. Do you think the Attorney General will even be allowed to write the report that you're talking about? Will she be allowed to publish it? Given the war on so-called DEI and race and gender discussion and description, because, I've got constituents who are being fired for reasons like this. I had one constituent, her job was to assemble patient pools for drug cancer tests, and one sentence in her job description said, and to do outreach to diverse constituencies in order to make sure that there was a cross-section of patients being tested, and she was fired as a DEI employee. So those words are radioactive now in the administration, and I'm just wondering, what the practical effect will be. And you seem to gesture at this a little bit. You hastened to assure everybody you hadn't gone woke, but you still thought it was important for us to get this information. I don't think that we should ever be afraid of information or facts or data. Despite the full-blown war that is taking place against facts and data at the National Weather Service, at NOAA, at the NIH, and throughout at the EPA, the Department of Agriculture, throughout the government. So I'm asking with all seriousness whether you think the Attorney General would even comply with what it is you're asking them to do. And I don't know if it's appropriate in my opening statement to be able to yield to you, but I would yield to you.
No, it's not. The gentleman is recognized for an opening statement.
Okay. So therefore, but I agree with it. I think that the political perils of the gentleman from Kentucky's amendment demonstrate what a serious situation we're in America right now, where it seems like certain words have become forbidden or illegal. The Associated Press was banned from certain parts of the White House because they dared to call the Gulf of Mexico the Gulf of Mexico. And there's some other real bad words out there now under the Trump-Musk regime, including equity and diversity, and I think women, gender. But I have some constituents, Mr. Chairman, who are in the military service in Germany, and they were sent a memo, which I actually showed in this committee, saying that the school libraries for the kids of military families would be closed for 7 to 10 days in order to make sure that the books and the learning materials in the libraries conform to the new executive order against equity ideology. I thought the Declaration of Independence was equity ideology. I thought that was the whole premise of American democracy, that all of us are created equal. But in any event, that seems to be a basis now for purging books from the library in complete violation of the First Amendment, a special insult to the people who are serving us all over the world. So in any event, I just have that question. I hope at some point Mr. Massey will be able to answer it, because he's moved perilously close to committing a thought crime under the new Trump administration simply by asking the question of what the racial effects and the gender effects are of particular legislation. Having said that, I'm happy to support it, and I hope all our colleagues will.
Without objection, the gentleman yields back. Without objection, all other opening statements be included in the record. Chair now recognizes the gentleman from Kentucky to offer an amendment in the nature of a substitute.
I offer the amendment in the nature of substitute.
Okay. Clerk will report the amendment.
Amendment in the nature of a substitute to H.R. 2267, offered by Mr.
Without
Massey.
objection, the amendment in the nature of a substitute will be considered as read and shall be considered base text for the purposes of amendment. The chair now recognizes the gentleman from Kentucky to explain his amendment.
So, as I said before, it's a very simple bill. We're just asking the the FBI and DOJ to report the statistics that are collected on the Form 4473 to basically quantify the degree of racial disparity that may result in these NICS background checks. And that's as simple as it is. It's passed before, it's passed here unanimously twice out of this committee, passed on the floor once. I urge support for it. And to answer Mr. Raskin's question in his opening statement, we always have a problem with the administration, whether it's Republican or Democrat, getting them to respond to Congress. And if they do, I expect this administration to follow the law. And if they are tardy in giving this report to us, when the Attorney General comes to this committee to testify, it'll be the first question I ask if it's not been submitted to us, this report. And I yield back.
Gentleman yields back. Is there further discussion on the amendment? Mr. Johnson.
Yeah, I mean, on its face, the legislation seems innocuous, but I'm just wondering, why is it necessary? What is going to be accomplished?
Here's the gentleman.
Yes, I will.
Allow me to answer a question. I'm concerned that there are inaccuracies in the NICS database, the way it works. For instance, if you have your name is spelled phonetically, if your name is phonetically similar to somebody in the database, it will catch you, it will flag you. If your birthday is similar, not exact, and if you did this, let's say you were hiring bank tellers at a bank, and you had a background check system that ended up flagging 3 times as many people inappropriately of a certain race versus another race, you would be sued out of existence. But the federal government can get away with this. And what I would prefer to see is, if we're going to have a background check system, that it work accurately, that it deprive those who shouldn't be allowed to have a firearm, but it doesn't deprive those who should be.
Does the gentleman believe that that is a very persistent problem today?
This idea came from somebody I know who worked at the DOJ, was not able to publish data, but could see it there as well. And
that person believes that there's just a horde of people who should be eligible to purchase a firearm, but were rendered ineligible due to a deficient background check.
We do have a GAO report on this, and in 2017, there were 112,000 denials and only 12 federal prosecutions, even though the ATF referred thousands of those for investigation. So it's clear there are a lot of false denials. Now, they can be appealed, but it's a tiered appeal process. And if you don't get a remedy in the first appeal, it starts becoming expensive. So it does exist, and it happens thousands, tens of thousands of times every year. There are false denials, and those denials, I believe, have a racial disparity that's built in.
Does this legislation call for the disclosure of false denials?
Yes. It would disclose denials, and then appeals.
False denials.
You will know the false denials when you see the number of appeals that are granted.
So the answer is no.
No, they will have to report how many initial denials by race. Then they will have to report on appeal how many were denied and subsequent denials. If you, for instance, have 100,000 denials and 50,000 are appealed and overturned, then those were false denials.
Well, I don't see any language in the bill that would call for a disclosure of false denials, just demographic data on all denials.
Correct. I'm working in good faith here, and I think I want to explain, if somebody appealed their conviction and the appeal was granted and the conviction was overturned, I would characterize that as a false conviction. And so that's how we'll know false denials by race, because if it was a legitimate denial, the appeal wouldn't have been granted.
So this legislation also calls for the identification of the person who was denied. Does it call for personally?
No, there would be no personal identification.
Just broad categories of folks denied. And so if it should occur, if it should appear after this legislation is passed and reports are submitted that there were more, let's say, black people in the country, or people who are identified as being black, than whites, then what would you do with that information? What would that information mean?
You would try to improve the system. And instead of using phonetically similar names, you would use exact spellings. Instead of using approximate birthdays, you would try to use accurate birthdays. You would do what they would do in the private sector, which is to try to make sure you don't falsely deny somebody and that their system isn't set up to biased for race or ethnicity.
Gentleman's time has expired. Further discussion on the amendment, Mr. Vandrew.
Thank you. And I'm going to be guilty of the same sin I guess the ranking member was, because I want to say I support the legislation. I'm not sure why anybody would not. But he then went on a tirade about equity and equality. And I had two choices. One was to sit there and just listen. I don't want the few people that happen to be watching this still, to think that means that we agree or we don't have an answer. So to answer Mr. Raskin, the ranking member, there is a difference between equity and equality. Equality, we are absolutely granted in the United States of America. It means that you have the chance to compete, that you are given equal access, that you, if you work as hard or are as smart or do as much, or whatever the case may be, that you have that opportunity. It should be a nation of equality, and when we are not, we have to fight to make sure that we do get to that point. Equity means you get the same result. Regardless of what you have, what you do, you're just going to always get the same result. That isn't life. That isn't the way it works. And what's happened is, especially in government and in education, and even spread to the private sector as well, every department, every agency, every division was hiring not always based on the best, the brightest, the most focused and talented, but on this artificial construct, this mechanism that we had to have all different kinds of balance. And not even sure what the balance meant. You know, I'm going to tell a story. I'm not making this up. You're not going to believe it, but a nurse and a midwife in my state, in the state of New Jersey, this is a state law, let me be clear, it's not a federal law, contacted my office, and they sent over a form that's given to parents with a newborn. This is a newborn. The baby's just born. For anybody that has children, you can relate to this. Your baby's born, you're there, husband and wife, whatever the case may be, and that baby's born. They ask if the baby is transgender. They ask if the baby is lesbian, LGBTQ+, heterosexual, and questions along those lines that are in depth. A little baby, you can't, they're trying to be so woke and so perfect. I couldn't believe that they asked those questions of parents when they have a newborn, and it wasn't for the parents, it was for the newborn baby. How do you know that with a newborn baby? This is crazy stuff. This all gets classified under crazy and too extreme. And American people don't like it and they don't believe it. So there are a small percentage of people that think that we want to completely restructure America in this way. It doesn't make sense. And that doesn't mean that we should do anything harmful to people that are different. It doesn't mean that these people don't have a right to succeed as well. It simply means that we all compete together, and then you let the chips fall where they may, that the best rises to the top, regardless of race or color or creed. We had it in our transportation, we had it in the EPA, we had it in, like I said, every division, agency, department. I mean, it was unbelievable. And guess what, folks? It costs billions upon billions of dollars to do that. Billions that don't go for better education, billions that don't go for more schools, billions that don't go to help veterans, billions that don't go to help senior citizens on nonsense. It doesn't make sense. And that's what I want to say back to the ranking member. It's not a desire to take freedom away. It's just a desire to return to some level of normal. That's all it is. With that, I yield back.
Gentleman yields back to further discussion. Gentlelady from Wyoming is recognized.
Thank you. I yield my time to the gentleman from Kentucky, Mr. Massey.
I thank the gentlelady from Wyoming. In response to the gentleman from Georgia's question, how prevalent it is, there were 22,615 appeals challenging a NICS denial with the FBI. This was in 2023. Of those appeals, 6,263 resulted in a denial being overturned. And so it's happened at least 6,263 times in a year. And the way, when we go look at the initial denials, and then you look at the ones that were overturned, and you go in and separate that by race, if you find out that there were more denials overturned for people within a certain race, then we can infer things from that. And the first denial, 93% of denials are dropped because you do a paperwork check, and then they find out it was a false denial, which results in, there's no lawyers involved. But if that first paperwork check doesn't fix it for you, and by the way, some people may just walk away and not exercise their Second Amendment on that first denial, but another 2% are dropped at the regional offices. They just do an additional check. If we just compared the race and sex of those who are initially denied with the race and sex of those cases that have been dropped at each of those first two stages, then we can from that divine whether this process of the NICS database process has a problem that results in a racial disparity. And I yield back to the gentlelady from Wyoming.
Would the gentlelady yield for a question?
Yes.
Thank you. Does the legislation call for the reason for the denial to be listed along with the demographic information requested?
If the gentlelady would yield to me to answer. They already disclose NICS data by category. The problem is they don't include race within that. So, for instance, some of the categories could be a fugitive from justice, misdemeanor, crime of domestic violence, illegal alien, dishonorable discharge. We have that data, but we don't have it. We don't have the racial data.
Would you be able to link it to the information provided under this legislation?
This just asks them to report the race, sex, and whatnot by category. Not like you couldn't go in and divine something from the Form 4473 to get personally identifiable information.
Mm-hmm. Seems like it would be sensible to know the basis for the denial along with this other information that is sought under this legislation.
Yeah, we can, getting a report from them is the first part. We could work with them to get that report with the FBI.
Well, why don't we amend the legislation
we can't,
to provide for the disclosure of the reason why the...
I'm open to your amendment.
And I'd certainly support that amendment.
If we could do that on the floor, or if you want to offer an amendment right now, we could do it, but maybe you want some time to think about what it would be.
Okay, well, I'd love to work with you as
Okay.
this legislation proceeds to the floor.
There would be nothing more disappointing to me than to get this bill passed, get the president to sign it, and then to get a report that doesn't give us the information that we need. So if you have ideas for improving it, I would absolutely be open to that.
Thank you.
Thank you. And I yield back to gentlelady from Wyoming.
Thank you. I yield back.
Gentlelady yields back. Is there further discussion? Gentleman from Texas, I recognize.
I'm just going to speak very briefly in support of my friend from Kentucky's bill. I think it is important. I'm glad there's bipartisan support for it. I would note, similar to my friend from New Jersey, the extraordinary difference in what is attempted to being done here, contra the ranking member's assertion. This is focused on ensuring that the power of government is not being used against its citizenry for, in this case, reasons that would be inappropriate. And I think that's a real core distinction. We can have our debates about DEI all day long, but debates about what the executive orders about the president, what we're doing on DEI, I agree with the president's executive orders. That's trying to pare back discriminatory practice, in our view. But all this is doing is simply saying where the power of the government is at its zenith to be used against the people, to deny them a fundamental right that is enshrined in the Constitution, that we ought to be mindful of how it's being used, collect the data, again, follow the truth wherever it may lead. Let's get the facts. I support the bill. I yield back.
Gentleman yields back. Is there further discussion? Seeing none, the question is on the adoption of the amendment in the nature of a substitute. This will be followed immediately by a vote on reporting the bill. Those in favor say aye. Those opposed say no. The opinion of the chair is the ayes have it, and the amendment in the nature of a substitute is adopted. The question is on favorably reporting the bill as amended. Those in favor say aye. Aye. Those opposed say no. The ayes have it, and the bill is ordered to be reported favorably to the House. Members will have 2 days to submit views. Without objection, the bill be reported as a single amendment in the nature of a substitute, incorporating all adopted amendments, and staff is authorized to make technical and conforming changes. Chair understands that votes are about to be called on the floor, and therefore the committee will stand in recess.
Get done tonight.
I think we'll make it through tonight. We won't be that one.
Yeah. Committee will come to order pursuant to notice. I call up H.R. 38, the Constitutional Concealed Carry Reciprocity Act for purpose of markup. Move that the committee report it favorably to the House. The clerk will report the bill.
H.R. 38 to amend.
Without objection, the bill will be considered as read and open for amendment. The chair is recognized for an opening statement. Our First Amendment rights do not change from one state to another, and our Second Amendment rights should not either. Law-abiding citizens should be able to carry a concealed firearm between states without worrying about conflicting state criminal laws or onerous civil suits. There are over 22 million concealed carry permit holders across the country. As of February 2025, 29 states have constitutional carry or permit-less carry laws. This means that a state does not require law-abiding citizens to obtain a concealed carry permit or license before carrying a firearm outside their home. Alaska was the first state to pass such legislation in 2003, with Louisiana and South Carolina most recently enacting constitutional carry just last year. In Vermont, consistently ranked as one of the safest states in the nation, no permit has ever been required to carry a firearm outside the home. Over the past 2 decades, the Supreme Court has issued several landmark decisions that have clarified what constitutes arms under the Second Amendment and the rights that the amendment protects. In the District of Columbia versus Heller, the court held that the term militia in the Second Amendment does not limit the protection to only those serving in our military. In McDonald versus Chicago, the court in 2010 explained that the Second Amendment is, quote, fundamental to the nation's scheme of ordered liberty and deeply rooted in the nation's history and tradition, and is therefore incorporated to the states through the 14th Amendment. Most recently, in New York State Rifle and Pistol Association versus Bruin, the court held in part that the Second Amendment protects the right to carry a handgun for self-defense outside the home. Before the Bruin decision, states fell into 2 categories when an individual applied for a concealed carry permit: shall issue states and may issue states. In other words, the simple desire for self-defense and the exercise of one's Second Amendment liberties were not always enough to satisfy the requirement in may issue states. The Constitutional Concealed Carry Reciprocity Act prioritizes the rights of law-abiding citizens to carry concealed firearms and the ability to travel freely between states without worrying about conflicting state codes or onerous civil suits. Under this bill, individuals with concealed carry permits or privileges in their state would be able to exercise those rights in any other state that allows concealed carry. This bipartisan legislation protects law-abiding citizens with nationwide reciprocity for concealed carry license holders and for residents of constitutional carry states, and passed the House on a bipartisan basis in 2017. I urge my colleagues to support H.R. 38. And with that, I would yield to the ranking member for an opening statement.
Thank you very much, Chairman Jordan. I oppose this legislation, which clearly has the wrong title in every element. First of all, this is not a reciprocity act. Quite the contrary, it has nothing to do with reciprocity. It abolishes reciprocity. States that right now want to engage in reciprocity arrangements with other states for concealed carry policies have that absolute right. 29 states, as the chairman says, have enacted some form of concealed carry reciprocity, exercising their powers under the Second Amendment and the 10th Amendment to negotiate reciprocal recognition agreements with neighboring states or all of the states. 9 states have chosen not to engage in any concealed carry reciprocity arrangements at all. Other states have permitless concealed carry for everybody. It's completely up to the states. In other words, good old-fashioned federalism is working. As Mr. Van Drew put it in our earlier discussion, concealed carry, he said, quote, is an individual state-by-state thing. But this bill would abolish this voluntary reciprocity right that the states currently enjoy. Amazingly, it would substitute for the judgment and the autonomy of each state legislature to set their own standards for who may carry a concealed firearm. The standards set only by the most lenient states, some of which have absolutely no standards at all. This bill is thus not about voluntary reciprocity. It's a nationwide mandate that our colleagues would impose on every single state, forcing them to accept the public safety risk decisions of states with the most permissive and, I would say, ineffectual gun safety laws. The word constitutional also sticks out like a sore thumb here. in the title of this bill. Under the 10th Amendment and the Second Amendment, states have the police power right to choose concealed carry laws consistent with their own traditions, with American traditions and local public safety. This is the meaning of the Bruin decision in 2022 by the Supreme Court. States have exercised that power to determine for themselves who may carry a concealed firearm. For example, in my state of Maryland, we have stringent requirements around concealed carry. To get a permit, you must complete safety training, which includes instruction on self-defense, safe firearm storage, conflict de-escalation, and suicide prevention, and then you have to show that you can shoot accurately and handle a gun safely. All of that is perfectly constitutional. You must also store your firearms in accordance with Maryland's child access prevention law, and you must be at least 21. But there are 29 states that don't require a permit, don't require a background check, don't require safety training to conceal carry in most places, and some states allow people to be as young as 18 years old in order to participate. The bill before us today would allow someone who comes from one of these wide open, anything goes states to come to Maryland and carry a concealed handgun against the laws adopted by our people, by the representatives of millions of people. This nationwide straitjacket mandate makes it possible for dangerous people from one state to circumvent the laws of every state. For example, a person who cannot meet the requirements of Maryland's law, either because, say, they failed the live fire accuracy test or the background check, or because there are indicators that they're a danger to themselves or to other people, they would be able to shop around for a state and find one quickly whose standards they can meet. Then they could go anywhere. There are many states that previously required a permit to conceal carry and later dropped their permit requirement, but still issue optional permits so that permit holders can take advantage of reciprocity agreements and for other purposes. Arizona is one such state, and it makes no distinction between Arizona residents and all other U.S. citizens who apply for a concealed carry permit in Arizona. So under this legislation, a person who lives in Maryland but could not get a concealed carry permit in our state could go and get one from Arizona without ever setting foot in the state, and then suddenly be allowed to conceal carry in Maryland and every other state in the nation based on Arizona's law, even though they might have shown signs of dangerousness that disqualified them in our state. And to make this race to the bottom even more shocking, the bill specifically allows such a person to carry a concealed gun in a gun-free school zone. Understand that's what we're voting on, colleagues. It will give them the right to carry a concealed gun in a gun-free school zone, eroding not only state laws protecting school zones, but federal laws protecting students, teachers, and others in our public and private schools. The end result of all this is clear. We will be less safe. Studies have found that weak concealed carry laws are associated with a 15% increase in violent crime and 11% higher rates of homicide using handguns. Well, maybe some people don't like those studies. They've got their other studies. Fine, do it that way in your state, but don't impose it on my state. This bill would cause weak laws to have dangerous nationwide repercussions. This bill would almost certainly lead to nationwide increases in violent gun crimes and homicide, reversing the big progress we've made over the last 2 years, which Ms. McBath has talked about frequently. Given the increased public safety risks this legislation would impose on all of our states, law enforcement officers and law enforcement organizations across America are strongly opposing this legislation. So for all of those who were invoking those groups before, take note, they are against this. They know this bill would impose the lowest common denominator and drive that denominator into the sub-mezzanine basement level. If the bill were to become law, law enforcement would have to deal with even more armed individuals, and the bill restricts their ability to arrest or detain a person carrying a concealed weapon. Law enforcement officers who keep our community safe will be unable to know the permit requirements of 50 states and unable to determine whether someone is lawfully carrying, since the bill allows people to carry across state lines without any permit at all if they live in a permitless carry state. And any mistakes an officer makes in trying to enforce the law could subject that officer to a lawsuit under the bill. As a statement from 7 different law enforcement groups, including the International Association of the Chiefs of Police, the Law Enforcement Action Partnership, and the Association of Prosecuting Attorneys, says this mandate would, quote, severely erode public and officer safety and make it near impossible for law enforcement to confirm that an armed individual is carrying legally. This bill reflects a NRA agenda when it comes to public safety, more guns in more places. And if that really worked, the U.S. would be the safest place in the world for guns, but it isn't. There are about 400 million guns in our country, more guns than people, and the homicide rate here is nearly 25 times higher than other high-income countries, and the firearm suicide rate is nearly 10 times that of other similar countries. Finally, I must note that as our colleagues are advancing this dangerous legislation, the Trump administration is taking many more actions that make life easier for violent criminals. They not only pardoned more than 1,500 convicted insurrectionists, they're trying to roll back regulations designed to reduce gun trafficking and illegal gun sales. They're working to give convicted criminals the right to own a gun again. And just a few days ago, it was reported that they're going to cut as many as 1,000 agents, more than a third, from the Bureau of Alcohol, Tobacco, Firearms, or ATF. If they get their way with this legislation and these actions, we will not only have more people, including potentially convicted criminals, carrying a lot more guns in all of our states, but we're going to have drastically fewer federal agents left on the beat to investigate and prevent gun crimes. This is deadly serious. If we don't stop these policies, it will only be a matter of time before the homicide rate starts increasing as fast as the stock market is sinking. I urge my colleagues to oppose this truly dangerous legislation. I yield back to you, Chairman Jordan.
Without objection, all other opening statements will be included in the record. Chair now is recognized to offer an amendment in the nature of a substitute. The clerk will, amendment at the desk, the clerk will report.
Amendment in the nature of a
Without
substitute.
objection, the amendment in the nature of substitute will be considered as read and shall be considered base text for the purpose of the amendment. The chair is now recognized to explain the amendment. This amendment simply adds the year to the title of the bill. There is no substantive change to the bill. I urge support for the amendment and yield back. The gentleman from Arizona is recognized.
Move to strike the last word.
Gentleman is recognized.
Thank you, Mr. Chairman. So this is a bill that's important. It's good. It's solid. I want to just make some comments because if you just heard recent comments from my friend across the aisle, you would think that this bill has nothing to do with federal land and law either, but it does. On page 4, talks about federal parks and lands and provides options or opportunities to carry there as well. But I have to speak as someone who has actually taken the classes in Arizona to become a certified concealed carry. You have to take the class where you learn about safety, care, and you actually shoot the weapon. You got to do that to become licensed to carry a concealed weapon in Arizona. You got to. But Arizona has another option. It is a constitutional carry state. That's the distinction, so because we believe that the Second Amendment extends to everyone in Arizona. But if you are a prohibited user, which Arizona does have prohibitions on carrying in certain places, you can't carry, you can't buy, you can't sell. But otherwise, we've got a constitutional carry. But I believe the gentleman sadly misunderstood Arizona's concealed weapon certification. And why did they keep that, even though you had constitutional carry? We kept it because we wanted to be able to get reciprocity in certain states. So if that was one of your deals and you wanted to carry in another state, you could apply and get reciprocity. That's why there's multiple avenues in Arizona. So, sorry, I think you were just a little bit off on that. I understand it. Might have been a little bit Byzantine to understand. With that, Mr. Chairman, I support this bill. And
will the gentleman yield for a friendly question?
A friendly question, sure. Now, I've walked down that aisle before.
Well, my friend, the question is this. Let's say someone doesn't qualify in Arizona and that they don't qualify at the shooting range or they failed the Arizona background check. Do you think they should be able to go find one of these other states that have lower standards than Arizona, get qualified, and then come back to Arizona after you've already rejected them?
Well, if they are not a prohibited user, they're going to start carrying constitutional carry, which we allow. And by the way, yeah, you can go either way, and so yeah, they're going to be able to carry concealed.
Okay.
So they're not. They're not going to leave the state, my friend, if they don't qualify to get the avenue, the certification for carried concealed weapon. They're not going to leave the state. What they're going to do is they're going to apply. They're basically going to. They're just going to start carrying, because we have open carry, we got constitutional carry.
Okay, then I misunderstood your original statement. I thought you were saying that not anybody could do it. But so I had chosen Arizona, but maybe I got it wrong on the theory that somebody could be rejected in Maryland and then they could get certified in Arizona and then come back to our state after we've already not qualified them. Is Arizona not one of those states that would do that?
No, I mean, if you came in from Maryland and you wanted to carry, you could carry in Arizona, right? You could, but if you want to obtain reciprocity under current laws, you would apply, and you might not get your concealed weapon.
No, I got you, but I guess that my basic problem is that there are people who would be rejected in Maryland who can find another state that would qualify them, that have basically an open policy, and then they could come back to our state having failed our test.
But if they're living under constitutional carry law in Arizona, that doesn't mean that they're going to get reciprocity in any other state necessarily, although some states do allow reciprocity.
I thought that was the whole point of this bill. Isn't the bill to say
that's the bill. That's
Okay.
you were trying to argue something as if it currently exists.
No, I was
that
saying,
would be erroneous, because that isn't the way Arizona.
Then I stand corrected. All I was saying, if this bill passes, somebody could go to a state with the most lax laws in the country, get certified there for concealed carry, and then they'd be able to come back to our state. I think that's the whole purpose of the bill, is to override the states that have a more stringent test. And I think that's a major assault on federalism.
I think that the purpose of the bill is to recognize Second Amendment rights don't have boundaries.
Right. Gentleman's time has expired. Who seeks recognition? The gentlelady from Georgia.
Thank you, Mr. Chair. Mr. Chairman, H.R. 38, the Constitutional Concealed Carry Reciprocity Act, would make every one of our communities less safe. This bill forces states to accept the concealed carry standards of every other state. States that have strong concealed carry laws will be forced to suddenly have many more people in their communities who were eligible to carry concealed firearms in their state, even though their duly elected state legislators had crafted laws to prevent that. This is an obvious violation of states' rights. But what about the states with more lax laws? As my colleague from Maryland had just stated, in 2022, my state of Georgia removed its requirement that people who want to carry a concealed firearm must get a permit. You might think that in a permitless state like Georgia, this bill would do no harm, but it would. Georgia doesn't require a permit to conceal carry, but it does require you to be at least 21 years old. Our neighboring state of South Carolina allows those who are 18 or older to concealed carry. So this legislation would lower the age limit for concealed carry in Georgia over the will of Georgia voters. And the same would be true for the 17 other states that have permitless carry but require you to be at least 21 years old. This bill would even allow more concealed guns in school zones. This is just one small example of how this bill would allow more people to carry more guns in more places, eliminating each state's right to set its own standards. Critically, this legislation is not just a violation of states' rights, it's outright dangerous. This bill would effectively move the whole country to a permitless carry by allowing those with a right to permitless carry in their state of residence to conceal carry in any other state. But we know that permitless carry is associated with increases in murder and gun assaults. One study found that states that enacted permitless carry laws experienced a 27% increase in murders for the 3 years since its enactment, compared to 10% increase in nationwide murders over the same period. Another study found that states that weakened their permitting laws experienced a 9.5% increase in gun assaults in the 10 years after weakening their standards. The evidence is absolutely clear. Lax concealed carry laws increase violent crime, including murder, so this bill would likely increase violent crime and murder nationwide. The increased risk of lives lost to gun violence should be more than enough to end the debate on this bill, but the dangers go even further. More people carrying firearms more often also means more injuries. One study found that unintentional firearm injuries rose after states weakened their permitting standards. Another study found that people who carry firearms regularly are more likely to have their firearms stolen, and those stolen guns are then more likely to be used to commit further crimes. Given these significant threats to public safety, it's no wonder that law enforcement opposes this legislation. A letter to Congress from the National Law Enforcement Partnership to Prevent Gun Violence explains that this bill would leave law enforcement helpless to keep guns out of the wrong hands when a person claims they have a right to carry a concealed gun. The letter further explains that this bill is, and I'm quoting, an obvious step in the wrong direction that would sow chaos and uncertainty, making a cop's job harder and citizens less safe, end quote. I agree with law enforcement. This bill is a step in the wrong direction. Following the passage of the Bipartisan Safer Communities Act, we had historic drops in murder and violent crime. We should be working together to build on that success, to save even more lives from gun violence, and to prevent even more families from losing a loved one the way that I lost my son 12 years ago. Every day, we lose more than 100 Americans to gun violence. More than 3,000 people have died from gun violence already this year. We must do more to make our communities safer. But this legislation will instead make all of our communities more dangerous places to live. I strongly oppose this misguided bill, and I urge my colleagues to oppose it as well.
Will the gentlelady yield when you have a second?
I yield.
My question to you, Ms. McBath, is so the good people of Georgia have said you can get a concealed carry permit at age 21, but in South Carolina, they set it at 18. So now any 18-year-old who gets a concealed carry permit in South Carolina will be able to travel to Georgia. Exactly. And the officers are saying that's a problem because they're not going to know whether to ask them or not, and they can get sued simply for allegedly violating their Second Amendment rights, although there's no Second Amendment right for an 18-year-old to have a concealed carry permit, right? And so is that why the officers are so upset?
Exactly. That is my point. So I'd like to offer unanimous consent to enter into the record this letter, this statement. It's just absolutely, I find this deplorable that we would be loosening our existing gun laws, and I just strongly oppose this piece of legislation, and I yield back.
Without objection. The gentleman from Tennessee is recognized.
Georgia. Surprised to see you at the wrestling national championships and getting a great crowd response that you got.
Yeah, thank you.
They all cheered for you.
Yeah, it was fun. Thank you.
You're welcome. I've got an amendment at the desk. Do I not have an amendment at the desk? Well, then she shouldn't have yielded. She should have put her amendment in.
She is getting recognized on the base call.
Who seeks recognition?
Ms. McMahon.
Excuse me, Mr. Chair, I have an amendment at the desk.
Gentlelady can, clerk will report.
Chairman, I reserve.
Gentleman from California reserves point of order.
Amendment to the amendment.
Without objection, the amendment will be considered as read. The gentlelady from Georgia is recognized to explain her amendment.
Mr. Chairman, my amendment would prohibit a person convicted of committing a crime against a law enforcement officer from carrying a concealed weapon under the bill. According to statistics from FBI, 79,091 officers were assaulted while performing their duties in 2023. So it comes as no surprise that so many in law enforcement oppose this bill. As 7 national law enforcement agencies noted in a letter to this committee, the legislation could create a chilling effect in instances where police have to make split-second decisions to protect others and themselves, and could deter police from taking appropriate and lawful action that may prevent someone from committing a serious and violent crime. Police officers need to be able to verify that people carrying concealed, loaded guns in public are legally allowed to carry them to keep themselves and their community safe. My amendment would at least ensure that officers don't need to worry that individuals who were previously convicted of committing a crime against law enforcement can carry a concealed weapon under this bill. I urge my colleagues to support this reasonable and important amendment to keep our law enforcement officers safe, and I yield back.
Gentleman yields back. Chair,
Mr. Chairman, I withdraw my.
gentleman from California withdraws. I oppose the amendment. Someone convicted of a felony conviction is prohibited from exercising this right and carrying a concealed firearm already. And this amendment does not take proportionality and fairness into consideration under a misdemeanor conviction. This could easily create a conflict between distinguishing either a misdemeanor assault or impersonating conviction. So for those reasons, I would oppose the amendment. Who seeks recognition? Gentleman from California is recognized.
Mr. Chairman, I would certainly want to second the comments you made about why this was poorly written, perhaps. But additionally, when it says who has not been convicted of a crime under federal, state, or tribal or local land, 20 years ago, 30 years ago, somebody may have been convicted. If they've gone through the process of having their rights restored, this, as written, this, of course, would strike that ability. So the fact is that the federal government and or a state may have restored rights for good and proper reason, and yet this amendment would, because it's overly broad, would prohibit that. So I think you have a number of reasons. The chairman cited one. I would add that one in opposition, and hope we'll strike.
Will the gentleman yield?
Of course I would yield.
I have a question, because it's my recollection that this body just voted on a bill that makes any kind of, I think it was evasion or escape from a law enforcement officer a deportable offense. And here we are talking about an actual crime against a law enforcement officer, and somehow that should not be a disqualifying event, and yet just simply evading a law enforcement officer is grounds for deportation.
I appreciate the gentleman's concern, although it really isn't germane. The fact is that a crime against a law enforcement officer is a felony. The chairman said it very well, and I added to it the possibility. But if you're concerned about immigration, I assure you, you'll have plenty of chances in this committee as we codify the president's many effective actions that have led to the streets of America being safer and the communities that I represent being safer. And with that, Mr. Chairman, I yield back.
Recognition. Gentleman from California is recognized.
Thank you, Mr. Chair. I support this amendment, and I oppose H.R. 38 for all of the reasons stated by my colleagues, and also because it is not going to keep law enforcement safe. Stevie Wonder can see that. It's not going to keep law enforcement safe. It will not bring down their anxiety. It will not give them less administrative headaches. And it is fallacious to say that this bill will make private citizens or law enforcement safer, or that any of these bills that we've discussed today will do that. The president wants to give states more authority. At least that's his argument for dismantling the Department of Education. And here you are with H.R. 38 trying to take away states' rights and the ability for law enforcement to do their job. We all here represent a district, so presumably we all know the needs of our communities. We know that they need Social Security and Medicaid and Medicare, and we know that they need their federal jobs. And we also know their safety risks, their appetite for firearm laws, the community's proclivities, and the capacity of our law enforcement agencies. And presumably, our states are making laws based on that alchemy of information. And H.R. 38 is going to turn all of that upside down. When I was in the California legislature, I was not making laws with Florida or New York in mind. I was making laws about California, and when I was making public safety laws, I was talking to our AG, our DAs, our probation officers, our sheriffs about the issues and the needs that they were dealing with, how they're operating their database, what other resources they need, what they have the capacity to do, what is allowed specific to California. And HR 38 says that none of that matters. It says that someone from another state can come into my state and say that they are governed by their state's laws in my states. That's like coming into my house and not obeying my house's rules. That is malarkey. And this is real stuff, because you're going to have people coming into your state hopped up on firearms and a bad attitude protected by the laws of their state when your state might legitimately not allow their behavior. And they can wreak all kinds of havoc because of the discrepancies in the law as it relates to firearms, the number of firearms, the types of magazines, different permits, all of that. And you are making law enforcement deal with that kind of chaos. It is going to create massive confusion for law enforcement, because states are going to have to figure out how to create a database to deal with this influx of folks who are coming in with their own ideas about their laws from their states. And we're all going to have to figure out how to reconcile those aversions. And that's just the paperwork. We're not talking about how this is going to harm officers, because that's also what's going to happen. And you're going to be tracking that in that HR 2240. I don't know about you, but when I talk to law enforcement, they say they don't want more guns on the streets. They are not okay with that. It increases their anxiety level, their stress level, it increases their calculation of danger, and they say repeatedly they care about staying alive so they can go home and be with their families. But with HR 38, law enforcement officers across the country are going to be worried about people from outside their jurisdictions coming into their town, and they have no way to really navigate the nonsense that's going to be created because of this bill. The ranker said, this is like, instead of forum shopping for the courts, you got like forum hunting because of this bill. And let me tell you something, when a law enforcement officer has to check on someone that they don't know with a gun, they have to call in another officer, 2 officers become 4, and that starts jacking up and straining that municipality's resources, because more guns do not make people safe. You know, Ronald Reagan, and I don't support nothing about Ronald Reagan really, but he was the governor of California, and he changed gun laws in our state. I don't agree with why he did it. I don't agree with what he did, but he knew his state enough to go to the legislature to address the issues of that time. And when he became president of the United States, he did not transfer California's laws to the nation. HR 38 runs completely counter to 2240. And it is gaslighting, because on the one hand, you want more guns on the street, all connected to different permits and laws and behaviors of 50 states and territories and districts, and you're essentially terrorizing law enforcement. And then on the other hand, with HR 2240, you want to track their sanity and mental health. Oppose this bill. That's how you can protect their sanity and mental health. I mean, there are no standards. And you're going to defund or dismantle DOJ and ATF, and you're going to increase the onus on these cities and counties and states because now they have to track all these people and their guns. This is an unfounded mandate, and you go tell that to your city mayors and your county supervisors and your governors.
Time.
This is about hijacking state resources and meddling with state sovereignty and getting rid of common sense, and I oppose the bill and support the amendment.
The time of the gentlelady has expired. Who seeks recognition?
If nobody else, I seek
question.
I seek recognition.
The gentleman from New York is recognized to speak on the amendment.
Thank you, Mr. Chairman. And I was disappointed not to have a more good faith colloquy with my friend from California on the, I think, hypocrisy of trying to defend law enforcement in the immigration context with non-felony crimes, but not protect law enforcement in the context of gun ownership and concealed carry. This is a very simple and I would imagine should be straightforward amendment that I'm surprised that my colleagues on the other side of the aisle who talk so much about backing the blue and supporting law enforcement think that a conviction, a non-felony conviction, which exists, so let's put felonies aside,
a non-felony conviction against a law enforcement officer should not be grounds to exclude someone from carrying a weapon to a different state. So this is only about actually transferring a weapon from a home state to a different state and overruling that different state's laws. And here we are with a very straightforward amendment that is designed to protect law enforcement. And my colleagues on the other side of the aisle, once again, are not backing the blue. They, when it's convenient, want to talk very much about how much we back the blue, and if someone flees from a law enforcement officer, they obviously should be deported, and yet if someone actually commits a crime against a law enforcement officer, totally fine for them to have a gun.
Would the gentleman yield?
Yes.
I hear the gentleman's point. The problem is, as the amendment's written, or as I read it, if one were to get into a scuffle in a bar with a tribal policeman at the casino and were convicted of a misdemeanor, you would then, under this, be prohibited from this right, even if that was simply a misdemeanor for which you served no time. So when I said that it as written was very poor, I meant it. In fairness, I didn't mean to cut you off at all. It's just that the rights under the Second Amendment guaranteed in the Constitution are very different than the complete absence of rights for a foreign terrorist who are being deported. And so I can't really conflate the two.
All right, well, I'll reclaim my time, but because obviously, you know, we like to create the hypothetical parade of horribles. Every single immigrant that comes into our country has to be a foreign terrorist. That's BS. We all know that. And the point is that you're happy to support someone running away from a law enforcement officer. That's not even a misdemeanor. They're running away from a law enforcement officer. They should be deported. And yes, somebody who assaults a police officer on tribal land and is actually convicted, either by admitting it or by being convicted of a judge or a jury, yes, too bad. You don't get to benefit from the concealed carry laws. I think that's a very legitimate and reasonable minor restriction on Second Amendment rights, of which we, of course, all acknowledge that there are far too few, but there do exist some. And I guess with that, unless any of my colleagues, I yield to the ranking member.
Thank you for those trenchant insights, Mr. Goldman. You know, the reason why we've got all these law enforcement associations, like the International Associations of Chiefs of Police and the Association of Prosecuting Attorneys, weighing in heavily against this bill is because it makes an absolute hash out of state law. So more than 30 states don't require training in order for someone to carry a concealed weapon. And that's totally their constitutional right and authority under the 10th Amendment and the Second Amendment to decide that. But other states do require training. For example, my state requires training. Well, why should my state have to accept people coming in, maybe 18 years old, who've never been trained on a gun, who got a concealed carry permit? Nobody's been able to explain, as a matter of federalism, why that's something we should do. I hear people say, because we should have national Second Amendment rights, but there's not a Second Amendment right to do it, because the Supreme Court in Bruin said that's up to the state to decide. So some states allow 18-year-olds, some allow 21-year-olds. Why won't you allow my state to do our thing without subjecting us to everybody else's law? Thank you for yielding.
Gentleman yields back. Who seeks recognition? Gentlelady from California is recognized.
Mr. Chairman, I'm persuaded by the arguments being made, and especially, our new representative in Los Angeles County, who just came from the state legislature and understands how this comes down. And in addition to listening to the police, I think it would be smart to listen to her. And I would also like to yield to the ranking member.
Thank you very kindly, Ms. Lofgren. I hope everybody takes the time to read these letters from the police officers who certainly would be supporting this amendment, although I can't say because I don't know they've seen the amendment, but at least this amendment says if you've been convicted for a crime, whether it's a felony or misdemeanor against a cop, no, you're not going to be able to get into somebody else's state with a lower certification. And God help us if one of those people does that, goes into another state and kills a cop or assaults another cop. I certainly would not want to be voting against that amendment in that case. But in any event, here's one of the things the officers are raising with this, and I'm reading it in their letters, and I recommend everybody read their letters carefully. There's no mechanism for police to verify out-of-state concealed carry permits, right? So you stop somebody who's, say, driving recklessly, and they've got a gun on them. Well, maybe that person is an 18-year-old who's got a permit from another state. Maybe they're from South Carolina. But if the individual is from a state that doesn't require a permit at all, and this is a permitless state, there may not even be a permit for law enforcement to verify in the first place. So how are they, can someone please tell me, and I'm very happy to ask, how will law enforcement verify that that person actually is a concealed carry permittee or licensee from South Carolina or another state? And the officers, they've been calling me and they're sending these letters. They're saying, how are we going to make this thing work? I mean, they're not carrying Westlaw and Lexus with them in their police car. How are they going to look up what the state law is and whether this person who claims to be a permittee really is or not? And nobody seems to be able to answer that question. There's another problem they've been raising, which is the police have to make a split-second decision now whether to check whether this person is somehow permitted or not, whether they're a licensee or not, and they can be sued if they're interfering with the very broadly articulated Second Amendment right that we're hearing from our colleagues. So this deters police in my state from taking appropriate and lawful action to prevent someone from committing a potentially serious and violent crime. And nobody's able to explain why we need to do this or how, in fact, it's going to work. So at the very least, we've got to support Ms. McBath's amendment. Someone who has been convicted, right? Ms. McBath, I'm taking, that's correct. It's not charged with, which was the standard that our colleagues were using in a lot of those immigration contexts, but somebody's been convicted. In other words, they've been indicted, they've been brought into court, they've had all the benefit of counsel and due process, and they've been convicted unanimously by a jury of their peers for assaulting a cop, for attacking a cop, and now we're saying that person's got free reign to go all over the country if they're able just to get to the right state, or if they happen to live in a state which gives them free reign there. That's a remarkable thing. I thank the gentlelady for yielding, and I yield back to you, Ms. Lofgren.
Thank you, Mr. Raskin, and with that, Mr. Chairman, I yield back.
Yields back. Who seeks recognition? Question occurs on the amendment. You want to talk about the amendment there, Bill? Amendment?
Mr. Chair. May I say something?
Gentleman from California is recognized on the amendment.
I was listening to my colleague from California and realizing how California has gotten itself into the mess it's in with the kind of thinking that we see reflected by its state legislature over the past several decades, and why such an unprecedented exodus of people voting with their feet and leaving our state is now occurring. Just a couple of quick points. First of all, states do not have rights. States have powers. Individuals have rights, and a natural right that is enshrined and protected in our Second Amendment is the right to bear arms. Now, when Americans cross state lines, they should be able to take those rights with them. That's the spirit, if not the letter, of the full faith and credit clause of the Constitution. A driver's license issued by one state is valid in another. If you drive across a state line, you shouldn't be forbidden from driving any further because your license was issued by another state. A marriage license issued by one state is valid in another. You shouldn't be separated from your spouse or your children because you were married in another state. And with respect to the comments we've been hearing about law enforcement, I would commend to the Democrats the works of Sir Robert Peel, the father of modern law enforcement, who founded the doctrines of law enforcement in free societies, that the police are merely an extension of the citizens. In his words, the citizens are the police and the police are the citizens. It's true that these doctrines are no longer recognized by the far left because they are, the left is authoritarian at its core, but, and obviously they appoint some police chiefs of like mind. But the principles are sound. I used to work for the chief of the Los Angeles Police Department, Chief Edward M. Davis. He brought crime in Los Angeles down in the 1970s, even while it was ballooning 50% nationally in the 8.5 years he was chief. He was the father of Neighborhood Watch and community-based policing and the basic car plan. And at the core of his philosophy was that there's a natural partnership between citizens and the police, and that the Second Amendment was absolutely central to that partnership. And he proved that that worked by, through his tenure, leading the LAPD through its golden age. So I think a little more of that philosophy is important, and I'll yield back.
Gentleman yields back. The gentleman is yielded back. I'm sure we can get some time. I'll be happy to get.
Mr. Chairman.
Gentleman from New York is recognized.
Move to strike last word.
Gentleman is recognized.
I yield to the gentlelady.
Gentlelady is recognized.
I had a question because the gentleman from California started talking about driver's licenses and marriage licenses. And I don't know if the gentleman is married, but I think if you get married in one state, you still have to get divorced in that same state. These things don't carry over. So states do have laws that you have to obey in that state and they don't transfer over. That's all I wanted to say. Thank you. I yield back.
I yield back.
From New York yields back. The question occurs on the amendment offered by the gentlelady from Georgia. All those in favor say aye.
Aye.
Those opposed, no. No. In the opinion of the chair, the noes have it.
We have a recorded vote, Mr. Chairman.
The ranking member requests a recorded vote. The clerk will call the roll.
Mr. Jordan?
No.
Mr. Jordan votes no. Mr. Issa? Mr. Biggs? Mr. McClintock? Mr. McClintock votes no. Mr. Tiffany? Mr. Massey? Mr. Roy? Mr. Roy votes no. Mr. Fitzgerald? Mr. Klein? Mr. Klein votes no. Mr. Gooden? Mr. Gooden votes no. Mr. Van Drew? No. Mr. Van Drew votes no. Mr. Nels? No. Mr. Nels votes no. Mr. Moore? Mr. Moore votes no. Mr. Kiley? Mr. Kiley votes no. Ms. Hageman? Ms. Lee?
Sheriff, no.
Mr. Hunt? Mr. Fry? Mr. Grothman? Mr. Knott? Mr. Harris? Mr. Onder? Mr. Onder votes no. Mr. Schmidt? Mr. Schmidt votes no. Mr. Gill? Mr. Baumgartner? Mr. Raskin? Mr. Raskin votes aye. Mr. Nadler? Mr. Nadler votes aye. Ms. Lofgren? Ms. Lofgren votes aye. Mr. Cohen? Mr. Johnson? Mr. Johnson votes aye. Mr. Swalwell? Mr. Liu? Ms. Jayapal? Mr. Correa? Ms. Scanlon? Ms. Scanlon votes aye. Mr. Neguse? Ms. McBath? Ms. McBath votes aye. Ms. Ross? Ms. Ballant? Ms. Ballant votes aye. Mr. Garcia? Mr. Garcia votes aye. Ms. Kamlager-Dove? Ms. Kamlager-Dove votes aye. Mr. Moskowitz? Mr. Goldman? Mr. Goldman votes aye. Ms. Crockett? Mr. Issa? Mr. Issa votes no. Mr. Tiffany? Mr. Tiffany votes no. Mr. Baumgartner? Mr. Baumgartner votes no.
Clerk will report.
Mr. Chairman, there are 10 ayes and 14 noes.
The amendment is not agreed to. Who seeks recognition? Gentleman from New Jersey is recognized.
Thank you, Mr. Chairman. I'm going to speak a little bit from the voice of experience here. As I mentioned earlier in the day, I have about 40 states, either through reciprocity or actually getting the permits. By the way, you want to talk about something prejudicial and wrong, you got to buy, in some states, these permits are very expensive. A lot of folks couldn't afford it. And in order to be safe and to carry, if you want to, as you travel around the country, it costs you a lot of money every year. And that in itself is unconstitutional and is wrong. You know, we hear about people carrying, and you know, in New Jersey years ago, before the Supreme Court ruling recently, it was virtually impossible to carry, virtually impossible. And I put a bill in the New Jersey legislature that would enable folks to carry in New Jersey. And I remember having a big argument with the Senate president because he said it was going to be the Wild West and it would be scary and it would be so terrible and it would be horrible. Well, guess what? They had to, in New Jersey, comply like the rest of the country to the Supreme Court ruling. And now there's a lot of folks carrying. The crime has gone down. The incidents have gone down. It isn't the Wild West. It hasn't created a problem. That's number one. You want to talk about people carrying and being concerned? Speak to your local law enforcement. Go out in the streets, and I've done this in some of the cities in my district, and you go around with them, and we'll talk about guns, and they'll say, you know that person over there, that one there, these are where the drug deals are going down, these are where you can buy an illegal firearm, and we put them in jail. It doesn't matter because the judges release them. They're out over and over and over again. We're too permissive. We let people out that have committed serious crimes too early and too easily, and it's wrong. And they are carrying. There's people carrying no matter how restrictive you are because they're carrying illegally, and that isn't good. And you encourage illegal carrying when you do that. And statistics. People talked about statistics. Statistics can be deceptive. They can be manipulated. And it depends whose set of statistics you're looking at. And I haven't seen anything that's convinced me that anything terrible happens because of legal carry. Because guess what? If you're going to go and have constitutional carry or carry legally, you're not the one that's going out and committing crimes. It's the people who shouldn't have a gun. It's like, again, I'll use a New Jersey example. They said the maximum amount of ammo that you could have in a magazine would be 10 rounds, no more than 10 rounds. So I guess all the criminals, before they went out and held up a bank, before they went out and killed somebody, they went to their gun store and had the pin put in so they could only carry the 10 rounds. I'm being facetious. Come on. We're, again, inflicting pain upon legal gun owners that just want to protect themselves or are involved in the sport and don't do any harm. It doesn't make sense. My friends on the other side, what they really want to do is amend the Constitution of the United States. That's what you want to do. You want to deny Second Amendment rights. It is clear in the Constitution that we have this right. So I would suggest instead of arguing against these laws and Supreme Court decisions that you attempt to change the Constitution. I don't think you'll be very successful. Rights of illegals, that came up. I wanted to talk about that. Guess what, ladies and gentlemen? The rights of illegals that are here illegally in the United States of America are not exactly the same as the rights of people who are here legally, and that is true in any country around the world. Any country, you don't have exactly the same rights. So, yes, if you're illegal and you attack a police officer, you are going to be detained, go through due process, and then you're going to be deported. Also was said that we want to dismantle the Department of Justice, the ATF, the Attorney General's office. No, we don't. We want to make it better. We want to depoliticize it. We want to de-weaponize it. But we don't want to have happen what happened to innocent people before, whether it was ATF, whether it was the Department of Justice, whether it was the Attorney General, it was wrong. The bottom line is the way that it's going in the country right now, the way that it's existed for years, when you've got to buy all these separate permits with separate laws, not knowing what you could do. Good people, innocent people, number one, sometimes can't afford it. Number two, they get jammed up, just like the story I told earlier about the young lady, the nurse from Pennsylvania, who had a carry permit in Pennsylvania, crossed over the bridge in New Jersey, was stopped for, I think one of her taillights were out or whatever, was a good, honest person, never even got a speeding ticket. They wanted to put her in jail for 3 years, and fortunately the governor saved her. That's what's wrong. It's discriminatory, it's wrong, it's ineffective. This is a way to even the playing field and to do it in a way that helps the average American who wants to be able to carry a firearm. It's the Second Amendment. We're obeying for once the Constitution and the Second Amendment. I yield back.
Gentleman yields back, seeks recognition. Gentlelady from Georgia is recognized.
Mr. Chairman, I have an amendment at the desk.
Clerk will report. Gentleman from California reserves a point of order.
Amendment to the amendment in the nature of a
Amendment will be
substitute.
considered as read. The gentlelady from Georgia is recognized to explain the amendment.
Thank you. Mr. Chair, my amendment would prohibit a person subject to a restraining order for stalking, threats, or harassment from carrying a concealed weapon under the bill. A person who is subject to a restraining order from an intimate partner due to stalking, threats, or harassment is not allowed to purchase or possess firearms and so could not carry a concealed firearm under this bill. But the bill would allow stalkers and harassers who are not intimate partners to conceal carry firearms under this bill. This bill makes it easier for them to conceal carry a gun as they pursue the target of their stalking, threats, or harassment across state lines. Attempted murders of women are often preceded by stalking incidents. In fact, one study found that nearly 9 out of 10 cases there had been a stalking incident in the year leading up to the attempted murder. Further, most mass shootings are related to domestic violence, and responding to domestic disturbances often prove deadly to law enforcement officers. We cannot be responsible for enabling stalkers and abusers to follow their victims across state lines with concealed handguns. My amendment would prevent this by excluding these potentially dangerous people from being able to conceal carry under this bill. And I ask unanimous consent to enter into the record the role of domestic violence and fatal mass shootings in the United States, 2014 to 2019.
Without objection.
Thank you. And also, too, there's an article here that just further substantiate what we've been talking about. Firearms are by far the most common method used to kill police officers in the United States. From 2012 to 2021, 504 police officers were killed in the United States. Out of those, 456 officers were fatally shot with a gun, meaning that 90% of these homicides were perpetrated with a gun. From 2020 to 2021, the number of police officers fatally shot rose to 35%. Another statement here, police officers in the United States are more likely to be fatally shot in states with higher levels of gun ownership and weaker gun laws. A 2016 study concluded that police officers were 3 times more likely to be fatally shot in the states with the highest levels of gun ownership in the state than in the states with the lowest levels of gun ownership. The Giffords Law Center graded states based on the strength of their gun laws. States that received an F saw higher rates of police officers fatally shot from 2017 to 2021. I asked to enter into the record, weak gun laws are hurting police officers.
Without objection.
And also debunking myths the gun lobby perpetuates following mass shootings.
Without objection.
Mr. Chair, for the last 12 years, I've been fighting with just my heart and soul to really try to make this make this country safer, make our communities safer. And I promise you, I worked with law enforcement so readily. They were so dedicated to helping me find justice when my son was murdered. The least that we could do is try to prevent them from being hurt while they're in the line of duty. Any legislation that prevents their ability from being hurt or maimed or killed while they're on duty, we need to consider this. And concealed carry reciprocity, it's an open door that allows anyone who has any nefarious reasons or criminality, whatever it is that they intend to do, it puts our law enforcement in so much more danger. And I just don't understand why it's something so simple and so common sense we are fighting against. I am very grateful to all the law enforcement in this country We owe them a great debt of gratitude for continuing to protect our communities and our homes and our lives. Why would you not want to do something that protects them from violence when they're on duty? And I yield back.
Generally yields back. I would oppose the amendment. I think it's redundant and repetitive. We have the Lautenberg Amendment of people convicted of domestic violence. We have the Bipartisan Safer Communities Act, which prohibits the purchase and possession of firearms for 5 years for people convicted in a court of a misdemeanor crime of domestic violence against a victim with whom they've have had a current or recent former dating relationship. And then when it comes to harassing or stalking, that is also covered. So I don't think this amendment is necessary. It's redundant. And would oppose the amendment. Who seeks recognition? The ranking member is recognized.
Thank you, Mr. Chairman. I want to commend Ms. McBath not only for this excellent and absolutely necessary amendment, but also for her magnificent activism. I'm not sure if all of our new colleagues know that Ms. McBath, because of the terrible personal tragedy she suffered, got into politics for that reason, to deal with this issue, and has been confronting the overwhelming power of the NRA and the gun manufacturers. And I'm sure she interprets this as just one more affront and insult today. But in any event, her amendment is excellent. It says that anybody who's subject to a court order restraining the person from harassing, stalking, or threatening an individual, which means that they have been doing that, does not have the benefit of this new nationwide mandate straitjacket on all of the states to admit people to come in on a concealed carry basis. The good chairman says this is redundant. It's already taken care of by existing law. And it is true that people who harass, stalk, or threaten intimate partners are prohibited purchasers and therefore would not have the benefit of this gaping new loophole that our colleagues want to create. But there are lots of people who harass and stalk and threaten other people who are not intimate partners. For example, people do that to politicians all the time. I think there's an Olympic athlete who was talking about being stalked today, Gabby Thomas. But there's also people who were once intimate partners or had some kind of relationship or got into a fight with somebody who stalked them. And so what Ms. McBath's amendment says, as I read it, is that if a court has ordered somebody to stop harassing, stalking, or threatening another person, whether or not they're an intimate partner, that person should not be allowed to cross state lines with a gun on a concealed carry basis, because that's a danger. Why are we opening up this Pandora's box in general? But at the very least, when it comes to people who've been convicted of crimes against cops or here who are harassing, stalking, or threatening another person, they should not have the benefit of that. And I'm happy to yield additional time to Ms. McBath if she's got further thoughts at this point.
Well, thank you to my colleague from Maryland. But there again, every day I meet people all across the country. And I'm meeting survivors every single day who've lost law enforcement, their loved ones. They're losing family members every single day. And when they ask me, why aren't you all doing anything? Why are you allowing these kinds of tragedies to happen over and over again? And I have to honestly say, I don't have an answer. I don't have an answer for you. All I can tell you is that the NRA gun lobby and my Republican colleagues refuse to consider keeping you safe, but expanding our gun laws, loosening our gun laws, and I don't have an answer for you.
Ms. McBath, if I could reclaim 1 second here, just an answer to that question. We heard the gentleman from New Jersey say, this is just about the Second Amendment. Nonsense. If it were about the Second Amendment, they wouldn't need this law. The Second Amendment would already take care of it. Of course it doesn't follow from the Second Amendment. The Supreme Court said in the Bruin case, it's up to each of the states to follow within the contours of the doctrine that they set down. And so if the Second Amendment took care of it, they would just wipe out all the laws, but they've not been able to do that. So right now, there are a lot of states that have imposed meaningful, muscular standards for people to get guns. You might disagree with that, fine. In your state, you don't have to have that. But why should your state get to trump everybody else's state who thinks that this is a matter of public safety and they want to deal with it? So that use of the Second Amendment is completely inaccurate. You can't say, for example, when the courts have said that assault weapons can be banned or not according to the state, you can't say, oh, well, it's a Second Amendment right, therefore you can't ban assault weapons. That's just nonsense. That's a ridiculous way of talking about the subject, right? Like under the First Amendment, we have reasonable time, place, manner restrictions. You don't have to allow people to have a rally in front of other people's houses at 2 o'clock in the morning. You can't say, oh yes, we have to allow that in every state now because that's what the First Amendment requires. That's what you're saying about the Second Amendment. It's a ridiculous and fantastical approach to a serious public policy problem. I want to thank Ms. McBath for her leadership on this. I yield back to you, Mr. Chairman.
Gentleman yields back. Gentlelady from Pennsylvania is recognized on the amendment.
Thank you. I do support the amendment offered by the gentlewoman from Georgia. It's a common sense amendment based on sound evidence, and it will save lives. Look, Americans across our country continue to live with the fear and grief caused by senseless gun violence that's taken the lives of too many of our loved ones, our neighbors, our friends. But Republicans here in D.C. want to roll back the progress we've made in states like Pennsylvania to keep weapons out of dangerous hands and off our neighborhood streets. This misguided bill that we're talking about right now, H.R. 38, would take a sledgehammer to our state's laws, forcing Pennsylvania and other states that have enacted stronger standards to allow individuals from any state with weak standards to carry concealed and loaded handguns in public. The data is clear. Studies have found that weak concealed carry laws are associated with an increase in violent crime and higher rates of handgun homicides. So Pennsylvania has enacted certain common sense laws to protect the public from some of the obvious dangers of concealed carry. In order to carry a concealed weapon in Pennsylvania, a person must have a valid license in their home state and be at least 21 years of age, because our legislature determined that's a minimum standard to protect our people in Pennsylvania. But 29 other states haven't enacted such common sense protections. They don't require a permit. So this bill would effectively overrule Pennsylvania's law requiring a permit. Pennsylvania says that people who pose a credible danger to the public can be blocked from having a concealed carry permit, but 35 states don't have that requirement. Pennsylvania blocks convicted stalkers from having concealed carry, but 23 states don't. Pennsylvania blocks abusive dating partners from concealed carry, but 20 states don't. Pennsylvania blocks people with multiple DUI convictions from concealed carry, but 33 other states don't. And Pennsylvania requires concealed carriers to be at least 21. 19 states don't. This bill would also allow concealed carry by out-of-state gun owners in areas that Pennsylvania does not, like elementary and secondary schools. So by subjecting Pennsylvania to this patchwork of laws from across the country, this law will make it harder for state and local law enforcement to do their jobs, because they're going to have to juggle what the laws are for every other jurisdiction and exempt out-of-state people from enforcement of those laws. And to add insult to injury, this bill would subject Pennsylvania police to lawsuit and money damages if they mistakenly enforce Pennsylvania's laws against people from states with weaker laws. So it's no surprise that this bill is opposed by law enforcement groups. Look, in the last couple years, we've seen a dramatic decrease in gun violence across Pennsylvania as a result of common sense policies that keep firearms out of the hands of people who shouldn't have them. Now is not the time to go backwards when it comes to reducing gun violence. There's plenty of work to do. Americans deserve a Congress that does its job and puts forward solutions to keep people safe, not one that turns back the clock. I strongly oppose this bill, and I yield back. Sorry, I would yield to the ranking member.
Thank you, Ms. Scanlon. I just want to say our colleagues should consider this when you're thinking about voting against the amendment to exempt from the benefit of this great new mandate on all 50 states in America people who are harassing, stalking, or threatening other individuals. Look at who's been doing that. The Judicial Conference has been complaining about the fact that they are being threatened, intimidated, and stalked by people across the country. In the last several decades, 4 federal judges have been murdered. Several more have seen their own family members killed at the hands of defendants and court litigants, and many others have been enduring repeated and lurid violent personal threats and intimidation and stalking. We have seen more than a tripling of violent threats against judges over the last decade. So now we're saying, all right, you've got a strong state like Pennsylvania, which says we are going to be very careful about who gets concealed carry so that criminals and dangerous people are not sneaking in. But suddenly we're going to impose this nationwide straitjacket on Pennsylvania and say they've got to accept the states with the weakest laws in the country, where basically anybody can get concealed carry and those people can enter the state. And what if one of them is nursing a grudge against a particular judge or a particular justice? Look where we are in America right now. And we're actually talking about not giving an exception to this law for people who are under a court order to stop them from stalking somebody. In other words, it's been proven in court they're threatening or intimidating, stalking somebody, and you guys want to make this part of this new nationwide law. It's incredible to me. Thank you. I yield back.
And I yield back.
Gentlelady yields back. The gentleman from Georgia is recognized on the amendment.
Thank you, Mr. Chairman. I rise I'm in favor of the amendment, and I would ask for unanimous consent to enter into the record a article, NBCnews.com, entitled "Olympian Gabby Thomas says a group of men have been following her at airports."
Without objection.
And, Mr. Chairman, this is an article that talks about a woman who is attractive, who is harassed and stalked at airports when she is traveling. And these can be people who follow her, or they can be people who just might happen to see her. She is an attractive woman. And the problem here is that we have non-intimate partner stalking. We have people who she could get a court order against to stop them from following her and stalking her, but because they are not considered to be intimate partners, then they would be exempt from the prohibition in the underlying legislation that would prohibit them from being able to conceal carry in any particular state. And so that's a loophole that this amendment would cover, which is why I support this amendment. And with that, I will yield back.
Gentleman yields back. Does anybody else seek to be recognized? This amendment? Hearing none, the question occurs on the amendment offered by the gentlelady from Georgia. Those in favor say aye.
Aye.
Those opposed say nay. No. Being the chair, the nays have it. Okay. Recorded
Request a
votes.
recorded vote.
Recorded vote's been requested. Clerk will call the roll.
Mr. Jordan. Mr. Issa. Mr. Issa votes no. Mr. Biggs. Mr. McClintock. Mr. Tiffany. Mr. Massey.
No.
Mr. Massey votes no. Mr. Roy. Mr. Roy votes no. Mr. Fitzgerald. Mr. Klein. Mr. Gooden. Mr. Van Drew. Mr. Van Drew votes no. Mr. Nels. Mr. Nels votes no. Mr. Moore. Mr. Moore votes no. Mr. Kiley. Ms. Hageman. Ms. Lee. Mr. Hunt. Mr. Fry. Mr. Grothman. Mr. Knott. Mr. Harris. Mr. Onder. Mr. Onder votes no. Mr. Schmidt. Mr. Schmidt votes no. Mr. Gill. Mr. Gill votes no. Mr. Baumgartner. Mr. Raskin. Mr. Raskin votes aye. Mr. Nadler? Mr. Nadler votes aye. Ms. Lofgren? Ms. Lofgren votes aye. Mr. Cohen? Mr. Johnson? Mr. Johnson votes aye. Mr. Swalwell? Mr. Liu? Ms. Jayapal? Mr. Correa? Ms. Scanlon? Ms. Scanlon votes aye. Mr. Neguse? Ms. McBath? Ms. McBath votes aye. Ms. Ross? Ms. Ballant? Mr. Garcia? Mr. Garcia votes aye. Ms. Kamlager-Dove? Ms. Kamlager-Dove votes aye. Mr. Moskowitz? Mr. Goldman? Mr. Goldman votes aye. Ms. Crockett? Mr. Biggs? Mr. Biggs votes no. Mr. Tiffany? Mr. Tiffany votes no. Mr. Fitzgerald? Mr. Fitzgerald votes no. Mr. Baumgartner? Mr. Baumgartner votes no. Mr. Klein? Mr. Klein votes no. Mr. Grothman? Mr. Grothman votes no. Mr. Kiley? Mr. Kiley votes no. Mr. Gooden? Mr. Gooden votes no. Mr. McClintock votes no.
Are there any members who wish to vote who haven't voted? Clerk will report.
Mr. Chairman, there are 9 ayes and 18 noes.
The nays have it. Who seeks recognition?
Mr. Chairman,
Gentleman from New York is recognized.
I have an amendment at the desk.
Clerk will report the amendment.
Amendment,
Mr. Tiffany reserves a point of order.
amendment to the amendment in the nature of a substitute to H.R. 38 offered by Mr. Nadler of New York.
Without objection, the amendment will be considered as read.
Mr. Chairman,
Gentleman's recognized.
thank you. Mr. Chairman, this nation is awash in guns, and gun violence is ravaging our communities. Each day, more than 300 people are shot, including more than 20 children. And each day, more than 100 people die from these wounds. But instead of tackling this epidemic of gun violence and bringing forward sensible gun safety legislation, House Republicans want to put more guns in our communities. Not only that, they want to overrule the reasonable restrictions that states have put in place to protect their citizens. This legislation is an affront to federalism and a threat to public safety. The states have made carefully crafted judgments about who may carry concealed firearms in their states and under what circumstances. This bill, however, would completely override those decisions and would endanger the citizens of the states whose laws will be overruled. This legislation would eviscerate the core public safety determinations that each state makes concerning eligibility to carry concealed weapons. Whether it is requirements for periodic training, certifications of good character, minimum age requirements, or other standards, each state chooses what best fits the needs of their own citizens and best protects the safety of their communities. For example, 13 states have made the deliberate determination to bar violent misdemeanor offenders from possessing guns at all. This policy is associated with a 21% reduction in intimate partner homicide and an 18% reduction in overall homicide. Other states will not issue concealed carry permits to individuals convicted of various violent misdemeanor offenses. Depending on the state and the circumstances, this may include people convicted of sexual battery, aggravated assault, and strangulation. Under this legislation, however, those states would be required to allow such offenders to carry a concealed weapon if they have a valid license from another state. That is an outrageous intrusion on states' rights and an unacceptable threat to public safety. My amendment, therefore, would exempt from this bill anyone who has been convicted of a violent misdemeanor. It would ensure that such offenders may not carry a concealed weapon in a state where their conviction would otherwise disqualify them from carrying in public. Without my amendment, this legislation would gut these states' public safety decisions and would subvert the will of their citizens. It would allow violent offenders to seek permits from those states that will happily grant them, and then to take those permits and legally carry guns in states that would otherwise bar them from doing so. We know from research that a history of misdemeanor convictions predicts future criminal activity for gun purchasers. One study showed that buyers with at least one conviction were more than 7 times more likely to be charged with a new crime compared to gun buyers who do not have that criminal history. In fact, if you look at men with at least 2 violent misdemeanor convictions, they are 10 to 15 times more likely to be charged with gun crimes or violent crimes after that gun purchase. To those states that have made the reasonable decision not to allow individuals with such violent criminal history to carry such a concealed weapon, this bill overrides that decision. We should respect the public safety determination of those states and make sure that these violent offenders cannot use this legislation to circumvent their laws. I urge adoption of the amendment. I yield back the balance of my time.
I thank the gentleman. Does anybody seek to be recognized on the amendment? Mr. Tiffany withdraws his point of order. Although I appreciate the gentleman's offer of an amendment here, an individual's constitutional right to protect themselves and their loved ones should not be stripped away for a misdemeanor. And by the way, the Gun Control Act of 1968 already prohibits an individual convicted of a felony or a crime punishable by a year or more from either purchasing or possessing a firearm. If you can't purchase or possess it under the law, how would you carry it under the law? This amendment is therefore redundant and unnecessary. Furthermore, federal law also prohibits an individual convicted of a misdemeanor of domestic violence from possessing or purchasing a firearm. So again, this amendment is therefore either redundant or unnecessary. I yield back.
May I be recognized?
Yes. Gentleman from New York is recognized.
Thank you, Mr. Chairman. I appreciate that convicted felons are not allowed to purchase a firearm and therefore are not allowed to carry a firearm. I appreciate that there are some misdemeanor domestic violence crimes that prohibit anyone from purchasing a firearm, but that's not what this amendment does. So by bringing up those facts, you are missing the point. The point here is there are violent misdemeanors. There are assaults. There are other crimes of violence that do not carry a penalty of 1 year or more. And it's bewildering to me that you all are so dug in against amending or changing a bill that you unilaterally drafted, even if the amendments are so clearly and obviously reasonable and they're not covered by existing law. Are you really telling me and telling the American people that someone convicted of a violent misdemeanor should not only be allowed to carry a gun in some states, but should be allowed to bring that concealed weapon to other states that would have prohibited that person from obtaining a gun? It's insanity. And I'm so tired of the hypocrisy when it comes to states' rights. Just be consistent. If you're going to tell us that you don't think that states should oversee any laws, that the federal government should be able to dive into whatever policy areas it wants to, great, fine. Then we know the playing field that we're on. And we're happy to have that conversation. But you can't pick and choose when states' rights apply and when they don't. Yet you do consistently. This is such an obvious common sense amendment. And then to misdirect everyone by saying it's redundant when it's not is a bad faith argument. So at least let's have a good faith discussion about this and explain to us why you oppose those convicted, not arrested, like the Lake and Riley Act, convicted of violent misdemeanors should be allowed to carry concealed weapons
into states where they would otherwise not be allowed to. If a single Republican member can explain a good rationale that does not rely on some blanket Second Amendment right, when we all know that the Second Amendment right is not absolute, and we are not, Mr. Van Drew, saying that there is no Second Amendment right. We are not sitting here telling you that the Second Amendment doesn't exist. We are simply putting common sense restrictions to prevent senseless deaths, senseless gun deaths that happen over and over and over again in this country at a rate so far above any other country that it is not mental health. It's just baffling that you're so partisan that you can't even look at an amendment in any kind of objective manner and say, you know what? We didn't include this in our bill, but this makes sense. Let's vote it in. I yield back.
Gentleman yields back. Gentleman from New Jersey is recognized.
Thank you. And to my friend from New York, look, there is a Second Amendment. There are Second Amendment rights. This legislation that we are debating today abides with those rights, is within those rights. And I'm still going to maintain what I said before. If you don't like it, I understand that. I even respect it. But then you have to change the Constitution. And to speak to some of the issues that you brought up, if you notice a hesitancy on this side of the aisle, there is a reason. Because the reality is, and the truth is, that many good people who are not lawbreakers, and there's many, many examples where they get in trouble for the most minor of incidents with a gun. And I don't mean holding somebody up or threatening somebody or anything like that, but crossing a state line by accident and not having the permit, by not really, was another example in our state of a farmer that had a shotgun that I think was an inch too short that he just used on his farm and didn't use for anything else. Never had any problems, never had any convictions, never had any arrests, never threatened anybody, got in trouble. The honest to God truth is that there are really good people who got in trouble because of this patchwork system that we have in place that doesn't abide by the Constitution of the United States of America. And you can try to point out little examples here or there or say that this is why we should do it. And again, you're free to have that argument, have that discussion, have that colloquy, have that debate. But the reality is, it is the Second Amendment, and if you want to change it, then you have to amend the Constitution. And the second point I want to make that is important and I think has been overlooked, we have a great deal of reciprocity already in the country. I mentioned before that I can carry in about 40 states. A lot of those are reciprocity states, states that recognize other states already across the country that have all different kinds of regulations and rules, but they recognize them. Because to be honest with you, it is tricky business. When you are a law-abiding, good person that never did anything but simply wants to carry, you can get in trouble and really have big problems. Just what you're mentioning before, the 18 and 21. Some states are 21, some states are 18. God forbid you're 18 years old and you go into a state that is 21 and you get, not realizing that, the way it currently is, you get caught, you're in deep trouble. You broke a gun law. Then you've got on your record you broke a gun law. And in some states, forgive me, but the states that tend to be more left, more liberal, more Democrat, whatever you want to say, that's the person who ends up going to jail. That's the person who ends up getting in trouble, not the person who knowingly, was convicted of a crime or has perpetrated a crime, has done something that we would all find distasteful, possibly evil. There, we're showing more laxity and we're trying to help them and we're trying to be, more understanding of what it is. But for good people that have done nothing wrong, and it has happened and it continues to happen in this country, they get in trouble because they get jammed up on all these technicalities from state to state. Some states you can go in a restaurant, other states you can't. Some states you can do one thing, other states you can't. And then I don't know how good you are, if you're traveling across the country or driving through multiple states, it can be very complicated, and good people really can be hurt by overly zealous.
Will the gentleman yield for a question?
I will yield.
I find it interesting that you noted that a number of states provide reciprocity, which seems to indicate that states are well aware of that possibility, and some have decided to provide it and some have not. Why is it appropriate for the federal government to come in and overrule the state's considered decision as to whether or not reciprocity should be given?
I will reclaim my time because I don't think they're overruling anything. They are just making sure that nationally we abide by the Constitution of the United States of America. And that provision, the Second Amendment, is part of that Constitution, and we need to make sure that the Constitution is fulfilled. And that's the answer to that.
Would the gentleman yield? Would the gentleman yield?
Yes, I will yield back.
I would suggest if the Democrats think you should be deprived of your Second Amendment rights for a bar fight or for shoving somebody, for a misdemeanor conviction that involves, quote, violence, they should try the next time they're in the majority to update Section 922G, which enumerates all of the reasons you would become a prohibited person and prohibited from purchasing a firearm. And yields back. Gentleman's time has expired. Now recognize the gentlelady from Pennsylvania.
Thank you. Frankly, I have to say I'm a little surprised that our Republican colleagues are opposing an amendment that would prevent violent criminals from carrying concealed weapons, because that's what this amendment would do. It's a well-drawn amendment that would address a loophole that we have here. Mr. Massey is correct that felonies are covered already, and he's also correct, or I can't remember if he mentioned, that misdemeanors regarding crimes of domestic violence are covered, but these aren't the only violent misdemeanors. For example, in Pennsylvania, it's a misdemeanor to obstruct or impair law enforcement by force or violence or physical interference. So if someone is convicted of that violent misdemeanor, obstructing a police officer, they would still be allowed to, they would not be allowed to have a concealed carry. I think it's a common sense law that we should all be able to agree upon, and I would support the amendment. And just with respect to Mr. Van Drew's suggestion that somehow this amendment is taking away someone's Second Amendment rights, it's not saying they can't own a weapon. It's just saying they can't carry it in a concealed fashion. I would yield back.
The gentleman yields back. The gentleman from California is recognized.
Thank you. I have a question for the gentleman from New York, if he, and will yield if you're inclined to answer, which is that, can you give me an example of any state where CCW holders commit homicide or any other crime at a rate greater than the general population?
I don't think I understand your question.
Can you give me an example of any state where CCW holders commit homicide or any crime at a rate that is higher than the general population does?
I don't have that data in front of me, but I'm happy to look into it.
Well, because you made some claims about how if we allow this policy, it's going to unleash criminals or, violence upon the rest of the country. It would seem for that, maybe you'd have a point if there was some state out there where, its standards are so low that you have all kinds of criminals getting their hands on CCWs and committing terrible crimes. But to my knowledge, there is no example of any such state. To the contrary, the data shows that CCW holders are usually, 10 times less likely to commit crimes, including violent crimes, than the general population.
Will the gentleman yield?
Sure.
I would just point out the data on gun violence in states that have lax gun laws and states that have strict gun laws, because what you will find is there's a direct correlation to gun violence and the amount of gun violence in the states, depending on how strict and restrictive their gun laws are.
Okay, but that's not the question. On this bill, we're talking about CCW holders. So if you saw reliable evidence that CCW holders are much less likely to commit acts of violence or other crimes than the general population, would that change your opinion on the merits of this bill?
No.
All right, I yield back.
The gentleman yields back. Who else seeks to be recognized?
I'd seek unanimous consent.
The gentlelady has unanimous consent. Request is recognized.
I would ask unanimous consent to enter into the record an analysis of the gun violence archive data from the Trace titled "Shooting Deaths Were Higher in Most States After Permitless Carry."
Without objection.
And also ask unanimous consent to enter into the record an article by Chip Brownlee titled "Permitless Carry Will Deter Shootings." Proponents said, "That's not what happened," published by the Trace on August 9, 2024.
Without objection. Gentleman from Virginia is recognized.
I move to strike last word.
Gentleman's recognized.
Thank you, Mr. Chairman. I'm glad we're having this debate tonight because we were all sent here by our constituents to represent the views of the majority back in our districts. In my district, a majority of constituents in my district sent me to Washington, just as they sent me to Richmond before that, to protect these constitutional rights. The constitutional rights, including the Second Amendment, which actually we can improve by passing this bill, which would allow people to cross state lines and still have those Second Amendment rights protected. It was an honor for me in the State House to chair the Committee on Militia, Police, and Public Safety, one of the oldest committees in the Virginia General Assembly, but it was a principle of that committee and of the Virginia House to defend those Second Amendment rights. We consistently reported out constitutional carry bills, and in Virginia we do have a concealed carry law, but we respect the rights of other states that if they have other laws, that they should be able to come into Virginia, that there should be some kind of reciprocity, and that individuals who are legally permitted to carry a concealed firearm in other states should be able to do so in other states. At the core, this bill is affirming just a simple truth: the right to self-defense, the right that is protected by our Second Amendment, should not end at a state border. The Second Amendment is not about gun violence. It's about your right to protect yourself, your family, your property in the way that you see fit, leaving to the individual the decision as to how to protect themselves. I hear a lot from the other side about how they make the decisions to keep people safe and how they know best as to how to keep Americans safe with more gun laws, more government intervention, and more government oversight over the rights of people to defend themselves. The people on this side of the aisle, and quite frankly, the side that got more votes in last November, believes in the power of the individuals to make those decisions. And that power was not granted to them by government, but by God, and that it was enshrined in the Constitution by the founders to protect that God-given right. So just as the First Amendment right to free speech doesn't change from state to state, we shouldn't burden lawful gun owners with an inconsistent or confusing patchwork of concealed carry laws. Some would argue that the bill jeopardizes public safety, but the facts don't support that claim because concealed carry permit holders, as has been stated, are the most law-abiding citizens in America. Criminals, by definition, don't follow the law, but law-abiding gun owners do, and they shouldn't have to risk legal jeopardy simply for exercising their constitutional rights while traveling to another state. So I support this important legislation, support the principles that are enshrined in the Constitution, and I hope that we would defeat this amendment and pass this bill.
Will the gentleman yield for a question?
Gentleman yields back. Who seeks recognition? Gentlelady from California is recognized on the Marley-Nadler amendment.
Thank you, Mr. Chair. I'd like to yield to my colleague from New York.
I thank the gentlewoman from California. We're focused right now on concealed carry permits. At least that's what my friend from California and Mr. Klein were just talking about. But this bill, as I understand it, you can correct me if I'm wrong, would apply to states that don't require permits to carry concealed weapons. And based on this data that we just entered into the record, there are 20 states
that do not require permits to carry weapons. The data on that we just introduced into the record shows that the majority of states that enacted permitless carry between 2015 and 2022 saw significantly higher shooting death rates after the implementation. So, and I'm willing to be corrected here if I'm reading this incorrectly, but what I understand from this bill is that if you are in a state that allows an individual to carry a concealed weapon without a permit, you will then be permitted to carry a concealed weapon without a permit in every state in the country. And so while I appreciate the gentleman's pointing to the additional, the data that shows that those who have concealed carry permits are safer with guns, we're talking about many, many, many people, 20 states that don't even require those permits. And now, essentially, the entire country, it will become a permitless country. And anybody who can go to one of those 20 states and get a permit can now go around the United States in contravention of state laws that are successful, those state laws that restrict concealed carry have lower gun violence rates, and now we're just undoing that with this bill. Correct me if I'm wrong, but that's how I read it. And so this conversation about concealed carry permits is a complete red herring. That's not even what we're talking about here. I yield back to the gentlelady.
Gentleman yields back. Question occurs on the amendment from the gentleman from New York. All those in favor say aye. Aye. Those opposed, no. No. In the opinion of the chair, the noes have it.
Recorded vote.
The roll call vote being requested on the Nadler amendment. The clerk will call the roll.
Mr. Jordan?
No.
Mr. Jordan votes no. Mr. Isa? Mr. Isa votes no. Mr. Biggs? Mr. Biggs votes no. Mr. McClintock? Mr. McClintock votes no. Mr. Tiffany? Mr. Tiffany votes no. Mr. Massey? Mr. Massey votes no. Mr. Roy? Mr. Roy votes no. Mr. Fitzgerald? Mr. Klein? Mr. Klein votes no. Mr. Gooden? Mr. Van Drew? Mr. Van Drew votes no. Mr. Nels? Mr. Nels votes no. Mr. Moore? Mr. Moore votes no. Mr. Kiley? Mr. Kiley votes no. Ms. Hageman? Ms. Lee? Mr. Hunt? Mr. Fry? Mr. Fry votes no. Mr. Grothman? Mr. Knott? Mr. Harris? Mr. Onder? Mr. Onder votes no. Mr. Schmidt? Mr. Schmidt votes no. Mr. Gill? Mr. Baumgartner? Mr. Raskin? Mr. Raskin votes aye. Mr. Nadler? Mr. Nadler votes aye. Ms. Lofgren? Ms. Lofgren votes aye. Mr. Cohen? Mr. Johnson? Mr. Johnson votes aye. Mr. Swalwell? Mr. Liu? Ms. Jayapal? Mr. Correa? Ms. Scanlon?
Aye.
Ms. Scanlon votes aye. Mr. Neguse? Ms. McBath? Ms. McBath votes aye. Ms. Ross? Ms. Ballant? Mr. Garcia? Mr. Garcia votes aye. Ms. Kamlager-Dove? Ms. Kamlager-Dove votes aye. Mr. Moskowitz? Mr. Goldman? Mr. Goldman votes aye. Ms. Crockett? Ms. Crockett votes aye. Mr. Fitzgerald, you are not recorded. Mr. Fitzgerald votes no.
How am I recorded?
Mr. Knott, you are not recorded.
No.
Mr. Knott votes no. Mr. Grothman, you are not recorded. Mr. Grothman votes no. Mr. Baumgartner? Mr. Baumgartner votes no. Mr. Gooden? Mr. Gooden votes no.
Clerk will report.
Mr. Chairman, there are 10 ayes and 20 noes.
The amendment is not agreed to. Who seeks recognition?
Mr. Chairman?
Gentleman from Kentucky is recognized.
Wait, I have an amendment at the desk.
Clerk will report.
Substitute for the amendment in the nature of a substitute to H.R.
Ranking
38,
member reserves a point of order.
offered by Mr. Massey of
Without
Kentucky.
objection, the amendment will be considered as read. The gentleman from California, or excuse me, from Kentucky is recognized to explain his amendment.
Mr. Chairman, I appreciate H.R. 38, the Constitutional Concealed Carry Reciprocity Act. I intend to vote for it, but and when it was first drafted, I think it was more complete. But what has happened is we've had a Supreme Court decision, and we've had some activity by the states, sort of changes the nature of H.R. 38. What is that activity? Well, 29 states are now constitutional carry. This will address Mr. Goldman's concern. 29 states are now constitutional carry. H.R. 38 sets up a situation where if you are in a state like Kentucky that has constitutional carry, and you travel to a state like California, which does not have constitutional carry, I have, in some ways, more rights to carry a gun in California than does a California resident, under the framework that H.R. 38 would establish. Now, those were just a few exceptions here and there to H.R. 38 when there weren't that many constitutional carry states. But now there are 29 constitutional carry states. What else has happened? Well, the Supreme Court decision of Bruin says that every state now has to issue a permit. So if I'm from Kentucky and I have constitutional carry, it means I now have constitutional carry in every state under H.R. 38. There's also sort of this other issue that Mr. Goldman, or actually Mr. Nadler's amendment got to that my amendment solves, because my amendment, by the way, is just a statement of a bill that I have offered, which is national constitutional carry. And what my bill says is that if it is legal for you to own a gun in a state, then it is also legal for you to carry that gun in that state. It doesn't impose on California a new set of gun rules or a new category of people who are eligible or not eligible to own a firearm. It just says, if the state of California has decided that you can own a gun, that you are able to own a gun, and that you meet those qualifications, and that the gun is one that the state of California approves of, then the state of California has to let you carry that gun. It doesn't provide any more rights to somebody from Kentucky and California than a person in California has in California, which is one of the problems with H.R. 38, is H.R. 38 gives me, the person from Kentucky, more rights in California than Mr. Kiley has in California. So we just solved this by doing constitutional carry for the whole country. If we're able to impose H.R. 38 and get half pregnant, surely we can get fully pregnant and do constitutional carry for the whole country. And I don't think this is, by the way, it doesn't rely on the Commerce Clause, which H.R. 38 does. My amendment, which is a restatement of my national reciprocity bill, just says the Constitution says you have the right to keep and bear arms. There should not be two standards. Yeah, we'll let the states, as Heller described, the Heller decision, have some discretion in who can own what, but once you've established that standard, you can't have another standard for who can carry that thing. I mean, if you can own it, surely you should be able to carry it. And by the way, there's been a lot of discussion about is constitutional carry good or not? Well, there are 29 states that allow it now, and guess what? 2 of those states, the legislature, both the House and the Senate in that state, and the governor, are controlled by Democrats, and they've not repealed it. They've had every opportunity. They control all the levers of government in Vermont and Maine, and they have constitutional carry, and guess what? They decided to keep it. It can't be all that bad if the Democrats in those states are keeping it.
But would the gentleman yield?
No, I've got to introduce this bill. Furthermore, a recent study in Ohio's constitutional carry law conducted by the Center for Justice Research shows that after constitutional carry was enacted, the rate of crimes involving a firearm decreased in 6 of Ohio's 8 largest cities. And it doesn't have an appreciable effect on law enforcement injuries or deaths by firearms in Ohio's cities of interest. So, and finally, the states are recognizing this. We're at 29 states. Every year there's another state that joins the rolls of constitutional carry. It just makes sense. Over half the states have it. Instead of having a patchwork, let's just grant the same rights to everybody that the Constitution, the Second Amendment, has enshrined. With that, my time has expired, and I yield back.
Gentleman yields back. Who seeks recognition?
I'll insist on my point of order, Mr. Chairman.
Mr. Chairman?
Yep.
I'm sorry. I withdraw my amendment.
The point of order is not really germane now that the gentleman has withdrawn his amendment. Even though I liked his amendment. But I don't know that everyone in the conference will leave it at that. Who seeks recognition? The gentleman from New York is recognized.
I have an amendment at the desk.
Clerk will report. Gentleman from Arizona reserves a point of order.
Amendment to the amendment and the
Without
nature.
objection, the amendment will be considered as read. The gentleman from New York is recognized to explain his amendment.
Well, Mr. Massey, you are in luck because this amendment does exactly what you wanted to do, which is
I
to
doubt
say,
that.
which is to say that this bill does not apply to any individual who would not otherwise be able to possess a gun in the state in which to which they carry it. It is pretty simple, just is a pure federalism amendment. It says that the state laws of a particular state shall not be overruled by a different state law through a federal mandate of reciprocity. Very simple. Pure states' rights. I know my colleagues support states' rights. And the notion here that we should have the ability, as Mr. Massey just said, for someone in Kentucky to have far more lenient gun laws when that person travels to California than an individual in California obviously makes no sense. And I know Mr. Massey will agree with that. So this is a fairly simple amendment that ensures that states get to control who possesses a gun within their own state lines. So if you're not permitted to carry a firearm in a particular state, you cannot do an end run around that prohibition by getting a permit in a different state and crossing state lines. I would love for my colleagues on the other side of the aisle to explain to me why they are going to oppose this, and I know they are going to. But explain how it is consistent with federalism when what you are effectively saying is that your knowledge, your expertise, your wisdom, your judgment should supersede that of states who have control over their own gun licenses and gun rules. And with that, I yield back.
Gentleman yields back. I oppose the amendment from the gentleman from New York. It's not to say my judgment supersedes the judgment of the state. It's to say that the Second Amendment should apply to every single American who is a law-abiding citizen who's not disqualified under current law, and they should be able to exercise their rights and enjoy the fullness of their rights, regardless of whether they're on one side of a state line or the other. It applies to the American people, and that would be the reason why. This amendment just simply undermines the whole purpose of the bill. And for those reasons, I would oppose it.
Will the gentleman yield?
Yeah.
So are you saying then that any state that effectively the most lenient gun laws are what the Second Amendment in a particular state are what the Second Amendment requires, and that any more restrictive gun laws in any other state then violates the Second Amendment?
No, I'm simply saying that your Second Amendment rights don't end because you happen to cross a state line. Your Second Amendment rights are your Second Amendment rights. They apply to you as an American citizen. The plain and simple. And that is what this legislation is all about. It's why I said I like the amendment by offered by our colleague from Kentucky and then withdrawn, but this amendment would undermine the whole concept.
No, I understand that it might undermine the whole concept.
Not might, it would.
The problem is that the concept itself is preposterous. And this amendment gets to the point.
The Second Amendment is far from
This
preposterous.
is not about the Second Amendment.
I think the time belongs to me. The Second Amendment is far from preposterous. It is the Second Amendment. It is fundamental, and court decision after court decision has said that. You can't have, like,
Mr. Chairman, I didn't say the Second Amendment is preposterous.
I think I have the
Okay,
time.
but just don't
May issue versus
misquote
shall
me.
issue.
Don't misquote me. I didn't say the Second Amendment is preposterous. I said this bill is preposterous.
And I'm saying your amendment undermines the entire purpose of the Second Amendment, which applies to American citizens, American people, and that is why we oppose why I oppose the amendment. Who seeks recognition? I yield back. Who seeks recognition?
I do, Mr. Chairman.
The ranking member's recognition.
Thank you kindly, Mr. Chairman. Look, we need to sort out this problem with what is constitutionally required and what's not. Okay, so the Supreme Court struck down New York's law in the Bruin decision, saying that it was far too difficult. But they did not strike down all laws governing access to concealed carry. In fact, courts have been upholding laws with respect to concealed carry. So there's differences around the country. So that's where the realm of play is. But this law would wipe that out, all in the name of the Second Amendment, even though the court is not saying that the Second Amendment compels states to wipe out any laws with respect to concealed carry. So I'll give you an example. So some states have said that if you assault a police officer, and it's not an aggravated assault, say it's a simple assault of a police officer, but it's an assault. You hit a police officer, you attack a police officer, then you can't get concealed carry for either a period of years in some states or forever in some states. Now, other states say no, if it's a felonious assault against a cop, then you're not going to be able to get it. But if it's a misdemeanor assault, we're going to allow you to get concealed carry. Now, that's within the realm of the policy discretion of the states. But your bill would say that the states that allow misdemeanors against police officers to have concealed carry as a matter of right overwhelm and trump those states which say no. And nobody can explain why, other than to go back to the fallacy that the Second Amendment requires it. The Second Amendment doesn't require it, right? So, but one state could say, we think the First Amendment is so important that you're allowed to have rock music and bullhorns at 2 in the morning in front of people's houses. The Supreme Court has said that's not necessary. There can be reasonable time, place, manner restrictions that ban that, but if your state wants to do it, they can do it. But now you would say, by this analogy, let's take that most extreme permissive law and spread it all across the country and say anybody who can show up with a bullhorn and shout at somebody else in somebody else's state. So, I understand why the NRA supports this. I just don't know why we would support this. What we're looking for in America is reasonable, common sense, common ground gun safety legislation. And what this does is it opens up a gaping hole in a way that is being deplored by the police officers and their associations, saying, don't do this. Don't give people the right to cross state lines under the most permissive state laws in the country, carrying guns to all 50 states. And that's exactly what this does. And the gentleman's amendment puts the lie to the claim that this is about reciprocity. It's not about reciprocity. It's about wiping out and flattening the state laws of 50 states across the country. It's an attack on federalism. And you may choose to do it, but don't lie to yourselves. This has nothing to do with reciprocity, because you're crushing the state laws that have been chosen by the legislatures of the people in each of the states. They've chosen to define their laws in a particular way, and what we're saying is, no, we're going to flatten it out with a nationwide sledgehammer instead. So, you know, the police officers are begging you not to do it. The gun safety groups are begging you not to do it. And yet it seems like it's full steam ahead. I want to speak strongly for Mr. Goldman's amendment. It doesn't completely wipe out the bill, as our good chairman just said, because all it says is that the state legislative choices of the particular legislature in a state are going to be honored and respected. And if a state doesn't mind what the other states are doing, that's reciprocity, right? Then that's real reciprocity. But you're not talking about reciprocity. You're talking about demolition of the legislative choices of the people of the particular states.
Will the gentleman yield?
Yes, by all means.
I would just add another element to why this is not gutting the whole the bill, as the chairman said, which is this amendment does not address concealed carry. This amendment addresses laws that would prohibit the purchase or possession of a firearm in a particular state. So even with this amendment, if the concealed carry rules would allow for a permit in one state, those concealed carry rules under the statute that you have proposed here would still apply to other states as long as that individual could lawfully possess that weapon. And as Mr. Massey was pointing out, there is a distinction between possession and carry, and this draws on that distinction.
Gentleman yields back. Gentleman from Maryland yields back. Question occurs on the amendment. The gentlelady, Ms. Crockett, is recognized.
Thank you so much, Mr. Chair. And I can appreciate the conversation and engagement that's taken place. One thing that I haven't heard since I've been here is anyone read the actual language of the Second Amendment, and I may have missed it. But it's curious to me that it starts off with a well-regulated militia. And it seems like every time we get a bill, and I will read the whole thing, a well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. It starts off with a well-regulated militia, but every time we get a bill, it seems like that bill is all about getting rid of regulations. And it seems as if there's never a real conversation around why we need regulations in this country. And now we have states that have enacted laws. And if we were having a conversation about, say, reproductive rights, I'm sure y'all would be arguing and saying, oh, give it back to the states, give it back to the states. And so I don't understand why in this moment you don't want the states to be able to decide when literally the very first words are talking about regulation. With that, I will yield.
Gentleman yields back. Question occurs on
I have a UC.
The gentleman from Arizona is recognized.
Yes, Mr. Chairman, I'd like to submit for the record the case of District of Columbia versus Heller, in which the Supreme Court said, there seems to us no doubt on the basis of both text and history that the Second Amendment conferred an individual right to keep and bear arms. And then I'll submit that, Mr. Chairman.
Without objection. The question occurs on the amendment offered by the gentleman from New York. All those in favor say aye. All those opposed, no. No. In the opinion of the chair, the noes have it.
Could we have recorded vote?
The vote being requested, the clerk will call the roll.
Mr. Jordan?
No.
Mr. Jordan votes no. Mr. Issa? Mr. Issa votes no. Mr. Biggs? Mr. Biggs votes no. Mr. McClintock? Mr. Tiffany? Mr. Tiffany votes no. Mr. Massey? Mr. Roy? Mr. Roy votes no. Mr. Fitzgerald? Mr. Klein? Mr. Klein votes no. Mr. Gooden? Mr. Van Drew? Mr. Van Drew votes no. Mr. Nels? Mr. Moore? Mr. Moore votes no. Mr. Kiley? Ms. Hageman? Ms. Lee? Mr. Hunt? Mr. Fry? Mr. Fry votes no. Mr. Grothman? Mr. Knott? Mr. Knott votes no. Mr. Harris? Mr. Onder? Mr. Onder votes no. Mr. Schmidt? Mr. Schmidt votes no. Mr. Gill? Mr. Gill? Mr. Gill votes no. Mr. Baumgartner? Mr. Baumgartner votes no. Mr. Raskin?
Aye.
Mr. Raskin votes aye. Mr. Nadler? Ms. Lofgren? Ms. Lofgren votes aye. Mr. Cohen? Mr. Johnson?
Aye.
Mr. Johnson votes aye. Mr. Swalwell? Mr. Liu? Ms. Jayapal? Mr. Correa? Ms. Scanlon? Ms. Scanlon votes aye. Mr. Neguse? Ms. McBath? Ms. McBath votes aye. Ms. Ross? Ms. Ballant? Mr. Garcia? Mr. Garcia votes aye. Ms. Kamlager-Dove? Ms. Kamlager-Dove votes aye. Mr. Moskowitz? Mr. Goldman? Mr. Goldman votes aye. Ms. Crockett? Ms. Crockett votes aye. Mr. McClintock votes no. Mr. Fitzgerald, you are not recorded. Mr. Fitzgerald votes no. Mr. Grothman? Mr. Grothman votes no. Mr. Gooden? Mr. Gooden votes no.
Clerk will report.
Mr. Chairman, there are 9 ayes and 18 noes.
The amendment is not agreed to. Question is on the adoption.
Mr. Chairman, I've got an amendment at the desk.
Clerk will report.
Reserve.
Point of order reserved by the gentleman from California. Clerk will report the amendment.
Amendment to the amendment in the nature
Without
of...
objection, the amendment will be considered as read. Gentleman from Maryland is recognized to explain his amendment.
It's a simple one, Mr. Chairman. It essentially tries to make the language of the bill live up to the title of the bill. It's about honoring those states that have already engaged in reciprocity arrangements with other states. And it honors those and says that it doesn't apply to them. So for states that don't have that, it would continue to apply. But for states that have actually engaged in reciprocal arrangements with other states, we honor those. I submit it to the wisdom of our committee.
Chairman, I withdraw my reserve.
Point of order is withdrawn. The chair recognizes himself. I mean, we oppose the, or I oppose the amendment. The idea is to give some uniformity, not to create this patchwork that I guess may exist now, does exist now. And this seems to me to water down what the legislation is intended to accomplish. For those reasons, I would urge a no on the amendment. 2-6 rec, and I yield back. On the amendment offered by the ranking member, all those in favor say aye.
Aye.
Those opposed, no. No. In the opinion of the chair, the noes have it.
Could I request a recorded vote, please, Mr. Chairman?
Recorded vote. The clerk will call the roll.
Mr. Jordan?
No.
Mr. Jordan votes no. Mr. Isa? Mr. Isa votes no. Mr. Biggs? Mr. Biggs votes no. Mr. McClintock? Mr. McClintock votes no. Mr. Tiffany? Mr. Tiffany votes no. Mr. Massey? Mr. Roy? Mr. Roy votes no. Mr. Fitzgerald? Mr. Klein? Mr. Klein votes no. Mr. Gooden? Mr. Gooden votes no. Mr. Van Drew? Mr. Van Drew votes no. Mr. Nels? Mr. Moore? Mr. Moore votes no. Mr. Kiley? Ms. Hageman? Ms. Lee? Mr. Hunt? Mr. Fry? Mr. Fry votes no. Mr. Groffman? Mr. Groffman votes no. Mr. Knott?
No.
Mr. Knott votes no. Mr. Harris? Mr. Onder? Mr. Onder votes no. Mr. Schmidt? Mr. Schmidt votes no. Mr. Gill? Mr. Gill votes no. Mr. Baumgartner? Mr. Baumgartner votes no. Mr. Raskin?
No.
Mr. Raskin votes no.
Oh, I'm sorry, I vote aye. I'm mistaken.
Mr. Raskin votes aye. Mr. Nadler? Ms. Lofgren?
Compelling argument.
Ms. Lofgren votes aye. Mr. Cohen? Mr. Johnson? Mr. Swalwell? Mr. Liu? Ms. Jayapal? Mr. Correa? Ms. Scanlon? Ms. Scanlon votes aye. Mr. Neguse? Ms. McBath? Ms. McBath votes aye. Ms. Ross? Ms. Ballant? Ms. Ballant votes aye. Mr. Garcia? Mr. Garcia votes aye. Ms. Kamlager-Dove? Ms. Kamlager-Dove votes aye. Mr. Moskowitz? Mr. Goldman? Mr. Goldman votes aye. Ms. Crockett?
Aye.
Ms. Crockett votes aye.
Gentleman from Wisconsin.
Mr. Fitzgerald, you are not recorded. Mr. Fitzgerald votes no.
Mr. Chair, point of information.
Gentlelady from Texas.
Is there any reason we don't vote electronically?
Yes, there's a reason. Let's finish the vote here, and then we can come back.
We finished the vote. What's the reason?
Clerk will report.
Mr. Chairman, there are 9 ayes and 18 noes.
The amendment is not agreed to. The question.
Mr. Chair, now that we finished the vote, I'm just thinking, because I know we've been talking about efficiency in government, and we have the technology.
Yes,
And
we
so
do.
this, you know, we appreciate our clerk, and our clerk would still have a job for sure, but
The tradition of the Judiciary Committee is to deal with the amendments when presented at the time, not to roll votes and vote electronically. I guess we could have electronic votes at the time.
Yes.
But we don't operate like the other committee I'm on, the committee Mr. Raskin came from, the Oversight Committee, where they roll votes.
But is it
And
possible? Is it possible for us to, even these votes that we're doing,
Understand,
is that something we can discuss?
we could.
Mr. Chairman, Mr. Chairman,
Mr. Chairman, I'd like regular order.
Yeah.
Mr. Chairman,
We could discuss it, but
a point of order, Mr. Chairman.
Gentlelady from
The
California.
Science Committee actually has electronic voting, and we
I
would be
understand.
happy to share that with the
I
committee.
understand, a number of committees do, but the Judiciary Committee does not and probably will not have it, at least this Congress. The question is on the adoption of the amendment, the nature of a substitute. This will be followed immediately by a vote on reporting the bill. All those in favor say aye. Aye. Those opposed, no. No. In the opinion of the chair, the ayes have it. The amendment, the nature of a substitute, is adopted. The question is on favorably reporting the bill as amended. All those in favor say aye. Aye. Those opposed, no.
No.
The ayes have it, and the bill is ordered to be reported favorably to the House.
Could we have a recorded vote, please?
I assume you were going to ask that, so the clerk will call the roll.
Mr. Jordan?
Manually, yes.
Mr. Jordan?
Yes.
Mr. Jordan votes yes. Mr. Isa? Mr. Isa votes yes. Mr. Biggs? Mr. Biggs votes aye. Mr. McClintock? Mr. McClintock votes aye. Mr. Tiffany? Mr. Tiffany votes aye. Mr. Massey? Mr. Roy? Mr. Roy votes aye. Mr. Fitzgerald? Mr. Klein? Mr. Klein votes aye. Mr. Gooden? Mr. Gooden votes aye. Mr. Van Drew? Mr. Van Drew votes aye. Mr. Nels? Mr. Moore? Mr. Moore votes aye. Mr. Kiley? Ms. Hageman? Ms. Lee? Mr. Hunt? Mr. Fry? Mr. Fry votes aye. Mr. Grothman? Mr. Grothman votes aye. Mr. Knott?
Aye.
Mr. Knott votes aye. Mr. Harris? Mr. Onder? Mr. Onder votes aye. Mr. Schmidt? Mr. Schmidt votes aye. Mr. Gill? Mr. Gill votes aye. Mr. Baumgartner? Mr. Baumgartner votes yes. Mr. Raskin? Mr. Raskin?
No.
Mr. Raskin votes no. Mr. Nadler? Ms. Lofgren? Ms. Lofgren votes no. Mr. Cohen? Mr. Johnson? Mr. Swalwell? Mr. Liu? Ms. Jayapal? Mr. Correa? Ms. Scanlon? Ms. Scanlon votes no. Mr. Neguse? Ms. McBath? Ms. McBath votes no. Ms. Ross? Ms. Ballant? Ms. Ballant votes no. Mr. Garcia? Mr. Garcia votes no. Ms. Kamlager-Dove? Ms. Kamlager-Dove votes no. Mr. Moskowitz? Mr. Goldman? Mr. Goldman votes no. Ms. Crockett? Ms. Crockett votes no. Mr. Fitzgerald, you're not recorded. Mr. Fitzgerald votes aye.
Clerk will report.
Mr. Chairman, there are 18 ayes and 9 noes.
The ayes have it, and the bill is ordered to be reported favorably to the House. Members will have 2 days to submit views. Without objection, the bill will be reported as a single amendment in the nature of a substitute, incorporating all adopted amendments, and staff is authorized to make technical and conforming changes. Pursuant to notice, I call up H.R. 2184, the Firearm Due Process Protection Act, for purpose of markup, and move the committee reported favorably to the House. The clerk will report the bill.
H.R. 2184.
Without objection, the bill will be considered as read. The chair is recognized for an opening statement. The Firearm Due Process Protection Act requires courts to hold a hearing within 30 days of individual filing a lawsuit challenging the accuracy of the records in the NICS system. Every year, the FBI's NICS system erroneously denies thousands of law-abiding Americans the ability to purchase a firearm. We had some of this discussion earlier today with Mr. Massey's legislation that I think got strong bipartisan support. Many of these denials stem from inaccurate information related to mismatched fingerprints or inaccurate criminal records within the NICS system. Furthermore, Black and Hispanic males are more likely to experience an erroneous NICS denial. In 2023, 6,263 cases NICS decisions were overturned after individuals challenged an initial denial. In order to challenge a NICS denial, individuals can either file an appeal with NICS, or they can file a lawsuit against the government or the entity that provided the alleged erroneous information to NICS that resulted in the denial. If an individual files an appeal, NICS has 60 days to process the appeal. However, there is no enforcement mechanism to ensure that the FBI completes its evaluation of the appeal within 60 days. If the FBI fails to process the appeal within 60 days, federal regulations require all appeals-related information to be purged from NICS before 90 calendar days, requiring the law-abiding citizens to start the process over from the beginning. If an individual elects to file a lawsuit, there are no provisions for an expedited hearing. This means that it can take years for courts to make a determination that a NICS denial was in error and that the individual is eligible to purchase and possess a firearm. This leaves law-abiding Americans without the right to exercise their Second Amendment rights. This bill will provide an expedited hearing so that law-abiding Americans can have their Second Amendment rights restored as quickly as possible. This seems to me as a common-sense bill consistent with legislation Mr. Massey brought forward earlier today that the committee approved. I urge my colleagues to support this bill. And I would now yield to the ranking member for an opening statement.
All right, thank you much, Mr. Jordan. This is a well-intentioned bill. Nobody should be wrongfully denied their Second Amendment rights due to some bureaucratic snafu. While the bill is being offered as a solution to the delayed appeals of NICS denials based on erroneous information, it does appear to me to be a solution in search of a problem because we don't have hard data explaining what the problem is. Still, I'm not going to oppose it. Currently, federal law provides any prospective purchaser who receives a NICS denial the ability to challenge and correct what they think is erroneous information. The AG has 60 days to determine whether the challenged information is erroneous or not, and then to remove any records that are. HR 2184 would amend Section 925 of Title 18 to create a procedure for obtaining an expedited hearing within 30 days for people challenging a NICS denial based on erroneous information, or people who are aggrieved by a violation of the Brady Act, mandating attorney's fees and litigation costs for a claimant who substantially prevails. Federal law also provides that a prospective purchaser may bring an action in court against a state or the United States if the person's denied a firearm purchase through NICS due to an erroneous record. The court may then order correction of the record or that the transfer be approved. Additionally, a person who believes they've received a false denial can use the FBI's voluntary appeal file process. When a person applies for the voluntary appeal file, FBI staff research whether the person is prohibited from getting firearms. If no prohibitions are found, the FBI will issue a unique personal ID number to prevent delays or false denials in the future. Anyone may apply for the voluntary appeal file, but it's designed to address false denials, including those caused by people who have similar names. It's also worth noting that some false denials can be prevented at the beginning. The form prospective gun buyers fill out prior to a NICS check gives them the option to provide a social security number. As the form notes, this is purely optional, but it can help to prevent misidentification and confusion. The NICS system isn't perfect. According to the NICS Operations Report 2023, the FBI received 22,615 firearm-related challenges. Of those, 12,406 were sustained, 6,263 were overturned. So I'm not opposed to the reporting requirements of the bill, which would give us insight into the average length of time needed to process these challenges. If people challenging denials are in fact experiencing delays, we should consider how to address that. Perhaps more funding or resources are needed to facilitate better processing times. I'm not sure that this bill, which promises expedited appeals in 30 days but doesn't specify how this will be enforced or provide any additional funding, is the answer. In any event, we could do better in the future, but this seems okay to me, and I yield back.
Without objection, statements will be included in the record. The chair now offers an amendment in the nature of a substitute. Clerk will report.
Amendment in the nature of a substitute.
Without objection, the amendment will be considered as read. This amendment simply adds the year to the title of the bill. It's not intended in any way to alter the important purpose of the legislation. I urge support of the amendment and yield back. Who seeks recognition? The gentleman from Texas is recognized.
Yeah, I don't want to take too long. I know we're getting late into the evening. I didn't get a chance to comment on the gentleman from Kentucky's legislation earlier because he withdrew it, and I didn't get a chance to add to it with respect to follow up on other amendments. I just wanted to say how much I strongly support the gentleman from Kentucky's version of the legislation that we just moved through committee. I strongly support the Second Amendment protection of an individual right to bear arms. I think the gentleman from Kentucky's version is more elegant. I think it is more consistent. I think it is more deferential to states, yet recognizing the constitutional, protection of our ability to bear arms. I think it is something we ought to consider as it goes from committee to the floor. I wish the gentleman had not withdrawn it. And I think it merits a further conversation and discussion. I'm not overly fond of the use of Commerce Clause to insert, one state's, permit, scheme onto another state and so forth, which the previous bill does. I voted for the bill, as the gentleman from Kentucky said he would for the bill, because I thought that it was important to make sure we advance and protect the Second Amendment right to bear arms. I would hope that we might be able to consider this as it goes through into the Rules Committee and gets to the floor of the House, because I think the gentleman from Kentucky's bill is a better bill. I yield back.
Gentleman yields back. Question.
Mr. Chairman, I just have some UC requests.
Go right ahead.
This is a statement from 7 national law enforcement agencies opposing H.R. 38 from the chiefs of police and so on.
Without objection.
One from the National Task Force to End Sexual and Domestic Violence, and one from Brady, and one from the Newtown Action Alliance, if we could take those.
Without objection.
And I just have a handful more. An article by Devlin Barrett from the New York Times, Trump administration prepares to give gun rights back to some convicts.
Objection.
Evan Perez and Hannah Rabinowitz, titled Patel Plans Major Cutback to ATF, published by CNN. And finally, Nick Wilson, Project 2025 would increase gun violence, reversing historic declines. Finally, 4 letters from Brady opposing several of the bills we looked at today.
Without objection. Question is on the adoption of the amendment in nature of a substitute. This will be followed by immediately by a vote on reporting the bill. All those in favor say aye. Aye. Those opposed, no. In the opinion of the chair, the ayes have it, and the amendment in the nature of a substitute is adopted. The question is on favorably reporting the bill as amended. All those in favor say aye. Those opposed, no. The ayes have it, and the bill is ordered to be reported favorably to the House. Members will have 2 days to submit views. Without objection, the bill will be reported as a single amendment in the nature of a substitute incorporating all adopted amendments, and staff is authorized to make technical and conforming changes. And that concludes today's markup. We'll see you all tomorrow.
Well done.